General memos. When do you want it? All right, give. Tim then. 13, 7 ಇದೆಲ್ಲ ಕೊಡಿ. ಯಾವ್ಯಾವ 7 ಇದೆಲ್ಲ ಕೊಡಿ. ಯಾವತ್ತು ಮೇಡಮ್ 10th 13th ಅದು? ಯಾವತ್ತು 13th? ಎಸ್. ಎಲ್ಲ 482. Anything else? Wait. Yes. ಎಲ್ಲ 482 ಕೊಡಿ. ಏನು ಫ್ರೆಶ್ ಅಪ್ ಎಂಡಿಂಗಾ ಕೊಡಿ. FR ನಂಬರ್ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ ಮಂಡೇ? ಎಸ್. That is not a ground at all. Next. Correct. That is not a ground. ಆಮೇಲೆ yes, all right. Unsound mind. ಆಯ್ತಾಯ್ತು ಕೊಡಿ. Yes, what Kirtana madam? You sit down. What do you want to tell me? Wait. Fresh matter. ಮತ್ತೆ ಸ್ಟೇ ಇದ್ಮೇಲೆ ಯಾಕೆ ಬೇಕು ಅರ್ಜೆನ್ಸಿ? ಆಯ್ತು ಗುಡ್. ವಿಚ್ ಇಯರ್ ಇಸ್ ದಟ್? Give it. We'll list it. You sit down. Yes. Give that memo and you sit down, madam. Yes. What were you doing till now, sir? When did you file the application? At what stage? When the matter was reserved for judgment? No, sir. Defense evidence is not take. No, sir. Not at the time of judgment at all. Anyway, give it. Yes. No, sir. Give it. 31st only post ಮಾಡಿ ಅದನ್ನ ತಗೊಳ್ಳಿ. ಎಷ್ಟು ಅನ್ಸೌಂಡ್ ಮೈಂಡ್ ಇದೆ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಕೊಡಿ. We'll post it. I can't take 300 matters, 400 matters every day. Give it. If all of you are mentioning at once, I'll stop taking memos. It's not a market. Have some discipline. Yes, Kodri. Monday or Tuesday we'll post it. Give it. Yes. ಬರೋಲ್ಲ. ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು? Move the next court. Extension. Okay, give it. Yes. Vacating stay you filed. Which year? Next week, Thursday. Kodi. FR or complied? FR or complied? Give it. Yes. If they are complied, it will be listed. Give it. Yes. No, sir. Yes, give it. Admitted in the lower court. Acquitted. Kodi waiver. ಅದು ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಕೊಡಿಯೋದು ಅದು ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಸ್ಯಾಟರ್ಡೆ. ಎಸ್. FR complied. Give it. Yes. Comply. Yes. No tomorrow. Why? What's the urgency? Getting what? Sorry? Apprehension. Bail ತಗೊಂಡಿಲ್ವಾ? ತಗೊಳ್ಳಿ. Yes. Give it. Give it. Yes. Pending or fresh? Give it. Yes. We'll fix it, sir. Give it. Monday or Tuesday, both the days. Yes, we'll see. No, sir. Fresh matter Monday or Tuesday ಬರುತ್ತೆ ಕೊಡಿ ಸರ್. Sir, today, this week, Saturday is a working day. 1 minute. ಪೂರ್ತಿ ಹೇಳೋದು ಕೇಳಿ. ನಿಮ್ಗೇನು ಆರಾಮಾಗಿರ್ತೀರಾ? Saturday is a working day. So ಸಾಯಂಕಾಲದವರೆಗೆ ಇಲ್ಲೇ ಆಗುತ್ತೆ. Sunday is the only day we get to read the files or whatever. If without reading, I'll come, no problem. ದಿನಕ್ಕೆ 20 ಮ್ಯಾಟರ್ ತಗೊಂತೀನಿ, ಸುಮ್ಮನಾಗ್ತೀನಿ. ಡೇಟ್ ಕೇಳ್ಬೇಡಿ, ಕೊಡಿ. ಬರುತ್ತೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ, ಕೊಡಿ. ಎಸ್. ಕೊಡಿ. ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? Monday or Tuesday, we come, yes. Huh? Withdraw, you want it now? Yes, leave it, yes. 2:30, yes.
Milord has kindly allowed it to be listed last Tuesday, Milord, but it was only FR number. Now we have complained, Milord. There is urgency, Milord.
What
Actually,
urgency?
it's accused of abetment of suicide. The only allegation is that I have not informed the
Give it,
mother
give
of
it.
the
All right, Monday,
deceased.
Monday.
No, this is
Being spoken, ಯಾಕೆ sir? Wait, huh? ಅದಕ್ಕೆ ಹಾ ಆಗ್ಲೇ ಇಲ್ವಾ? Being spoken to ತಗೊಳ್ಳಿ, yes.
not this is covered by the judgment of this honorable court.
January
There's no
25.
stay, there's no stay, my lord.
No, covered and no stay.
No stay, my lord.
Give it, yes.
Kindly fresh matters ಅಲ್ಲಿ list ಮಾಡ್ತದೆ.
ನೋಡುವ ಕೊಡಿ, yes.
Fresh matter.
376.
Compromise 376 ತರಲೇಬೇಡಿ, yes.
Your Lordship, fresh matter, Your Lordship, 482, Your Lordship, kindly have it on Monday or Tuesday, Your Lordship.
ಏನ್ urgency?
Your Lordship, ಇದರಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಮ್ಯಾಟರ್ ಇದೆ.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Lordship, ಮೊನ್ನೆ ಫೈಲ್ ಮಾಡಿ.
ಕೊಡಿ, yes.
It's
Monday or Tuesday, no dates, either it will be Monday, Tuesday or Wednesday. Give it, yes.
memo for being spoken to.
Why, sir?
That's a disposed of matter. The date of charge sheet is a mistake.
ಅಷ್ಟೇನಾ ತಗೊಳ್ಳಿ. ಹಾ ಸರಿ, ಅದಕ್ಕೆ ಅಷ್ಟೇನು ವೆಕೆಟ್ ಮಾಡ್ಬೇಡ, ಕೊಡಿ, yes. ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಫ್ರೆಶ್ ಪೆಂಡಿಂಗಾ ಸರ್? ಕೊಡಿ, ಎಸ್. ಯಾವತ್ ಬೇಕು ಬರೆದು ಕೊಡಿ.
Disposed on 9/8 with liberty to file a fresh petition.
ಕೊಡಿ.
The wrong submission for that date.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ?
No charge.
ಅದು ಬಿಂಗ್ ಸ್ಪೋಕನ್ ಹಾಕ್ಬಿಟ್ಟು ರೀಕಾಲ್ ಮಾಡೋಣ, ತಗೊಳ್ಳಿ. ವೆನ್ ಡು ಯು ವಾಂಟ್? ವೆನ್ ಡು ಯು ವಾಂಟ್? ನಿಮ್ಗಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಸೆಟಲ್ಮೆಂಟ್. ಹಾ ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ತಗೊಳ್ಳಿ. January 25, stay ilva? January 2025, don't give that memo, don't give it, yes. Settlement, when do you want, give it? Tagoli, yes. Fresh pending, give it, yes. Why end of the list, why? Tomorrow? You should be louder, madam.
Check amount.
Jambu Bandari, give it, yes, end of the list, yes.
From is pending, that is for my marriage.
Marriage, madam, or
Actual ಆಗಿ ಕೆಳಗಡೆ court ನಲ್ಲಿ
ಆಯ್ತು, you will not get married till the NOC is given by this court.
that actual ಆಗಿ ಅವರು ಕೆಳಗಡೆ
ಅದ್
court
ತಗೊಳ್ಳಿ madam.
ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಸೊ
ಅದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ತಗೊಂಡಿದ್ದಾರೆ.
ಪೆಂಡಿಂಗ್ ಅದು,
ಹೌದು
ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಶನಿವಾರ
ಪ್ಲೀಸ್
ಮೇಡಮ್, ಅದು ಶನಿವಾರಕ್ಕೆ ತಗೊಳ್ಳಿ. ಅದೇನು FR ನಂಬರು ಇಲ್ವಾ ಅದರಲ್ಲಿ? ಅವ್ರದ್ರಲ್ಲಿ ನಂಬರು ಇಲ್ವಾ? ರಿವಿಷನ್ MPML ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್, ಎಸ್. ಶನಿವಾರ
Showcase notice has been issued by the DCP for cancellation of arms license, my lords.
ಆರ್ಮ್ಸ್ ಲೈಸೆನ್ಸ್ ಈಗ? ವೈ?
Because of pendency of the criminal case, my lords, civil
ಆರ್ಮ್ಸ್ ಲೈಸೆನ್ಸ್ ಈಗ?
injunction order is in our favor, my lords.
ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ.
My lord, petitioner got an opportunity to go to abroad, my lord, to hire.
Go.
No, my lord, FIR is there, my lord. So he needs some.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
Charge sheet agilla, madam.
ಸ್ಟೇ ಇದೆಯಾ?
Stay there.
ಮತ್ತೆ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
US ಗೆ ಹೋಗ್ಬೋದು.
ಗಿವ್ ಇಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ ವರ್ಷದ ನೋಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಮೇಡಮ್.
Monday.
ಮಂಡೇ
My lord,
ಮ್ಯಾಟರ್ ಅಲ್ವಲ್ಲ,
my lord,
ಪೆಂಡಿಂಗ್
10
ಅಲ್ವಾ?
days are there, my lord. He has
ಪೆಂಡಿಂಗ್ ಅಲ್ವಾ?
pending, my lord.
ಮಂಡೇಗೆ ಬರಲ್ಲ, ಇಟ್ ವಿಲ್ ಕಮ್, ಎಸ್.
ಕಲಬುರ್ಗಿಯಲ್ಲಿ ಇರೋದು.
ಏನು?
Fifth marriage, sir.
ಫಿಫ್ತ್ ಮ್ಯಾರೇಜಾ?
5ನೇ ಮದುವೆ ನಮ್ಮನ್ನಾಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಕಲಬುರ್ಗಿಯಲ್ಲಿ ಇರೋದು ಆಲ್ರೆಡಿ ಅವ್ರ ಮೇಲೆ 420 ಕೇಸ್ ಎಲ್ಲ ಇದೆ. ಕಲಬುರ್ಗಿಯಲ್ಲಿ ಇರೋದು, ಬೆಂಗಳೂರಲ್ಲಿ ಬಂದು FIR ಮಾಡ್ತಿದ್ದಾರೆ.
ಓ, ಕಲಬುರ್ಗಿಲಿ 5 ಮ್ಯಾರೇಜಸ್ ಆಗಿದೆಯಾ? ನೀವು ಬೆಂಗಳೂರಾ?
ಅಲ್ಲ, ನಾವು ಕಲಬುರ್ಗಿ ಅವರೇ, ಬಟ್
ಮತ್ತೆ ಇಲ್ಲಿ ಯಾಕೆ?
ಫಾಲ್ಸ್ ಕೇಸು, ಇಲ್ಲಿ ನಾವು ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಇದೀವಿ ಅಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ FIR ಮಾಡ್ತೀವಿ.
ಆಯ್ತು, ನಂಬರ್ ಆಫ್ ಹಸ್ಬೆಂಡ್ಸ್ ಆರ್ ಇನ್ಕ್ರೀಸಿಂಗ್ ಎವ್ರಿ ಡೇ, ಗಿವ್ ಇಟ್, ಎಸ್.
My lord, before
7 ಆಯ್ತು, 10 ಆಯ್ತು, ಮತ್ತೆ 5 ಆಗೋಯ್ತಲ್ಲ, ಕಮ್ಮಿ ಆಯ್ತು, ಎಸ್. ಅದು ಯಾವತ್ತು ಪೆಂಡಿಂಗ್ ಮೇಡಮ್? ಅದು ಎಫ್
ಮಂಡೇ
ಕಂಪ್ಲೈ ಮಾಡಿ ಫಸ್ಟ್,
ಕಂಪ್ಲೈ ಮಾಡಿ.
ಎಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್ ಮಾತ್ರ ಹೋಗೋದು.
Petitioner is a bank employee, retired bank employee.
ಸೊ
Lordship, he is from Bangalore.
ಸೊ
Lordship, there is he has been implicated in the false case where Lordship, he has dispersed the loan.
ಹಾ,
And just Lordship, on the basis
ವಿತೌಟ್
of
ಟೇಕಿಂಗ್ ಎನಿ ಅಡಿಕ್ವೇಟ್ ಸೆಕ್ಯೂರಿಟಿ.
on the basis of quotation.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Third charge here.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಕ್ಕೆ ಇಷ್ಟು ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನಥಿಂಗ್ ಡೂಯಿಂಗ್ ಕೊಡಿ, ಎಸ್.
Pending, Your Worship.
ನೋ ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಮಂಡೇ ಅಷ್ಟೇ, ಕಂಪ್ಲೈ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಎನಿ ಡೇ, ಎಸ್.
Date was given today and 28th and 29th.
ಆಲ್ ರೈಟ್,
but it
ಎಸ್,
was not listed here.
ನೋ ಪ್ರಾಬ್ಲಮ್. ಸ್ಟೇ ಇದೆಯಾ? ಸ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಮೇಡಮ್. ವಿಲ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ದ ಡೇಸ್. ವೇಟ್, give it. You give the memo. Don't ask for Monday or Tuesday. We'll have it listed throughout the next week. Yes.
I filed a complaint against the.
What's the urgency, sir?
Principal, my lord, I've been repeatedly called. In fact, I filed a complaint against the accused number 1 and 2 that.
So what's the urgency?
Sir, I've been called to the police station.
Go.
My lord. Repeatedly, I'm staying in Koppal district, my lord.
Koppal illake?
But, the FIR is in Siddhapura police station. my lord.
Okay, give it.
Monday.
Fresh matter. Monday or Tuesday or Wednesday, it will come on one of those 3 days. Madam will distribute next week. Yes.
9/7/2024.
9,000, 2,000?
9/7/2024 notice, emergent notice was issued, my lord. 8 cases are.
Give it. Notice ಆಗಿರುತ್ತೆ, ಲಿಸ್ಟ್ ಆಗಲ್ಲ ಅದು. Yes.
Purchaser will sign from queue number 1 and 2 what parents have to travel abroad company ಕೆಲಸ ಮಾಡ್ತಾರೆ. CC ಆಗಿದೆ sir.
ನೋಡಿ ಕುಡಿಯೋದು. ಟ್ರಾವೆಲ್ ಅಂದ್ರೆ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಮೇಡಮ್. 6-7 ಸರಿಯಾಗಿದೆಯಾ? ಇದು 8ನೇದಾ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ನಿಮ್ದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ತಗೊಳ್ಳಿ ಮೇಡಮ್. ವೆಕೇಟಿಂಗ್ಸ್ ಯಾವ ಸರಿ ಬರುತ್ತೆ, ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರುತ್ತೆ.
Fresh matter of the list.
Give it. Yes.
Case has been registered.
Every case is false, madam. Fresh pending.
That is the person studies abroad. Because of the pendency of this, I cannot go. This is a pending matter. It came before the court, but because of the volume of cases, the arguments were not addressed.
That is every day there. Volume of cases will always be there.
Right.
Yes. We'll see which year.
2023.
As a student, yes.
My lords,
Wednesday or Thursday will see.
end
Yes.
of the list, my lords.
End of the list. Why, sir?
My lord, section 69 of BNS has been invoked on the parents of the accused number 1. And my lords, they have been now sought to be arrested. Section 69 refers to sexual intercourse on the pretense of marriage. And these are parents and the sisters have been added as a parties.
Take bail.
My lords,
Seek bail.
my lords, I will apply for the bail, my lords, but it is an abuse of process, pure
That's
abuse
all
of
right.
process.
Apply bail.
Can it be taken up for end of
No. Apply bail. We'll take it on Monday or Tuesday. Yes.
Monday or Tuesday, my lords?
We'll see. Yes.
Lord, it's a fresh matter. Fresh
7
matter.
13.
Lord, not 7. Lord, I was the employee of KPSC. Allegation is, my lord, I have demanded rupees 5 lakhs to get him a job. 420 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Correct ಆಗಿದೆ. Then doubt ಇಲ್ಲ.
But this all court has held that.
Justice ಪಣೀಂದ್ರ ಅವರು.
Yes,
ಪ್ರೇಮಲತಾ.
Lord,
ಆಮೇಲೆ
there is some urgency.
ಏನದು?
ಇಲ್ಲ, last occasion, Lord, I had more.
ಏನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ, fresh matter. Monday ಕೊಟ್ಟಿದ್ರಿ.
Memo
Lord,
ಕೊಡಿ.
maybe.
ಡೇಟ್ ಕೊಡೋಣ. ಮೆಮೊ ಕೊಡಿ.
Lord,
ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. If you hoodwink someone,
Lord,
you need not.
may I request, my lord, Saturday, my lord.
Next Saturday, 21st ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಅಲ್ಲ 21st Saturday ತಗೊಳ್ಳಿ. Yes.
31st.
You said Saturday.
31st.
31st ಬೇಡ. We'll take it 10 days early. 21st. Yes.
I'll take chance, my lord.
No, sir. Yes.
But ನಂಬರು ಆಗಿದೆ.
ಆಗಿಲ್ವಾ?
ನಂಬರ್ ಆಗಿದೆ.
21 ಗ್ಯಾರಂಟಿ ಹಾಕೋಣ ಕೊಡಿ. ತಗೊಂಬಿಡಿ. Take that memo. ಬೇಡವಾ?
31st, my lord.
ಹಾ ಸರ್.
Lord,
ಏನಾದ್ರಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
ಆಯ್ತು, Monday.
We'll see.
Monday.
ಕೊಡಿ. ಮೆಮೊ ಕೊಡಿ ಸರ್. Yes, call the cases. List 2 ತಗೊಂಬೇಡ. ಇಲ್ಲ 1 ಮುಗಿಸ್ಕೊಂಡು ಏನ್ ಮಾಡಿ. List 2 are there. ಆಯ್ತು, list 2 ತಗೊಂಡು ಮುಗಿಸ್ಕೊಂಡು.
Number 2, number 1.
This matter charge sheet has been filed.
So
I have to secure the.
last time ಅದೇ ಹೇಳಿದ್ರಿ.
ಇಲ್ಲ, they have filed it. My objection. We are able to learn in the trial court is that they have filed incompletely. So ಅದರ ಇನ್ನು cognizance order.
Whether complete, incomplete, this is not a case where any indulgence can be shown.
Bit on 6th May.
You'll have it any day you want, no problem. Yes.
Statement of objection.
ಏನದು?
To file.
ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ.
Yes.
Heard the learned counsel appearing for the petitioner and the learned special counsel. How do we, special prosecutor?
ನಾವಿಬ್ರು ಸ್ಪೆಷಲ್. ಈ ಕೇಸ್ಗೆ is special.
Special prosecutor.
Both are.
The learned counsel for the petitioner seeks a week's time to secure instructions with regard to the prosecution filing the final report before the concerned court. List the matter on 13th.
Other cases there.
Which other case?
There are three, in fact, three.
ಒಂದು ಇವತ್ತೇ ಎರಡಿದೆ.
Already,
Hmm.
kindly have it on.
ಆಯ್ತು, 5th, no problem. Yes. List on 5th.
Charge. Objections copy. Objections copy. Okay.
Number 2.
171 F and H.
Copy is not served.
Why, sir?
I shall have it served today.
Hmm?
Shall I have it served today? I apologize.
List on 5th, the counsel for the petitioner shall serve a requisite set of papers upon the counsel for the second respondent forthwith. The interim protection granted shall continue till the 5th of September 2024.
Sincere apology.
Yes. Other, these small things you should not do.
Due to oversight, my lord.
You should keep a
Sure,
tab
sir,
of
today.
everything, sir. Yes.
Very
Order still number 3.
Connected.
Same, ಅದು 5th. Same ಬರ್ದ್ಬಿಡಿ. How it's not so. Yes.
May I make one request?
Yes, sir.
Would may kindly consider hearing these matters in camera
These in
to
particular.
avoid the identity of the
I know,
prosecutor.
these matters will do something.
Yeah, I request the court to consider that
We'll see.
because the
Anyway, when they
some
hear,
facts are so intricately connected. Somewhere we may spill the identity of the prosecutor. That should
Yes,
not
sir.
happen.
No
Only
problem.
that.
Yes, sir.
Kindly,
We'll do
consider.
that. Next week, we'll do something. Anyway, when the hearing
and
starts,
if we can be given an exclusive session, either morning or evening, afternoon.
let's see, because orders have to be passed by the Honorable Chief Justice.
Alla-
We'll
no.
take his and then do it. Yes.
Great.
4.
Lapsing stay ಕೊಟ್ಟಿದ್ದೀನಿ.
ತಾವು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂದ್ಬಿಟ್ಟು ಅವ್ರು ಟೈಮ್ ತಗೊಂಡು
ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ರೆಡಿ ಇದೆ ಅಂತೆ.
ಎಸ್, ಜಗದೀಶ್ ಸರ್.
ಇಲ್ಲ ಬಿ ವಿ ಪಾಟೀಲ್
ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಲೋಕಾಯುಕ್ತ.
ಲೋಕಾಯುಕ್ತ.
ನಾವಿಲ್ಲ.
He told me that it is ready to be filed and.
What is ready? B report or objections?
Objections.
Objections.
Post charge sheet, my lord, this is, I have come.
Post charge sheet. Oh, sanction,
197.
218, 197.
Yes. So he said he would be seeking time.
Lapsing,
Labs, now granting interim order, lordship, sir.
my entry model.
Come.
No, it's not come,
It has come.
the
Detailed
23
Interim order, your lordship.
Harvard. Yes. At the request of the counsel appearing for the respondent, should B.S. Prasad and
B.B. Patil.
B.B. Patil. List the matter on 13th. Objections, if any, by then, the interim order subsisting shall continue till the next date of hearing.
5.
I represent the petitioner, my lord.
188,
Yes, identical matter has been disposed of, my lord.
Number,
Criminal petition number 10686 of 2023, my lord.
copy of the judgment.
I will furnish, my lord, I will furnish.
If you have not furnished, take my judgment, dismissed.
I'm sorry, my lord, I will furnish.
Yes. 13th. List
Yes,
on 13th, interim order subsisting shall continue till the next date of hearing. Madam. ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ? 12th, sorry, 12th, not 13th. ಅದು previous ಅಷ್ಟೇ ಕಾವ್ಯ ಎಲ್ಲಿದೆ 12th. Yes.
Still number 6.
My lord, appeal for petition 171 C and F, my lord, 123.
Huh?
171 C and F, 171
That
C
time
and F.
aware, sir, it's my interim order, I guess. Yes, Jagdish, ಯಾವ್ದ್ರಲ್ಲಿ ರೆಡಿ ಇಲ್ವಾ?
ಇಲ್ಲ, ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಕವರ್ಡ್ ಬೈ ಡಿಸಿಷನ್ ಅಂತ ಹೇಳಿದ್ರು, ವಿಜೇಶ್ ಪಿಳ್ಳೈಯಲ್ಲಿ ಕವರ್ಡ್ ಅಂತ ಹೇಳಿ.
ವಿಜೇಶ್ ಪಿಳ್ಳೆ ಅಂದ್ರೆ ವಾಪಸ್ ಕಳಿಸ್ತೇನೆ.
ಹೌದು.
We'll say that, yes.
ಇಲ್ಲ, ಇಲ್ಲೇ ಕ್ವಾಶ್ ಮಾಡಿ.
ಇಲ್ಲೇ ಕ್ವಾಶ್.
Allegation, my lord, is in my Instagram, I uploaded some video showing about the using the public place and making campaign. That is the only allegation.
Yes, sir.
It has to, that is the case, my lord, it has to go back.
ಅಲ್ಲ ಇದೇನು ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ವೇರ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಟೇಕಿಂಗ್ ಪರ್ಮಿಷನ್ ಗ್ರಾಂಟಿಂಗ್ ಪರ್ಮಿಷನ್
Malad, annexure A, Malad, annexure A, page, Malad, in the same, in the complaint itself, Malad, page 16, Malad.
perused the requisition signed therein so
And
and
there
so
on, satisfied
hence
by the
in view of
grounds
so
urged.
grounds made out.
Just to go back.
ಆಮೇಲೆ ಬರ್ತಿರಲ್ಲ ಹೆಂಗೋ ಇಲ್ಲೇ.
Like, allegations is not so grievous also, Malad. It is.
ಇದೆ ನಿಮ್ಮವರಲ್ವ ಇವರು?
Bald.
ಗೊತ್ತಿಲ್ಲ, ನೋಡ್ಲಿಲ್ಲ.
ಹಾ?
ಅವ್ರವ್ರೆ.
ಹೌದಾ?
ಅವ್ರ ಕಡೆ ಅವ್ರು.
ಆಯ್ತು. List on 12th interim order subsisting shall continue till the next date of hearing. We'll see whether it makes out an offense or not and then decide.
Please.
7.
Which is covered by certain decisions itself, my lords.
Interim order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
One is it's barred by limitation, my lords. And second is 285 ingredients, my lords has held when the ingredients are made out, when it is not made out. In Sadiq Pasha, my lords fell back on a Supreme Court ruling. Now, if we say it is a fire incident, there should have been some kind of a fire incident. Merely not having license will not amount to an offense under 285. That's a view my lords has taken.
I have said so.
Yes, my lords. My lords, could I just point out what has happened in this case,
Please.
my lords?
Hmm.
My lords, commercial building, my lords. My predecessor in title, he puts up a commercial building in 2005 after obtaining sanction plan.
Hmm.
2014, I purchased it.
Hmm.
I am under the bona fide impression I have done everything which is required insofar as the fire department is concerned, my lords. Now, the fire department, they would come and have an inspection of the building on, these dates may be relevant, my lords, 31/12/2017,
Hmm.
5/1/2018, and 31/1/2018. So, my lords, the period of limitation for them to initiate an FIR could be only before 31/1/2019, 1 year, my lords. The present complaint is filed on 2/4/2019. So, my lords, under Sarah Matthews' case, this should get barred by limitation. And my lords, it could not have proceeded further. No cognizance could have been taken. That is point number one. Second is, my lords, during the crime stage, we had approached this honorable court and there was an order of stay.
Now also there is an order.
No, my lords, order of stay. Now, despite order of stay, they would go and file the charge sheet. When an order of stay is in existence, the IO would go and file the charge sheet. That prompted us to withdraw that petition and file the present petition, which we brought to the notice of the court when the interim order was granted. So this is number two, my lords. The third aspect is ingredient insofar as 285. Now, the case made out is when we inspected, certain fire safety equipments were all not there. That's a violation. Now, for that violation, 285 is not in.
Kirpal,
I just, my lord's decision, my lord.
Guru Kanwar Singh Pal
Could
Kirpal.
I, could I? My lord, Sadiq Pasha, where my lords fell back on Supreme Court ruling, my lords. The Supreme Court ruling which my lords fell back on.
Yes.
It's a Guru Kanwar Singh Pal Kirpal.
Kirpal.
Yes.
My lords, in Guru Kirpal Singh, what happened was, my lords, a plant where my
This
lords,
was not yet reported.
but my lords decision.
No, that also I have quoted this only.
Quoted this.
Not-
and it's
not
put
yet
as
reported.
R, but I, yes.
Yes.
Fine. So, my lords, on all the three fronts, my lords, whether it's a case of barred by limitation, whether filing a charge sheet despite there being an order of stay, and the fact that,
When was the cognizance taken?
my lords, the date of taking cognizance, my lords, that may not be relevant.
I'm
Yes,
asking-
sorry,
I know that,
sorry,
sir.
my lords.
Specifically, I'm asking.
My lords.
There is one judgment of the coordinate bench which says date of cognizance is what is to be looked into.
But Sarah Matthews
No, no,
clarifies.
I'm aware, sir. Yes.
18/10/2009,
1810,
2019.
2009, cognizance order. Limitation?
My lords, limitation would have been, my lords, limitation 31/1/2019, my lords. 31/1/2019,
Complaint filed on?
complaint on 2/4/2019,
Cognizance on?
on 18/10/2019.
1810.
18/10. So either way, my lords, it is beyond. But But I thought, my lords, that was the subject matter of what came up before the bench Supreme Court, my lords, which is the date we consider. Then
I have no doubt. I have no obfuscation about that at all.
So on all three fronts, I
There is a
think,
judgment of the coordinate bench, recently rendered.
and quoting the Supreme Court ruling, Sarah Matthew.
Quoting the Supreme Court.
So I think there it is very.
Quoting
clear.
the Supreme Court ruling and saying date of cognizance. No, their conviction is set aside on the ground that cognizance is taken 3 years after.
Not have been cognizance. it
It's
should
not
be the
cognizance.
date of reporting of
Cognizance, the court will take after 10 years,
It's
sir.
exactly what they
The
had.
date
For-
of complaint is what is
For the
important.
delay of the court, the party should not
That's
suffer.
why
So when it is.
if the
in fact-
party himself, whoever aggrieved person goes beyond 3 years, then it is his
Yes.
peril.
Yes,
To
that's
his
where
peril,
limitation
that's all,
comes.
that's all. Limitation is not with regard to cognizance. Cognizance will be taken after 10 years, 12 years, many a case.
My lords, the other offense here which they allege is, my lords, under section 25 of the Karnataka Fire Force Act 1964.
Anyway, on limitation, if you're,
500 rupees, then it becomes
it's all right.
non-cognizable
No,
again.
if you are succeeding on limitation, why should we ever touch any other ground?
The three grounds also are
Limitation.
safe, my lords. In fact, three grounds are also very,
Limitation may not arise, my lord,
Why,
because
sir?
it's a continuation of offense.
What continuations?
you complete the,
What continuation?
The offense, my lord, your lordship, may see page 15, my lord, according to us,
Hmm.
is continued even the day of filing a complaint.
What is the offense, sir?
The non-following the fire safety measures and
When did you inspect the unit?
inspection has happened, my lord, but
Non-following in air, it comes about, or when you inspect the unit?
no, when we inspected, but even.
When did you inspect the unit?
No, that was done on 3 occasions, my lord.
What was the last occasion?
Last occasion on 31/1/2018.
31/1?
2018.
2018. After that, whether they have followed or not, where did you inspect? How do you assume that it's a continuing cause or assume that they have not corrected it? And your complaint is based upon what?
inspection report.
Inspection.
Inspection.
Dated 31/1/2018. Limitation runs from what?
No,
Continuing
inspection-
cause of action?
Cause of action, my lord, according to us, on
Date of inspection.
9/4/2018. From 9/4.
Why 9/4/2018?
That is the day which we have also visited. That's the day in the FIR which speaks about, my lord.
No, 9/4/2018. How did that date spring?
That's because, my lord, in the
Show cause notices.
9/4 only to cover up 2/4.
Oh.
But where is 9/4 incident? What did you do on 9/4?
there is one reference, my lord, in page number 18, number 4, reference number 4.
It's show cause notice, isn't it?
1 minute, sir.
Show cause notice.
Reference number 4, my lord.
ಉಲ್ಲೇಖ 4 ಅಲ್ಲ?
Yes,
Maru Suchana Patra, 40, page 40 ಅಲ್ಲಿ.
ಉಲ್ಲೇಖ 3.
complaint ಅಲ್ಲಿ ಇದೆ, page 18,
ಅಲ್ಲ
annexure
ಅಲ್ಲ,
B.
ಉಲ್ಲೇಖ 4 ಬಗ್ಗೆ ಇದ್ರಲ್ಲಿ ಇದೇನಿದು? ಕಂಪ್ಲೇಂಟ್ ಯಾವುದು?
Page 18, my lord.
18 is the complaint. ಅದ್ರಲ್ಲಿ ಉಲ್ಲೇಖ 4 ಅಂತಿದೆ.
ಹೌದು,
Page
ಅದ್ರ
40.
ಅದ್ರ ಉಲ್ಲೇಖ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಅದ್ರ ಉಲ್ಲೇಖ?
ಅದರಲ್ಲಿ
ಸುಮ್ನೆ ಉಲ್ಲೇಖ ಹಾಕ್ಬಿಟ್ರೆ ಆಯ್ತು, ಏನು ಇರೋದೇ ಇಲ್ಲ. That is why ಉಲ್ಲೇಖ. Sir, that would have been your main ground if at all that real reference was there. ಸುಮ್ನೆ ಒಂದು reference ಹಾಕಿದ್ರೆ to escape limitation.
No, but there is,
Well, where is the record to show that on 2/4/2019 you did something? Merely stating that we will not, sir. Government officers cannot be believed like this. Unless there is a document. ಇಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆಯಾ? 3 ಉಲ್ಲೇಖನೂ ಇದೆ. ಅದರದ್ದು ಯಾಕಿಲ್ಲ? ಅದ್ರ ಬಗ್ಗೆ ಏನಾರು ಒಂದು ಲೈನ್ ಇದೆಯಾ ಹೇಳಿ? You quote all the 3.
yes, my lord.
4th one, there is no reference at all. ಇದ್ರೆ ಅಲ್ವಾ? ಕಂಪ್ಲೇಂಟ್ ನೋಡಿದೀರಾ? ಸಂದೇಶ.
ಹೌದು ಹೌದು. Yes,
ಹಾ,
my lords.
ಉಲ್ಲೇಖ
Page
4 ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, ಏನಿಲ್ಲ, my lords.
ಉಲ್ಲೇಖ 3 ಬಗ್ಗೆ ಇದೆ, 4.
And my lords,
ಉಲ್ಲೇಖ 3ಕ್ಕೆ ಸ್ಟಾಪ್ ಆಗಿದೆ ಎಲ್ಲ, ಅದಕ್ಕೆ ಉಲ್ಲೇಖ 3 ಬಗ್ಗೆ ಇದೆ ಅಷ್ಟೇ.
and they say
ಅದು
which
ಕರೆಕ್ಟ್ ಆಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಿರಲ್ಲ, 2/4 ರಿಜಿಸ್ಟರ್ ಮಾಡಿದೀರಾ, ಒಂದು ವಾರ ಆದ್ಮೇಲೆ ಒಂದು ಉಲ್ಲೇಖ ಹಾಕ್ಬಿಟ್ರೆ ಸರಿ ಹೋಗ್ಬಿಡುತ್ತೆ. This is not the way to register the crimes. See, if you really want to do something, please do it. Don't leave loopholes like this.
Even, that's
For the
correct.
sake of filing, you should not file.
That's correct.
ಏನು ಇಲ್ಲ ಅಲ್ಲಿ.
But whether they, even as on today, The investigation also says that they have not complete, they have not,
Where?
charge sheet has been filed now.
Where is the charge sheet?
Page 29.
20?
29, my lord.
ಏನ್ ಪಬ್ಬ ಇದು?
I'm sorry, my lord.
Pub is it?
No, commercial building ali one is a pub. Commercial building, my lord.
Fire safety measures are not there in the
My
commercial
lord,
building?
it is there now, my lords. It is definitely.
then it was not there?
Okay, the first point of time when they inspected, it wasn't there, my lord.
Why?
My lords, at that time, we were under the impression that it was there, my lords. It wasn't there when the inspection was done, but subsequently we have rectified that. We have rectified it. Now, my lords, the four aspects which they say is a
Will
paid-
impose exemplary costs for not having it
at that point
at
of
that
time.
point in time.
Fire itself, my lords, is not.
No, no, that's a different thing, but you can't be left off the hook just like that. Use fire safety norms, how did you, start the
No, my lords, the whole issue.
business in the
and
building?
the whole issue was, my lords, the height, the floor height.
Sir,
that goes
whatever
on the
it is.
basis of the floor
A
height.
building did not have fire safety norms in it is not pardonable. Limitation, see, because of the act of these officers who don't register the crime in time, you will get away like this.
No, not just that, my lords, the ingredients of the offense which they.
That will see.
Adilla. My lords, ingredient irudu 25 matra.
ಅದೆಲ್ಲ
Section
ಅದೆಲ್ಲ
25 of the
ನೋಡುವ,
act.
but without fire safety, how did you even
No, my
allow,
lords,
allow business in the building?
my respectful submission is, I purchased this building in
Sir,
2015, my
Maybe,
lords.
sir,
The
maybe.
building was put up under the sanction plan in 2000.
Maybe fire safety you need not wait.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿದ 2004 ಅಲ್ಲಿ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಪ್ರಕಾರ.
ಆಯ್ತು,
2000
will impose some exemplary costs. A cost ಮೇಲೆ you take it to the Supreme Court, ಸರಿ ಹೋಗುತ್ತೆ.
Not a case for cost, my lords, when the ingredient itself is lacking.
That's a different thing, but it is ingredient ಅಲ್ಲ, we are on limitation.
ಅಲ್ಲ ಮೂರು.
These officers have fumbled.
ಅಲ್ಲ ಲಿಮಿಟೇಷನ್ ತಾವ್ ನೋಡಿ 285 ಅಲ್ಲಿ, my lords, they should have been an incident pertaining to fire. That's what my lords
All
said.
that I will observe.
Kind happened. Nothing has happened, my lords.
But why you did not have fire safety?
My lords, how all this arose is, could I just mention, my lords, there was a writ petition filed, some other writ petition, a direction had been given to the fire department, examine all the buildings. On that basis, my lords, inspections took place. And on the inspection, my lords, they felt these four aspects, my lords, you get at page 19, four aspects, my lords, which were not there. Page 19 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, these four aspects. Complaint ಅಲ್ಲಿ, page 19 ಅಲ್ಲಿ. Please notice, my lords, not a case of a fire taking place, but a case of these 4 points not being complied
No,
with.
no. This is not a case where no untoward incident has happened, true.
IPC ಅಲ್ಲಿ ಹೇಗೆ ಬರುತ್ತೆ, my lords? IPC ಅಲ್ಲಿ, if you have to make out a case, crime, there's no crime at all, my lords.
We'll impose
That-
some costs.
My lords,
we'll
my
quash
lords
it.
is holding
We'll quash it and impose costs
Alla,
for
my
not
lord.
having. I'm on limitation, I'll quash it.
ಒಂದು limitation. Please notice if 285 is made out, my lords judgment covers it.
I know that
Why
ಅಲ್ಲಿ
is
limitation
there-
ಇರ್ಲಿಲ್ಲ.
285 ಹೇಗೆ ಬರುತ್ತೆ?
Limitation we'll allow it.
ಅಲ್ಲ allowing it cost impose ಮಾಡಿ after
Allow
allow-
ಮಾಡಿ cost impose ಮಾಡಿ.
ಅದೇ first time, my lords. Dismiss ಮಾಡಿ cost impose ಮಾಡೋದು ಬೇರೆ.
We'll change it, sir.
Ah,
Allow
my
ಮಾಡಿ
lords,
cost impose ಮಾಡಿ.
Let's not have a new precedent of that kind, my lords. ಆಮೇಲೆ ಇದು ಎಲ್ಲ ಕೇಸಲ್ಲಿ we are allowing it, we are imposing it. ಅದು
ಅಲ್ಲ,
ಬೇಡ, my lords.
ಎಲ್ಲ ಕೇಸಲ್ಲ.
But my lords, because if ingredient only is not there, my lords, ಅದ್ರಲ್ಲಿ allowing a petition and
So
saying.
you
I'll
should
still-
sensitize your officers not to do these things. They sleep over the file and then one fine day wake up from slumber and say, oh, we'll register it now. Limitation ಆಗೋಗ್ತಾ ಇದೆ.
The problem is from department to department sending these files and
ಇದು ಒಂದ್ ವರ್ಷ
communication.
ಬೇಕಾ?
That is where,
ಒಂದ್ ವರ್ಷ ಬೇಕಾದಕ್ಕೆ. Huh?
that is where the lack. Fire department
My
has
lords,
sent.
ತಾವು ಸ್ಟೇ ಕೊಟ್ಟಿದ ನಂತರ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಾರ್ದಾಗಿತ್ತು.
ಅದು ನೋಡ್
ಅದು ಕೂಡ ಇದೆ. ಮೂರ್ ಆಸ್ಪೆಕ್ಟ್, my lords.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಡೇಟ್ ಯಾವತ್ತು?
My lords, ಚಾರ್ಜ್ ಶೀಟ್
I
ಹಾಕಿದ
have-
ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ
I have captured that in the
ಹೌದು,
interim
in
order.
the interim order only it's there, my lords. Because the ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ ಡೇಟ್
11/10/2019. ಇಲ್ಲ. 11/10/2019.
19, because my lords, the charge sheet is dated, they've shown the date in the charge sheet to be 25/2019, charge sheet ali, page 29 ali, my lords. But submitted before the court on 11/10/2019, after an stay order had been.
The 9/9 I granted this
on
stay
that-
order was
on that
granted,
basis.
not mine, of course.
So my lords, virtually on all fronts.
But that front
I,
also.
I understand on moral, not a case where a petition is being allowed and then a cost of it.
Yes, heard the petitioner is before this petitioners, the petitioners accused 1 and 2 are before this court calling in question proceedings in CC 56902 of 2019 registered for offense punishable under section 285 of the IPC and section 25 of the Karnataka Fire Force Act 1964. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner and the learned additional SPP for the state. It is the case of the prosecution that the petitioner acquires ownership of a commercial building in HAL second stage Indiranagar on 5/2/2014. Prior to which, in writ petition 380073 of 2010, this the division bench of this court had directed the fire department to notify preventive measures for high-rise buildings in terms of the notification by issuing a notification in terms of section 13 of the Karnataka Fire Services Force Act 1964. The petitioner, after acquiring the building, the petitioner, as observed here and above, acquires the building. The fire department inspects the property of the petitioner. The inspection is said to have taken place on 3 dates: on 31/12/2017, on 5/1/2018, and the last on 31/1/2018. On the allegation that there is violation of the Act and offense under 285 of the IPC, a complaint comes to be registered on 2/4/2019 before the jurisdictional magistrate police,
FIR.
before the jurisdictional police for offense punishable under section 285 and 336 of the IPC. The said registration of the crime was called in question before this court in criminal petition 4604 of 2019. This court had, the coordinate bench of this court had granted an interim order of stay of all further proceedings on 9/9/2018.
19.
To 9/9/2019. Long thereafter, on 11/10/2019, the police filed a charge sheet before the concerned court, and the concerned court registers the same as CC 56902 of 2019. Summons were issued to the petitioners on 6/10/2023. It is then they realized that despite the subsistence of the interim order, charge sheet was filed by the police. The said petition was withdrawn and the present petition was presented before the court after securing such liberty from the hands of this court. The learned counsel for the petitioner, learned senior counsel for the petitioner would submit that none of the ingredients of section 285 of the IPC or even what act is that?
At 25 beta melons, ingredient will be 285. And
280
25 I'm not, because 500 rupees fine and they, but
That's
that's
all right.
also part
So
of
and so.
limitation.
None of the ingredients of section 285 are met. The learned senior counsel would submit that the issue of limitation in registering the complaint would cut at the root of the matter, and therefore would submit that on these grounds the petition deserves to succeed. Per contra, the learned additional SPP would refute the submission to contend that non-adherence to fire safety norms is a continuing cause of action. The petitioners have not installed fire safety equipment in the building, and therefore the inspection led to registration of the complaint. He would seek to refer to he would seek to place reliance upon a reference in the complaint so registered, which is dated 2/4/2019, to buttress his submission that the complaint was registered within limitation. He would seek that the charge sheet is filed by the police and he would submit the charge sheet is filed by the police and the petitioners have to come out clean in a full-blown trial. I have given my anxious consideration to the submissions made by so-and-so. The afore narrated facts, a little history to the petitioner coming in possession of the property is that direction in writ petition 38073 of 2010 to the fire department to issue a notification to bring in preventive measures preventive measures for fire mishaps in high-rise buildings. This happens on 7/7/2011, and later the petitioner acquires the property on 5/2/2014. The inspection, it is on record that the inspection takes place on 3 dates by the fire department of the premises of the petitioner on 31/12/2017, on 5/1/2018, and 31/1/2018. As subsequent inspections having taken place, as no record is available for subsequent inspections having taken place of the building of the petitioner. Which is the limitation? ಯಾವ್ದ್ರಲ್ಲದು?
Sarah Matthew.
1 year ಅಲ್ಲ?
1 year limitation. 1 year limitation.
The complaint, the offense under section 285 is punishable with imprisonment up to 1 year. Therefore, the limitation to register the crime for offense punishable under section 285 is 1 year from the date of the incident. The incident is in the case at hand is on 31/1/2018. And 31 as the last date of inspection available on record is 31/1/2018. Therefore, the period of limitation the punishment, the maximum punishment that can be imposed runs from 31/1/2018 and would end on 30th January 2019. The complaint admittedly is filed on 2/4/2019, long thereafter. Therefore, the very registration of the crime is hit by section 468 of the CRPC. Section 468 reads as follows. Section 468 would mandate the limitation to run from the limitation to run the punishment that is to be imposed on certain offenses. As observed here in above, offense under section 285 is punishable by 1 year.
6 months.
By 6 months, huh?
How the 6 months?
Extendable to 1 year?
Illa, my lords, it says 6 months. For 285.
285 is punishable with
which may extend to 6 months or with fine or both.
Limitation
1 year. Huh?
Limitation in any case 1 year.
Limitation
is
1
in
year,
any
but
case 1 year.
punishment
That
is
is
up to 6 months.
So and so. Therefore, the complaint so filed after the period of limitation being over ought not to have been entertained at the outset. The learned magistrate has taken cognizance of the offense after the filing of the final report by the jurisdictional police. This is in error, and the error would cut at the root of the matter, as it is the question of limitation. The learned question of limitation. It would become apposite to refer to the judgment of the apex court in the case of Sarah Matthew, so and so. Constitution bench, five judge bench of the apex court in the case of Sarah Matthew, so and so, wherein the apex court holds that it is not the date of taking of cognizance of the offense that would determine limitation, but the date on which the complainant would register the complaint, or any aggrieved person would register the complaint before the jurisdictional court or the jurisdictional police, as the case would be. In that light, the very act of registration of the complaint after the period of 1 year would, on the face of it, lose its legs to stand. Therefore, all subsequent acts would undoubtedly become a nullity. The learned senior counsel has also sought to place reliance upon the judgment rendered by this court in criminal petition 4507 of 2023 to buttress his submission that even the ingredients of section 285 are not met in the case at hand. This court has held as follows. Para 11 extract madi. On the aforesaid twin counts, the petition deserves to succeed and allowed cost.
Obliged.
ಒಂದು observation ಮಾಡಬೇಕು.
But after allowing it, observation.
Yes.
Obliged.
188
188
charge sheet ಆಗಿದೆ. 188 charge sheet.
188 charge sheet ಆಗಿದೆ. 131B also
ಹೌದು.
of RP Act. ಇವ್ರು ಬರೋದೇ ಇಲ್ಲ. No representation we have the petitioner list after 4 weeks. Yes, next.
9.
171H,
The private
Motor
complaint-
Vehicles Act.
It's a private complaint filed.
125.
10 ಇದು?
9.
9.
9? All right,
The
yes.
private complaint was filed by the respondent. That the election affidavit did not disclose that there is a son to the petitioner was a
Son-a?
seizure. But they have to disclose, my lords, the existence of a dependent.
Hmm.
And the second is with reference to a property owned by the firm.
Hmm.
These are two allegations, my lord. The private complaint is filed by the voter.
How can complaint lie?
It will not, it is not maintainable. It is election officer.
Election ಅದೇ ಅವ್ರು ಹಾಕ್ಬೇಕಾಗಿರೋದು ನೀವಲ್ಲ. Complaint cannot lie.
Your lordship, non-disclosure of assets. In the very particular in the document and affidavit itself now not disclose the assets of the defendants. Mayur Nimbavali.
Which is that covered matter ಯಾವ್ದು?
My lords, there is a one connected matter which is specifically dealing on the maintainability of the PCR itself, my lord, that was clubbed initially, but subsequently.
ಯಾವ್ದು number ಏನು?
But interim order list, the day when the interim order was granted, it is mentioned. Yes.
Tag this petition along with writ petition 7458 of 2024. List them both on 12th. ಅವತ್ ಮುಗ್ಸೋಣ.
Interim order may be.
Interim order subsisting will continue till the next date of hearing.
Acts are different.
Completely different matter.
Complaint is not maintainable. Complaint is maintainable not by you. A voter cannot.
Election officer.
Forum, election officer, yes.
10.
155(2) is not complied. But on 30th
Permitted, ah.
March, the fire, my lord, the lordship, and you-
Ah,
in page 12,
155(2).
30th
Yeah,
April,
put it.
complaint is filed. Yeah. And I'll go on for it.
Jagdish will get it.
ಜಾಸ್ತಿನೇ ಬರ್ಬೇಕು.
ಅವಶ್ಯಕತೆಗೆ ಜಾಸ್ತಿ.
ಜಾಸ್ತಿ ಬರುತ್ತೆ.
ಓಹೋ. ಇದು ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ಗಿಂತ ಜಾಸ್ತಿ ಇದೆ. ಬರೆದ್ರೆ ಹಿಂಗೆ ಇಲ್ದರೆ ಪರ್ಮಿಟೆಡ್.
But sir, 30th
It
complaint
depends
is,
on who goes before the court.
but sir, may I know the date of the order, my lord, sir? It is- Sorry, I don't have.
ತಗೊಳ್ಳಿ ಏನ್.
But on 30th,
Take
6
it.
o'clock, 30th, 6 o'clock,
Put
my
it.
lord's complaint is filed.
ಆಯ್ತು ನೀವು ತಗೊಂಡು ನೋಡಿ ಅದೇನ್ ತೊಂದ್ರೆ. ಏನ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಕ್ಲಾಸಿಫೈಡ್ ಡಾಕ್ಯುಮೆಂಟ್.
ದಳವಾಯಿ ಅವರಿಗೆ ನಥಿಂಗ್ ಕ್ಲಾಸಿಫೈಡ್.
Huh?
ದಳವಾಯಿ ಅವರಿಗೆ ನಥಿಂಗ್ ಕ್ಲಾಸಿಫೈಡ್.
Oh, nothing.
He will himself be in shock.
Very detailed.
Very
Virtually a
detailed.
conviction is passed.
Huh?
Conviction order.
ಅಷ್ಟು ಇರಲ್ಲ.
My lord, done.
6 ಪೇಜ್ ಪರ್ಮಿಷನ್ಗೆ. ಎಸ್.
What's the offenses charged against
ಸೊ ಆ ಗ್ರೌಂಡ್ ಹೋಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಗ್ರೌಂಡ್ ಹೇಳಿ.
171G.
ಹಾ.
And
Again, what is the allegation, sir?
allegation is that against one Sayukta, my lord's Patil was a candidate.
Huh.
My lords, I have made an allegation against her father, who was by then a minister and a MLA. So my
Huh.
lords, he was not even a candidate. That is the allegation.
ಬೇರೆ ಕಡೆ ಹೋಗಿ ಮಾಡಿದ್ರಿ ಅಂತನಾ?
Where a
False statement.
false statement against Shivananda Patil.
Hmm.
My lords, he was
Again,
not.
what was false about it?
My lords, I have made that some ಸಕ್ಕರೆ ಕಾರ್ಖಾನೆ ಎಲ್ಲ ಮಾಡಿ ದುಡ್ಡು ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ.
ಯಾಕೆ ವೈ?
My lords, he has filed a defamation that will be considered, my lords.
What happened? Defamation.
My lords, that your lordships have stated it on the ground that under BNSS, my lords, whether a sworn statement should be
ಓ,
recorded.
ಅದೇನಾ ಇದು? Yes, yes.
And so far as 171G is concerned, my lords, he was not a candidate. The lordships were to say 171G
Huh. He should be a candidate.
should be a candidate. Even under the election law also same thing. So these two offenses will not apply.
Yes, sir. But ಅದು ಯಾಕೆ ಬೇಕು? You don't encourage restraint at all.
ನಾವು ಸಾವಿರ ಸಲ ಹೇಳಿದ್ವಿ.
Hmm. Yes, ground will close it. The petitioner is before this court calling in question registration of a crime in crime number 28 of 2024, registered for offences punishable under section 123(4) of the Representation of People Act and 171G of the IPC. The registration of the crime has driven the petitioner to this court in the subject petition. The heard sounds. A complaint comes to be registered on 30th April 2024, alleging that on 18/4/2024, when the candidate was conducting a march to the filing of nomination for the Lok Sabha elections between 2 p.m. to 3 p.m., a speech is made by the petitioner against one Shivanand Patil, alleging that it amounted to character assassination. The complaint comes to be registered. Yaar complainant yaro?
Election officer.
Complaint comes to be registered by the election officer, alleging the aforesaid offences. The issue in the list is whether the registration of the crime has driven the petitioner to this court in the subject petition. The issue would be whether the offense alleged under section 171G is met in the case at hand. Section 171G reads as follows. Section 171G directs that whoever with an intent to affect the result of the election makes or publishes any statement purporting to be a statement of fact which is false would become punishable. The further mandate of 171G is that false statement should be made of character or conduct of any candidate who is contesting in the election, failing which
Word used is whoever, not necessarily the person. 171.
whoever, ಆಯ್ತು ಪರವಾಗಿಲ್ಲ, ಆದ್ರೆ ಕ್ಯಾಂಡಿಡೇಟ್ ಮೇಲೆ ಮಾಡ್ಬೇಕಲ್ಲ. Whoever sounds, I will answer it. Candidate sounds. In the case at hand, the petitioner has spoken about the character of, allegedly spoken about the character of one Shivanand Patil. It is an admitted fact that the said person against whom the petitioner had spoken was not a candidate for the elections then. Therefore, the section 171G would not be met. Though section 171G would spring into action the moment, not by a candidate, by whoever would make any statement which would tarnish the personal character or the conduct of any candidate. It need not be another candidate in the election. In the case at hand, since the petitioner had made such statements about one Shivanand Patil, who was not the candidate who was contesting for election, section 171G would not be met. Innondeno 123(4).
Same.
The same goes with subsection 4 of section 123 of the Representation of People's Act. In the light of the ingredient of the offense under section 171G not being met, permitting further investigation even in the case at hand would become an abuse of the process of the law and result in miscarriage of justice. The petition thus deserves to succeed with an observation that the finding herein would not become applicable or come in the way of any other proceeding pending between the parties before any other fora. For the aforesaid reasons, the following order. Allowed cost. Next in our defamation ಹಾಕ್ಬಿಟ್ರೆ ಕಷ್ಟ. ಅದ್ರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಆಲ್ರೆಡಿ. Yes. ಆಟೋ ಯಾರು? ಫ್ಲೈಯಿಂಗ್ ಸ್ಕ್ವಾಡ್. ಇದು ಗವರ್ಮೆಂಟ್. ಆಟೋ ನೀವೇ ಅಲ್ವಾ? Additional SPPF respondents.
7.
171H. Bribery. ಇದು ಅಷ್ಟೇ ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಸೇಮ್ ಲಾಸ್ಟ್ ವೀಕ್ ಮಾಡಿದ್ನಲ್ಲ. No representation. List on, no representation, we have the petitioner, list on 12th.
12,
Revision petitions I'll take on 19th, both. 12 and 13. Yes.
13.
Vinod Kumar,
Krishna, my lord. My lord, case of undue influence, 171C, my lord, there is no undue influence.
my entry order, sir.
And
ಕುಡಿಯೋದು
honorable-
ನಂದೇ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಇತ್ತಲ್ಲ ಇಲ್ಲಿ
ಇದು-
ಅರ್ಲಿಯರ್
ಅದು
ಜೆ
fix
ಪಿ
ಮಾಡಿ.
ನಡ್ಡದ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಇತ್ತಲ್ಲ
Yes, my lord, I have fixed, madam.
STP ಅವ್ರು ಬರ್ತಾರೆ.
My lord.
ಹಾ ಎಸ್ ದ ಡೀಟೈಲ್ಡ್ ಆರ್ಡರ್
STP ಅವ್ರು
My
ಬರ್ತಾರೆ.
lord.
STP ಅವ್ರು ಬರ್ತಾರೆ.
ಇದಕ್ಕ
Yeah. My lord, full bench of the apex court has clarified what is.
ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಫುಲ್ ಬೆಂಚ್
Yes, my lord, what is undue influence?
ಕೊಡಿ
Mere canvassing is not undue influence. That's what my lord is.
ಇದೊಂದು copy ಕೊಡಿ ವಿನೋದ್.
ಕೊಡ್ತೀನಿ sir. Charan Singh ಎಷ್ಟಿದೆ? ಇನ್ನೊಂದು file ತೆಗಿ.
ಸರ್ ಚರಣ್ ಲಾಲ್ ಸಾಹು
Yes, my lord. So page, para number 35 and 36, which says,
Yes.
mere canvassing is not.
ದಟ್ ಟೈಮ್ ಎಸ್
And you know. ಒಂದು ಚರಣ್ ಲಾಲ್ ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ. Lordship, may kindly see. Para number 35, madam. A gravamen of this section is that.
It's all right.
that- Yes,
ದಟ್ ಲೆಟ್ us not get into larger questions.
and
ಕ್ಯಾನ್ವಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಅಂತಲ್ಲ.
no, Lordship, may kindly see. The meaning, only one statement he has made, that
But it is covered by page 48.
TP ಬರ್ತದೆ next week.
SPP will come depending upon who is the petitioner. Yes, sir.
Lordship, may kindly see para number.
His hands are tied.
Yes.
Yes. List the matter on 12th. 12th, 12th at the request of the land additional SPP who would submit that the SPP 1 would be making his submissions in the case at hand. Interim order subsisting shall continue till the next date of hearing.
Much.
What happened to the sanction?
More connected matter is there, or some similar point, 7853/22.
Sanction ಏನಾಗಿದೆ
Yes,
ಇದರಲ್ಲಿ?
they have not granted. When they get
ಅಲ್ಲ, ಎಲ್ಲಿ-
opportunity, they don't grant. Otherwise, they agitate.
Number ಹೇಳಿ.
7853/22.
Tag this petition along with 7853 of 2022. ಅದೇ ಇದೆ ಇದು 7853.
7942. 7942.
7942 7942 of 2023. List them both on 20th, 19th. Yes.
Final disposal 16. 16.
Final disposal. No representation. ನೀವೇನ್ ರೆಸ್ಪಾಂಡ್ ಸ್ಟೇಟ್ ಆಯ್ತಾ? ರೆಸ್ಪಾಂಡ್ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡ್ ಯಾರಲ್ಲ ನೋಡಿ. No representation. We have the petitioner as a last chance. Let's this matter on 19th. Yes. Enter ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Dictating ಕರಿಬೇಡಿ. Yes.
Further reading 20.
Pramod. ಎಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡಿ ಮೇಡಮ್. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. No representation. We have the petitioners. ಅದು ಸೇಮ್. ಶ್ರೀಧರ್ ಪ್ರಭು. 19th ಎಷ್ಟಾಗಿದೆ?
19.
ಏನಿಲ್ವಾ? 19th ಎಲ್ಲ 19th. ಯಾರಿಲ್ಲ ಅವ್ರು ಎಂಟ್ರಿ ಮಾಡ್ರು ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಎಸ್.
22. List 2, 22.
List for the petitioners. My lords, I've heard the matter before, but if you permit, I would like to state the facts of this case once again. My lord, this case is, the present case is filed against a false and baseless PCR case filed by the respondents in PCR 19857 of 2021. My lord, if you observe, there are 52 accused and I am the 51st accused in that PCR. I would state, my lord, I am a person who creates video contents of the happenings of the around the state, and I create informative videos and I present it before the public on platforms like Facebook and YouTube. On 27 November 2020, I came across one such event of a protest happened on 24th against the respondents. There were rallies, there were banners raised, and I would like to read what was written on the banners. Barisu Kannada Dim Dima, Jai Karnataka, Hridaya Yesu. So such banners were raised, and my video contained such informations about and given it to the public. The video also contained a press conference which was
I'm sorry.
Wait,
a press conference which was conducted by the respondent herself the next day, clearing certain facts, and that also has been covered in the video. Milord, I would like you to turn to page 132. I would like to note the ground on which they have filed the case against defamation against me. Dinanka 27/11/2020 ರಂದು 51ನೇಯ ಆರೋಪಿಯಾದ ರಾಧಾಕೃಷ್ಣ ಹೊಳ್ಳ ಫೇಸ್ಬುಕ್ನಲ್ಲಿ ನನ್ನ ಗೌರವಕ್ಕೆ ಕುಂದು ಬರುವ ರೀತಿಯಲ್ಲಿ ಸೌಮ್ಯ ರೆಡ್ಡಿ ಉತ್ತರಿಸದೆ ಉಳಿದ ಪ್ರಶ್ನೆಗಳು. ಸೌಮ್ಯ ರೆಡ್ಡಿ ಉತ್ತರಿಸಿದೆ ಉಳಿದ ಪ್ರಶ್ನೆಗಳು. These are the only lines against which they have filed a case against me, my lord. So now, my lord, the learned single judge has taken cognizance of that.
single judge.
Learned sessions judge, sorry.
Yes.
Sessions judge has taken a cognizance of that.
Hmm.
This was a special matter of MLA case, so it was transferred to the magistrate.
Hmm.
And they have also charged 499 and 500 against me, my lord. Now, I would like you to read the exceptions of 499, my lord.
Hmm.
The exception itself covers the second exception, public conduct of public servants. It is not defamation to express in good faith any opinion whatsoever respecting the conduct of the public servant in the discharge of his public functions or respecting his character, so far as his character appears in that conduct.
I
And
see
no,
time.
my lord, no defamation, no ground.
Accepted. Intermodal is there.
Yes, my lord. My lord's entry model, my lord. Lord,
Detailed entry model.
Yes, my lord.
Yes.
My lord, I would seek time, my lord, for.
Why sir ಏನಿದೆ ಇದರಲ್ಲಿ?
My lord, I am not the arguing counsel, my lord. Arguing counsel is, she had come due to some medical reasons, she had went away, my lord. Kindly have it next week any day, my lord. She is ready with the matter. We have filed the objection also.
Lord, nothing, shortest date, my lord.
Please, my lord.
Anything.
Huh?
Shortest date. if
Shortest
any.
date. Okay.
Entry model is my lord's, my lord, may be extended. My lord's entry model, which may be extended.
Rest the matter on 12th as a last chance, awaiting the submissions of the, what's your name?
Vaishnav.
Heard the learned counsel, so and so. Awaiting the submissions of the
order.
counsel for the respondent, list the matter on 12th. Interim order shall continue to the next date of hearing.
Much obliged. my lord.
Yes.
Till hearing 23.
For appellant, my lord. Kindly press time, my lord, senior.
What? Praise time?
Kindly
No
press
grants time? Yes.
Short date may be.
Why?
given, my-
Why praise time?
Senior is out of station.
Okay, grants time. Yes. When do you want? 19th? Praise time, grants time, 19th.
Before.
But short date may be given, but there is some inconvenience.
All appeals, wait. All appeals on 19th.
Please.
27, up to 27. All appeals on 19th.
28.
Serial number 27, they need to paper book ಕೊಟ್ಟಿಲ್ಲ ಇದ್ರಲ್ಲಿ 27.
Common SCR paper placed ಇದೆ paper book.
But
Take it from the registry.
serial number
ಇಲ್ಲೇ ಕೊಡ್ಬೇಕಾ? Registry ಇಂದ ತಗೊಳ್ಳಿ. Yes. All 19th. All appeals on 19th.
Criminal petition 6731/2023, serial number 27.
27 appeals, sir. Sir, second list, first list ಅಲ್ಲ.
Sorry.
Yes. ಯಾರಿಲ್ಲ 19th ಹಾಕ್ತಾ ಇರಿ.
29.
Yes, Ravishankar. 499 fine.
Lords, the allegation, my lords, against this petition, kindly pass over.
Allegations are not to pass over. What is that style?
1711 interim order covers, my lord. It's a
But we have filed a private complaint.
Defamation ಬರದೆ private company. Oh, it's my detailed
Yes,
order, sir. ಇದಕ್ಕೆ ಬರ್ಬಿಟ್ಟು next time easy ಆಗ.
It will be easier for the court to.
Court or next bench, whatever it is.
My lords, they say that the trustees of the Sevanjali Charitable Trust, my lords, they're specifically saying they are blackmailers, gunda elements and manipulate documents and they conduct forgery. And I am the president of this said trust, my lords.
That's the truth, is it?
No, my lords, it's.
ಅಲ್ವಾ? All right, 19th. At the request of the council appearing for the respondent list on, you sought pass over, is it?
Passed.
Passed over by 2 weeks, yes. Interim order extended till the next date of hearing.
30.
Yes, Shiv Prasad.
188 covered by my lord's judgment.
Interim order unta?
No, this is a very interesting order, my lord. Your lordship see the order. My lord said sought for an inquiry to be conducted against the concerned.
Oh, this
Page 23.
tampering.
ಅಲ್ಲ
Tampering ನಮ್ದಲ್ಲ.
ಅಲ್ಲ
NI Act, my lord.
ಇವ್ರದಲ್ಲ, ಯಾರ್ದೋ ಕಾಗ್ನಿಸೆನ್ಸ್ ತೆಗೆದಿಲ್ಲ ಹಾಕಿರೋದು.
138 then copy.
This is, ಇದು ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ವಾ?
No, my lord, matter was admitted. Section 188. That is.
I know it.
Explanation was also.
It's my detailed interim order here.
Yes.
This is, ಯಾವ್ದೋ ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡು ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ ಅದ್ರಲ್ಲಿ ತಿದ್ದಿ.
The explanation was called.
By me, explanation.
No, no,
Was the
coordinate bench.
inquiry to be conducted by.
Coordinate.
My lord said also passed an order to conduct an inquiry against the concerned officer.
Let's say, I don't know what has happened.
Can be disposed of.
Petition could be disposed of.
That will be on the face of it allowed, because these
Yes.
things should not be tolerated.
Yes.
No, but administratively, what's to be done, we'll see. We'll dispose it, we'll take it as disposed.
Please.
Administratively ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
Please.
Allowed cost.
31.
Petitioner, my lords. Our chief may kindly have it after. Let's. Have it after week.
30?
31. Here for the petitioner.
The 19th.
Sanction.
ಅಲ್ಲ STP ಅವ್ರು ಬರ್ತಾರೆ.
ಯಾರ್ important person. Oh. I list the matter 19th.
Please.
Tell SPP.
Next time ಕೇಳಿ.
ಅಲ್ಲ 19th 12th.
19th.
Ask him to be here on 19th. ಎಲ್ಲ 19th ಹಾಕಿದ್ದೇವೆ.
Yes.
Interim order.
List on 19th, interim order subsisting ಕೊಡಿ ಏನದು?
Place appeal.
ಯಶವಾನಂದ ಬರ್ತಾರೆ. Interim order, admit ಆದ್ಮೇಲೆ interim order extend ಏನ್ ಬಂತು? Yes. The petition has been admitted by an order dated 5/7/2024. Therefore, the interim order stands extended till the disposal of the petition. I'll next date ಅಂತ ಹೇಳಿದ್ದಾರೆ. Disposal of the petition. Yes, list on 19th. You ask him to come.
Yes.
On 19th. 32? Madam? ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ admit. Complete petition ಇದು. Admitted ಎಲ್ಲ ಒಂದೇ. Pending ಇದೆಯಾ? Oppose the matter for final hearing, correct? On 19th. Yes, go to the first, 2:30 ತಾನೆ?
Okay.
Yes.
Number 1. Being spoken to number 1.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
ಅದೇ ಇದ್ರಲ್ಲಿ wrong submission was made.
Wrong submission.
Charge sheet was challenged.
ಹಾ.
ಅವರು ಚಾರ್ಜ್ ಶೀಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫೈಲ್ ಅಂದ್ರು ನಮ್ಮ ಕೊಲಿಗೂ he said that charge sheet has been filed ಅಂತ ತಾವು fresh petition file ಮಾಡಿ, but it was the charge sheet which was actual challenge.
ಲಿಬರ್ಟಿ ತಗೊಂಡಿದ್ದ?
ಹಾ.
ಯಾರು ಮಾಡಿದ್ರು ರಾಂಗ್ ಸಬ್ಮಿಷನ್?
ನಮ್ಮ
ನೀವೇನಾ?
colleague, my
No,
colleague.
I did not
You
appear
are
on the
colleague.
last occasion.
I thought she has made wrong
No,
submission.
No.
Yes. Charge sheet ಆಗಿಲ್ವಾ?
Prayer
Charge sheet file ಆಗಿದೆ.
reason my lord, prayer, they only mention crime number.
ಇಲ್ಲ sir.
All right.
ನಮಗ್ ಕೊಟ್ಟಿರೋದು.
This court on 19/8/2024 disposed the petition on the submission of the counsel for the petitioner that charge sheet had been filed during the pendency of the petition. The learned counsel, after verification, would submit that it was an inadvertent submission that was made, inadvertent erroneous submission that was made, that charge sheet had been filed. In that light, the order dated so and so stands recalled. Petition is restored to file to be heard. List the matter on 19th. Yes. 19th for admission.
Number 2.
See, I had to get you from the VC.
Not yesterday, there were many matters clashing.
It's all right. So ಅದಕ್ಕೆ
It's
we
serial.
posted it today to get you from the VC. Yes. This court on so and so. Then second time, why do
May I
you
just
want?
make one submission?
Hey,
Not the first FIR.
I'd grant an interim order.
ಅಲ್ಲ, ಅದು ಹೇಳ್ಬೋದು ಒಂದೇ.
We'll grant the interim order.
Crime 82 of 24 of Malleshwaram Police Minot has now been re-registered as crime 185/24.
I'll
ಅದು
file
prayer
a memo to
correct
that.
ಮಾಡ್ಬೇಕು.
I'll file a memo. Right away.
It's all right.
This crime 82 of 24 of Malleshwaram has been re-registered as crime 185/24. The second FIR which my learned friend is saying, not is crime 190 of 24 of Ashok Nagara Police Station. Now, I have examined both the FIRs. The allegations that are made in the second FIR can definitely merge not with the
Yes.
investigation in
It's
the first
always
FIR.
there.
ಅಷ್ಟೇ ಆದ್ರೆ ಸಾಕು.
It's always
ಅಂತ
there.
it can dispose of.
No, I want to argue on merits. They have filed
Then
some
let there be an
documents,
interim
three-
order as against, only as against the
not
second.
3 pages, they are not even legible in the objection statement filed by them. Let it be posted for.
ಅಲ್ಲ, ಇವರು 207 ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ, ಅದು ಎಲಿಜಿಬಲ್ ಇಲ್ಲ ಅಂತೆಲ್ಲ ಮಾಡಿ ರೂಢಿ ಇದೆ.
You want to submit on merits, we will hear it.
No, my lords, let it be posted on.
No problem. ಅಲ್ಲ, ಈ ಎರಡು ಕ್ರೈಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಒಂದೇ.
On 190 also I have challenged. It is 8213. It's in FR number, my lords.
Where is it?
My lords, it's
ಅಲ್ಲ,
not
then
been
we will
listed.
hear that.
My lords, along both of them together, my lords. In the
No.
meanwhile,
ಅಲ್ಲ, ಎರಡು ಸ್ಟೇ ಮಾಡಕ್ಕೆ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲ, ಅದು ಬಂದಾಗ ನೋಡೋಣ.
FIR ಅಂದ್ರೆ
ಅದು
ಒಂದು stay.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಯಾವುದು ಸರ್?
my lords, this case was originally crime number 80.
185 199 ಇದು.
ನಾನು 190 ಬಗ್ಗೆ ಈಗ ಹೇಳ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
ಈಗ 185 ಮಾತ್ರನಾ ಇದು?
185 ಮಾತ್ರ.
ಈಗ so prayer has to be 185.
185 of Ashok Nagar Police Station, which was earlier 82 of Malleshwaram Police Station. ಅಷ್ಟೇ, ಬೇರೆ ಏನು ವ್ಯತ್ಯಾಸ ಇಲ್ಲ. ನಂಬರಿಂಗ್ ಮಾತ್ರ ಚೇಂಜ್ ಆಗಿದೆ. And the police station. And what I was trying to show here, my lords, or demonstrate, was not merely the change of number, the manner in which the abuse has happened.
That we'll see in
How
the
they're
other case
using the
also.
criminal law. If Malleshwaram police, admittedly, the police comes to the magistrate's court.
What's the allegation?
My lords, may I just mention this, my lords,
Hearing.
why there is abuse and why a civil matter is being turned into a criminal case. Only on this aspect, this is very vital, my lords. It doesn't happen often in investigation. The arrest is occasioned at the instance of one police station. That police IO comes to the magistrate's court and says that I want further investigation, further PC in order to conduct investigation. Then the court asks him, is there a single instance of anything having transpired within your jurisdiction? He admits that he does not have. In fact, I was.
How does he seek your arrest?
My lords?
How does he seek your arrest if
He
nothing is there?
keeps me, in fact, that would be unlawful custody for a matter of about 9 days. He keeps me and still has the audacity to ask for further extension of police custody. When we point out the illegality to the honorable magistrate, the learned magistrate immediately seized upon the matter, asks him, do you want me to write it to the DGP about what you have done, or?
All this is in writing?
My lords, that aspect, only that bit about the DGP is oral, but the finding that the IO says that I will hand it over to the Ashok Nagar Police Station. On the same day when he also asked for PC. This is the manner in which they are misusing this. And then I move bail, my lords. Ashok Nagar Police Station then re-registers this as crime number 185. When they get a whiff of the fact that I might get a bail in this because it is posted for orders, they file another. It is not as innocuous as they are saying about crime number 190 being filed. So this is a case of grave misuse abuse of the criminal law in order to settle everything arising out of an agreement where sale is happening of the goods as well as the trademarks. Now, they don't want to transfer the trademarks to me. It has got stuck at that level. When I'm trying to push that, they make use of these criminal cases in order to settle the scores. It is not that we don't
On
want to.
merits, if you want, we will hear it. Objections
Please, let-
ಹಾಕಿದಿರಲ್ಲ.
Objection ಹಾಕಿದೆ.
I want to file a rejoinder also, Manoj. A very thick objection has been filed.
Rejoinder.
Or let it be.
ಅದೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಅಂತ ಎಲ್ಲ ಇಲ್ಲೇ
ಇಲ್ಲ.
this is not a civil case.
Rejoinder criminal petition.
ಅಲ್ಲಲ್ಲ,
Objection ಇಲ್ಲ, state
ಅಲ್ಲ.
objection ಅಷ್ಟೇ ಅದು.
Very
But
well.
this is objection not on merits of the matter.
ಇಲ್ಲ, merits ಗೆ ಹಾಕಿದ್ದಾರೆ. Let it be posted merits anytime next week.
That
We'll
will
dispose
do.
it off.
But my submission is, if he is saying there are two FIRs, that they've been interim orders for a
ಅದನ್ನ
second
comply
FIR
ಮಾಡಿ
is
move
concerned.
ಮಾಡ್ಬೇಕು ತಾನೆ, ಎರಡು ಒಟ್ಟಿಗೆ ತಗೋಬಹುದು.
My lord, there was some delay, my lords. What the problem was, the client was not here. I am told that they are also filing cases in Kerala where he has to go and pursue it.
ಕೇರಳ
They're
ಪೋಕ್ಸೋ
using
ಕೇಸ್ ಹಾಕಿದೆ,
every
ನಾವು ಹಾಕಿದ್ದಲ್ಲ.
criminal
ಪೋಕ್ಸೋ
case.
ಕೇಸ್ ನಾವು ಮಾಡಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲಲ್ಲ, ನಾವು ಯಾವ್ದು ಅಂತ offense ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ಹೆಂಗ್
ಪೋಕ್ಸೋ
ಗೊತ್ತು?
ಕೇಸ್ ಆಗಿದೆ.
ಅಲ್ಲಲ್ಲ, ಅವ್ರಿಗೆ ಹೆಂಗ್
We know,
ಗೊತ್ತಿದೆ?
not we know.
ಅಲ್ಲಲ್ಲ, ಹೆಂಗ್ ಗೊತ್ತಿದೆ?
ಅವ್ರಿಗೂ ಗೊತ್ತಿದೆ, ನಮ್ಗೆ ಗೊತ್ತು, ಯಾಕೆ ಗೊತ್ತಿರಬಾರ್ದು?
ಯಾಕೆ ಗೊತ್ತಿದೆ?
ಯಾಕೆ
ಯಾಕೆ ಗೊತ್ತಿದೆ
ಯಾಕೆ
ಅಂತಂದ್ರೆ misuse
ಗೊತ್ತಿರಬಾರ್ದು?
ಮಾಡ್ತಾ ಇದೀರ, ಅದಕ್ಕೆ
ಯಾಕೆ
ಗೊತ್ತಿದೆ.
ಗೊತ್ತಿರಬಾರ್ದು? It's a cognizable
ಯಾವಾಗ
offense.
ಫೈಲ್ ಮಾಡ್ತೀರಾ? ಇದನ್ನ
FIR
ಪೋಕ್ಸೋ?
ಆಗಿದೆ.
That's all.
ಎರಡನೇ FIR ಆದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡ್ತೀರಿ.
ಅಲ್ಲ, ನಾನು ಮಾಡಿಲ್ಲ, ಪೋಕ್ಸೋ ನಾನು ಹಾಕಕ್ಕಾಗಲ್ಲ.
It is as
ಪೋಕ್ಸೋ ಯಾರು
crystal
ಹಾಕ್ಬೇಕು?
All right, I guess it's time for coffee.
Please, my lord.
Yes.
But my request is, not if it is
My
saying there are
request
two
is let
FIR,
it be posted
let
after
there be
2 weeks,
not
my lords.
interim order in respect to second FIR, not the first one.
Kindly.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆ ಅದು ಸ್ಟೇ ಆಗುತ್ತೆ.
Stay ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್
So
ಮ್ಯಾಟರ್
great.
ಅಂತಂದ್ರೆ, not kindly permit me to not bring to a lordship pain.
No, Prasanna Kumar sir. This is crime number 185 is the subject matter here.
Please, bro.
190 is not yet before the court.
The petition, not the submission was, there are two FIRs. Second FIR stay agli, not the first one.
No. That is not the submission. I'm so sorry. Don't
ಈಗ
misinterpret
which is
it.
the first one, sir?
First
It's
one is
not
this
the
one,
submission.
185 of 24.
ಯಾವ ಚಾಲೆಂಜ್ ಇದೆ ಅದು ಸ್ಟೇ ಮಾಡ್ತೀವಿ.
Same.
ಈಗ ಯಾವ ಚಾಲೆಂಜ್
ಅಲ್ಲ,
ಆಗಿಲ್ಲ,
ಇನ್ನೊಂದು ಚಾಲೆಂಜ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. Not
ಇನ್ನೊಂದು
the-
ಬಂದಾಗ ಅದ್ ಮಾಡೋಣ.
No.
ಬಿಕಾಸ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೆ. ಇಟ್ಸ್ ನಾಟ್ ದಟ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, not the bank account details indicates, not he has transferred not crores of rupees to his personal account from the not company account. Just for instance, not page
ಇಲ್ಲ, ಅದನ್ನ
33.
ಈಗ ಡಿಫ್ರೀಸಿಂಗ್ ಕೇಳಿದೀರಾ?
My lords,
ಅಲ್ಲ, defreezing ಅಲ್ಲ.
my lords, if he's going
Not
to
he is,
argue on
ಒಂದ್
merits,
ನಿಮಿಷ ಇರಿ ಸರ್, ನಿಮ್ದು ಹೇಳಿದೆ, ಒಂದು ಸಮಾಧಾನ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಸಮಾಧಾನ
But
ಮಾಡ್ತಾ
page
ಇದ್ದೀವಿ.
33
You
of
are
my statement of
misinterpreting.
objection.
Crime number 180 ಅಲ್ಲಿ ನಾವು ಕೇಳ್ತಾ
ಅದೇ ಐ
ಇದ್ದೀವಿ.
ಗ್ರಾಂಟೆಡ್ an interim
ಮಾತಾಡೋಣ.
order, it's only for correction. Wait.
You have invited us, please wait. Not kindly have a look at page 33 of my statement of objections, not.
ಹಾ,
Not the, this
No,
is
no.
not the statement of the bank statement of not the complainant company,
all right,
of which he is also director.
all right.
Not kindly come to, not the transaction dated 21/5/24, wherein not he has withdrawn, transferred to himself, a sum of rupees 46 lakhs,
46
that's
lakhs.
46 lakhs,
Sorry.
not into his account.
All right.
Secondly, not kindly also have a look at,
From which account, sir?
not from, not the company account to his account, personal account.
Was he not involved in the company?
I was a
But
CEO.
Not, he was a CEO, not, there is no, not.
Then
good,
wha-
not-
what's
But I have account statement to show that I have transferred the
Magistrate
money.
ಕೊಡ್ತಾರ, ಮಾಡಿದ್ರೆ ನಾನು
Sir,
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
1 minute, yes.
Company account ಅದು. ಕಂಪನಿಯಿಂದ he is a director. Not unless not there is a resolution that he can draw so much money to himself. Not, this is not illegal
That
transaction. Not,
becomes,
then not.
that
kindly-
becomes a crime?
Then not kindly also have a look at, not page 54.
I will hear it.
Please.
ಈಗ being spoken to ಬಂದಿದೆ. I will only restore that interim order because it was a mistake.
ಇಂಟ್ರಿ ಮಾಡ್ರು ನೋಡಿದ್ರೆ 2 FIR ಇದೆ ಅಂತ ಇಂಟ್ರಿ ಮಾಡ್ರು
Yeah,
ಕೊಟ್ಟಾರೆ.
I'll clarify. I have not yet uploaded it. I'll clarify.
ಅಲ್ಲ, ಇಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿ 2 FIR ಇದೆ ಅಂತ ಹೇಳಿ stay
ಎರಡು
ಕೊಟ್ಟಾರೆ.
FIR ಇದೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ 2ನೇ FIR ಸ್ಟೇ ಆಗ್ಬೇಕು ಅಂತ ನನ್ನ
ಇಲ್ಲ, ನಾ may summarize what was the point I was trying
ಎರಡು
to.
ಯಾಕೆ ಇದರಲ್ಲಿ offenses ಜಾಸ್ತಿ ಇದೆಯಾ?
ಅಲ್ಲ, ಇದು any one of them have to continue ಅಷ್ಟೇ ನಾನು ಹೇಳೋದು.
That we will see, which will permit to continue, we'll see. But 2 FIRs on the same cause of action cannot be there. That's why I asked him when between 185 and 190 gap of 9 days ಇತ್ತು ಅಂದ್ರೆ ಆ 9 days ಅಲ್ಲಿ ಏನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ? Nothing. If nothing,
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ, that can be looked into in the first FIR itself.
ಆಗಿರೋದನ್ನ ಸೆಕೆಂಡ್ FIR ಅಲ್ಲಿ ಹೇಳಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಸೆಕೆಂಡ್ FIR ಅಂತ ಹೇಳದೇ ಇದ್ರೆ then not the interim order, the tenor of the interim order not, we may have to change.
no, we'll do that. I've not yet uploaded this anyway. Yes. Our 185-82 ಇದರಲ್ಲಿ I was unnecessarily rude also to him yesterday.
That is right.
Sorry,
But
yes. Yes. This court on 23/8/2024 had dictated the interim order. Before the order could be signed and the order uploaded, it was noticed that what the prior that was sought in the petition was stay of further proceedings in 82 of 2024, the council, and therefore the matter was posted for being spoken to. New word. For being spoken to. The learned counsel Nitin Ramesh has clarified that it was a mistake on their part of not amending the prior to bring in a challenge to crime number 185 of 2024 as 82 of 2024 on its transfer to Ashok Nagar.
Please.
On its transfer to Ashok Nagar Police Station has been re-registered as 185 of 2024.
Please.
In that light, the interim order so granted. In that light, there shall be, the interim order was granted on the premise that after registration of the crime on, in crime number 185 of 2024, within a gap of 9 days, another crime comes to be registered in crime number 190 of 2024. Therefore, 2 FIRs are registered on the same cause of action. Though the learned counsel for the respondent P. Prasanna Kumar would seriously dispute the fact and submit that the matter has to be heard, the matter would be heard. But the investigation in crime number 185 of 2024 shall remain stayed till the next date.
Any date after 9th.
But this may not preclude, not continuation of investigation, not of the other one.
That's all.
Please, please.
It is made clear that the stay is granted only for investigation in crime number 185 of 2024.
Yes. Great.
Yes. 190 is ಮಾಡ್ಕೊಳ್ಳೋದು ಬಂದಾಗ ನೋಡೋಣ.
ಬಂದಾಗಿದೆ. Not any date after 9th.
All right, it's on 11th.
11th. Great.
Yes,
Please.
it's on 11th in the fresh matters list.
Along with ಅದು ಇನ್ನೊಂದು ಯಾವ್ದೋ ನಂಬರ್ ಹೇಳಿದ್ರೆ ಅದು ಬಂದ್ಬಿಟ್ರೆ.
ಅದು FR ನಂಬರ್ ಇದೆ ಅಂತ ಬರ್ಲಿ, ಅದು ಮೂವ್ ಮಾಡಿದಾಗ ಹೇಳ್ತೀನಿ.
Please.
Number 3.
Refer for the respondent number 2 in this matter.
ಇದ್ಯಾಕೆ?
And the matter was compounded by so far as the petitioners are concerned.
ಓ ಎಲ್ಲಾರ್ದು ಆಗೋಗಿದ್ಯಾ? Settlement.
Operative portion.
ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ ಕ್ವೇ ದಿ ಪೆಟಿಷನರ್ಸ್ ಅಂತ ಹಾಕಿ ಅಷ್ಟೇ. ಆಲ್ ರೈಟ್, ಎಸ್. ರವಿಶಂಕರ್. So detailed entry model.
Other 409, 417, that's all. Even in the merits millet, I have a case.
Ashu.
Ashu case is, it's not, both the departmental inquiry. In this case, my lord, is not covered because in both the departmental inquiry, evidence is not recorded. Evidence is not recorded.
Why did you, Lokayukta, say that there is already, we will not proceed further?
Because
how can you, the respondent arguing against his own order? Unheard of.
Even the prosecution wanted to withdraw. Idu gandange hinti beda. ಆಯ್ತೆ ಸೊಸೆಗೆ ಅತ್ತೆ ಬೇಕು
ಬೇರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸಿಗದೇ ಇಲ್ವಾ ನಿಮ್ಗೆ?
That is not, they doesn't want.
Why do you always enter into a family? Yes.
ಅಲ್ಲ ಅತ್ತೆದು ಮನೆ ಮ್ಯಾನೇಜ್ ಮಾಡೋದು ಕರ್ತವ್ಯ, ಅದಕ್ಕೋಸ್ಕರನೇ ಮಾಡ್ತಾರೆ.
Yes.
Even prosecution doesn't want. They want to withdraw.
My department.
No. That is not the issue. The Lokayukta itself says that no, there is already an order. We will not interfere. ಅದೇ ಅಲ್ವಾ ಇದು ಕೇಸು?
I cited one decision.
ಏನ್ decision ಕೊಡಿ? ಏನು you can argue against your own action?
No, my lord, departmental inquiry is not at all conducted. Only thing is, my lord.
Why did you pass an order saying this is not a fit case for us to conduct an inquiry?
Because.
Why did you say that?
Because it's already departmental inquiry is conducted by the
correct.
Conducted by the government.
All right.
That is the reason, my lord, is drop the proceedings.
ಈಗ ಅದೇನ್ ಜ್ಞಾನೋದಯ ಆಗಿದ್ದ ಆಮೇಲೆ?
It's a criminal proceedings is entirely different, my lord. That's my submission.
No, sir, we will not.
And the last occasion I cited this decision, para 7, Sanju Ranjan Nair. It's para 7, my lord, is has to be considered. What else? Last occasion ಕೊಟ್ಟಿದ್ದೀನಿ.
Last week ಕೊಟ್ರಾ?
Last time.
ಅದು last week ಆಯ್ತು.
ಅಲ್ಲ. ನನ್ನ ಹತ್ರ ಒಂದೇ ಉಳಿತದೆ. Para 7, well. If it is recorded the evidence.
That I know, sir. Departmental inquiry.
Departmental inquiry recorded the evidence. The same evidence has to be looked into in the criminal case also. In this case, in both the departmental inquiry, evidence is not at all recorded. On that point of time, my lord, this is not covered by judgment. In recent Supreme Court decision, my lord, clearly says that evidence is entirely different. If it is an evidence.
An allegation,
409, 470.
Fact
The
of the
fact-
allegation.
The petitioners are the PDO and grade 1, grade 2 employees of the panchayat. For a Narega millet under the scheme.
ಎಷ್ಟು misappropriation?
Misappropriation ಏನಿಲ್ಲ, ದುಡ್ಡು ಎಲ್ಲ ವಾಪಸ್ ಬಂದಿದೆ. Even before the crime was in millet registered, the amounts have been paid. That is the allegation. Even before the registration of the crime.
It's still worse, my lord, they
one second,
admitted
one-
that, my lord, they
ಇಲ್ಲ.
committed an offense
Prasad,
and
ನಿಮಿಷ.
reimbursed the amount on that point of time.
ಯಾರು reimburse ಮಾಡಿದ್ರು?
Very, ಎಲ್ಲರೂ
But there was no guidance to give how much it has to be awarded. Under section 405 millet,
No, did you reimburse amount from your pocket?
yes, my lord.
it has been given.
No,
The
why did you
allegation-
reimburse from your pocket?
Millet, it has been, they have taken from the pockets and it has
They
been
took
given.
from your pocket.
Millet, page 129.
Give, sir.
Millet, we have given.
Why?
Millet, page 129, that is
Is
the
there,
allegation.
if you're not done anything or taken money, why did you give it
Millet,
back?
because there was no circular how much it has to be paid. On the
That's
work
all,
direction.
that's all right, sir. Why did you give it from your pocket?
Millet, they have initiated the.
So is
proceedings.
it that you have pocketed?
No,
Then-
we have not pocketed.
Then-
For accused number 71, for accused number 71, they have made for the fixation of a kit and board millet holdings, they have made an excess payment. That excess payment was recovered on the ground that there was no direction issued how much it has to be paid.
Recovered from whom?
Millet, the PDO and the grade 1 and 2 secretaries. There was no directions issued by the government.
First thing is, why did that money come to you?
Millet, it has been ordered to be given for fixation of the holdings.
All right, sir. Who gave you that money?
Millet, by the panchayat itself. To give
it
to
was
the accused number.
legal-
Also have been
No, no,
procured.
it was legally interested money to you?
Yes, Millet.
You gave it back from, why did you give it back from your pocket?
Because there was no direction how much it has to be. One board ಗೆ ಎಷ್ಟು
Sir,
ಕೊಡ್ಬೇಕು
ಒಂದ್
ಅಂತ
ನಿಮಿಷ.
ಹೇಳಿರ್ಲಿಲ್ಲ.
ನಿಮ್ಗೆ ಪಂಚಾಯತ್ ಕೊಟ್ರು.
ಹೌದು.
ಅದೇನ್ ಅವ್ರ
ಪಂಚಾಯತ್ ನ ಫಂಡ್
ಪರ್ಸನಲ್ ಮನಿ ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದು,
ಅಲ್ಲ, ಹೌದು.
ಪಬ್ಲಿಕ್ ಮನಿ.
ಪಬ್ಲಿಕ್.
Why did you give your personal money in exchange?
Millet, that what is the amount which was excessive has been paid from the accused number 71, it was recorded and paid.
Why?
Because we have already made access payment to accused number 71. That is the Millet allegation. Kindly see page 129 for a moment. This is the only allegation. 129.
Page?
129. Even it starts from 126.
ನಿಗದಿತ ಬೆಲೆಗಿಂತ ಹೆಚ್ಚುವರಿಯಾಗಿ
ಅವರಿಂದ
ಪಾವತಿಸಿ-
ರಿಕವರಿ ಮಾಡಿ it has been given.
ಈ ಅವ್ರು ಪಾವತಿಸಿದ್ದು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ ನೀವ್ ಕೈಯಿಂದ ಯಾಕೆ ಕೊಟ್ರಿ? That's all the issue. Why did you reimburse the money?
Because under 71 Millet, there was no guidelines how much will have to be paid. It has been recovered from the accused number 71 and it has been reimbursed. Whatever the amount which has been paid excess to the accused number 71. Even Millet, it has been paid on 21/4/2012. FIR has been registered in the year 2014. As on the date when the alleged offense was made, they, in the charge sheet,
ಇದೆಲ್ಲ ಮುಕ್ತಗೊಳಿಸಿದೆ ಅಂದಿದ್ದೆಲ್ಲ ಯಾವಾಗ?
Millet, that has been,
Page 159.
yes, yes.
Because they
And
reimbursed
even-
that amount, that is the reason.
1 second, 158. ಮುಂದುವರೆಯುತ್ತ ಲಾಸ್ಟ್ ಮುಂದುವರೆಯುತ್ತ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಮೇಲುಸ್ತುವಾರಿ ನಡೆಸದೆ ಕರ್ತವ್ಯ ಲೋಪವನ್ನು ಎದುರಿಸುತ್ತಿರುವ ಈ ಕೆಳಕಂಡ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಪಾರದರ್ಶಕ ನಿಯಮವನ್ನು ಪಾಲಿಸಿ ಖರೀದಿಸಿರುವ ಬಗ್ಗೆ ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆ ಮತ್ತು ಉಭಯತರ ವಾದ ಮತ್ತು ಪ್ರತಿವಾದವನ್ನು ಪರಿಶೀಲಿಸಿ ನೌಕರರ ಕರ್ತವ್ಯ ಲೋಪಕ್ಕೆ ಸಾಕ್ಷ್ಯಾಧಾರರ ಕೊರತೆಯಿಂದಾಗಿ ಆರೋಪ ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲ, ನೀಡಿರುವ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಅಂಗೀಕರಿಸಿದೆ. Millet, they draw a government order on 17/4/2008.
Inquiry officer was appointed.
Please, Millet. Enquiry officer was appointed as could be eminent, Millet, under page 158. They say, and the government order accepts that. Thereafter, the government once again, Millet, page 161. The very same government,
Oh, that is a-
whatever interested,
Disciplinary authority.
no, it is there's a disciplinary authority. Page 161 is a
Adeshavana-
government order. Page 161.
Oh, government
Itself,
interestment
what's-
withdrawn.
Withdrawn. When, that is why I quoted the first line ಅವರಿಗೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಇವರಿಗೆ ಬೇಕು. They want to pursue this. And there was
ಅಲ್ಲ ಇವ್ರೇನೋ ಒಂದ್ ಮಾಡಿದಾರಲ್ಲ
that has been produced along with the
where-
memo. Kindly see para 98 of along with my memo. Page number 54, 53 and 54 of my memo dated 18/7/24.
18/7.
Yes. Along with the memo I have given.
ಯಾವ ಮೆಮೊ?
I shall pass on. They have said, they have conducted enquiry, it is not possible, it becomes a double jeopardy, therefore we will not do it.
ಇದು ಫೈಲ್ ಮಾಡಿದ್ರ ಇದು?
Along with the memo I filed. That was not available because the first submission was that Lokayukt is also initiated proceedings, therefore there is no disciplinary enquiries complete. Then the Lokayukt said, no, we will drop it.
ಇದು ನೋಡಿ. Yes. Yes, sir.
Sir,
Therefore, there is no 405 itself.
Page number 158, my lord. Page number 158. First paragraph. ಈ ಮೇಲ್ಕಂಡ 30 ನೌಕರಗಳ ಪೈಕಿ 22 ನೌಕರರು ಮಾರುಕಟ್ಟೆ ದರಕ್ಕಿಂತ ಹೆಚ್ಚುವರಿ ಆಗಿ ಪಾವತಿಸುವ ಮೊತ್ತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಜಮಾ ಮಾಡಿರುವುದಾಗಿ, 4 ನೌಕರರು ದೋಷ ಪಟ್ಟಿಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಮೊತ್ತಕ್ಕಿಂತ ಕಡಿಮೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸುವುದಾಗಿ ಹಾಗೂ 4 ನೌಕರರು ಪಾವತಿಸಿರುವುದಿಲ್ಲ ಎಂದು ಮೇಲೆ ಓದಲಾದ 8 ಚಾಮರಾಜ ಸರ್ಕಾರ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. They gave from their pocket. That is the reason, my lord, they admitted that crime. That is the reason all these aspects, my lord, is a matter of evidence.
ಆಮೇಲೆ
And I cited that decision, my lord.
your entrustment itself is withdrawn. Entrustment department
ಹೌದು.
enquiry ಗೆ ಯಾವ್ದಕ್ಕೆ?
ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಆ ಎಲ್ಲಾ ದೂರುಗಳನ್ನು ಲೋಕಾಯುಕ್ತ ಹಾಕಿದ್ದನ್ನು ವಿಡ್ರಾ ಮಾಡಿದೆ.
ಇದನ್ನು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ.
ಹೌದು. ದಟ್ ಇಸ್ ವಾಟ್. ಅದರಂತೆ ಸದರಿ ಆದೇಶ ಅನ್ವಯ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿ ಹೂಡಿದ ದಾಖಲಿರಿಸುವ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳನ್ನು
Lokaयुक्त, this is Karnataka Lokaयुक्त police, not Karnataka Lokaयुक्त. Under the Lokaयुक्त Act service, Karnataka Lokaयुक्त police blood, and it is not withdrawn. There is no specific order to the Karnataka Lokaयुक्त police. Withdrawal of prosecution, my lord, is not communicated. This is concern, my lord, is the departmental inquiry.
All right. ಅಷ್ಟೇನಾ? Order reserved. Interim order subsisting shall continue till the disposal of the petty.
Great.
Yes. ಐದು ಕೊಡಿ ಮೆಮೊ.
ಮೈ ಕಾಪಿ
ತಗೊಳ್ಳಿ. Yes. Next.
5. Bill number 5.
Not the-
Respondent. Loan was obtained in the name of A1.
All right. Yes. Petitioner ಹೇಳಿದ್ದಾಳೆ. ಯಾಕೆ?
Please,
Why are you in a hurry?
please.
Yes, sir.
I'm the representative of the developer.
Ah.
On behalf of the developer, I've received the money.
Ah.
I'm not part of any of the documents. I'm
Ah.
not a signatory to any of the documents.
Hmm.
Now, they are really on 3 documents where they have involved in the idu antadne. So kindly come to the document which has been produced by them on the last date of hearing. Kindly come to page number 73, Mala.
Yes.
This is a letter that's been written by the developer to the bank. The 2 authorized signatory, not the MD. In all the documents, the tripartite agreement, the sale agreement, sanction, loan agreement, all along this managing director has signed the document. Here this authorized signatory has signed the
Who are you?
document.
Who are you?
I'm the representative of this developer to receive the money. ನಾನು ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಅಷ್ಟೇನೆ.
ಆಯ್ತು. ಆಮೇಲೆ
ಅದ್ರಲ್ಲಿ ನಂದು ಇನ್ನೇನು ರೋಲೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
Anything else? Yes, sir.
The amount, the loan was supposed to be credited to the account of the borrower. The petitioner has induced the bank to transfer it to his account.
Any communication given to you?
There's
Written
no-
communication?
There's no.
Why did you transfer it to him?
I have, the bank has also suspended the concerned manager in this behalf.
Why did you transfer it? I mean, what did you do of the money?
I've transferred it to the developer, Mala. ಅವ್ರು ಯಾರು ಹೇಳ್ತಾರೋ ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದೀನಿ, ನಾನು ಮಿಸ್ಆಪರೇಟ್ ಮಾಡಿದ್ದೀನಿ, ಚೀಟಿಂಗ್ ಮಾಡಿದ್ದೀನಿ, ಡೆವಲಪರ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್, ನಾಟ್ ದಿ ಬ್ಯಾಂಕ್.
No, developer is not is not a beneficiary at all here. ಅವ್ರಿಗೆ ದೊಡ್ಡ
ಅಲ್ಲ, ಇವ್ರು ಯಾರು?
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್,
ಅಲ್ಲ, who is he?
agreement.
Who is he?
He is the third party. He is an agent of the bank who secures
Loan.
loans.
Facilitate.
ಕೇಸಲ್ಲಿ ಇಲ್ಲ,
One ನಿಮಿಷ.
ಸಾರಿ
Facilitate loans.
Facilitator.
All right. Now, all the amount from the bank goes to his account.
Has gone to
Why?
the-
You
ಅಲ್ಲ,
give all the money to the agents, is it? Loan the.
No.
Then why did you transfer the money to his account?
This particular case, the concerned manager has been suspended and is under
Suspended ಅಷ್ಟೇ.
inquiry.
Inquiry ಅಷ್ಟೇ. Criminal case
Initiate
register
ಆಗಿದೆ
ಮಾಡಿಲ್ವಾ?
already.
Criminal case register ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, ಈಗ ಬ್ಯಾಂಕ್
number
only initiated.
ಅಲ್ಲ, bank
complaint
manager
against
ಮೇಲೆ
the
ಮಾಡಿಲ್ವಾ?
manager.
Accused number 3
A3.
sir.
Huh?
Accused number 3.
All right.
Your A3, petitioner is A2, borrower is A1.
Yes, sir.
Really,
These are matters of evidence.
please.
ಕರೆಕ್ಟ್ ಮಾಡಿ, ನಂದು ಏನು ರೋಲೇ ಇಲ್ಲ ಇದರಲ್ಲಿ. ಲೆಟ್ಸ್ ಅಸ್ಯೂಮ್ ನಾನು ಇದ್ರ ಚೀಟ್ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ ಹೂ ಹ್ಯಾಸ್ ಟು ಫೈಲ್ ಕಂಪ್ಲೇಂಟ್
No,
ಮಾಡಿ.
no. All right. ಈಗ ದುಡ್ಡು ಬಂದಿದ್ದಲ್ಲ, ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
ಅದನ್ನು ಆಸ್ ಪರ್ ಡೈರೆಕ್ಷನ್ ಆಫ್ ಡೆವಲಪರ್ ಐ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಥರ್ಡ್ ಪರ್ಸನ್ಸ್. ಅವ್ರು ಯಾರು ಹೇಳ್ತಾರೆ ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದೇನೆ. ಅದಾದ್ಮೇಲೆ ನನ್ನ ಅಕೌಂಟ್ ನ ಫ್ರೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ 1 ಲಕ್ಷದ ಇದು 1 crore 30 lakhs has been freezed by 1 crore 92 lakhs was there. 1 crore 30 lakhs has been taken by them. Under 76,000 lakh has to be recovered.
Correct.
ನಂದು ಏನು ರೋಲೇ ಇಲ್ಲ, ಬಟ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ MOU also my lord, where that the developer has authorized me to.
We'll see your role. Stay ಇದೆಯಾ ಅಲ್ಲಿ?
ಇಲ್ಲ ಅದಕ್ಕೆ
ಇಲ್ಲ.
Huh?
ಏನಿಲ್ಲ.
Yes. Get the investigation papers. Yes. The learned HCGP is directed to secure the investigation papers and place it before the court. List on 18.
Till that time.
No,
my lord.
not a case.
In any of the documents which has been produced by them, my
No,
lord.
no,
I'm not a signatory, my lord. I've not done any.
We'll see. Let the investigation. Yes, next.
Bill number 6.
And for the respondent.
Interim order ಇದೆಯಲ್ಲ?
Yes.
List on 24th, interim order subsisting shall continue till the next date of hearing.
7.
171 H and D.
E and H. H doesn't apply, E anyway. Only allegation is there are some kits found, provision kits.
ಎಷ್ಟು ಕಿಟ್ಸ್? ಕೊಡಿ.
25 ಸಂಖ್ಯೆ.
ಏನು ರಿಟರ್ನ್ ಗಿಫ್ಟ್?
ಹೌದೌದು.
ಹಾ.
ಪೇಜ್ 36
ಓಟ್ ಕೊಟ್ರೆ ರಿಟರ್ನ್ ಗಿಫ್ಟ್ ಅಥವಾ ಪ್ರೀಪೇಯ್ಡ್? ಪ್ರೀಪೇಯ್ಡ್, ಪೋಸ್ಟ್ ಪೇಯ್ಡ್ ಅಲ್ಲ. ಇಲ್ಲಿಗಲ್ ಪೇಮೆಂಟ್ಸ್.
25 ಸಂಖ್ಯೆ ಪ್ಲಾಸ್ಟಿಕ್ ಕವರ್ ಕಿಟ್, 84 ಸಂಖ್ಯೆ ಸುಮಾರು 5 kg ಅಕ್ಕಿ, 9 ಸಂಖ್ಯೆ ಪ್ರೀಮಿಯರ್ ಬಾಕ್ಸ್, ಒಂದು ಬಾಕ್ಸ್ 40 ಅಂತ ಇರುತ್ತದೆ, ಬುಲೆಟ್ ರೈಸ್ ಅಕ್ಕಿ.
Why were you holding that?
I was not holding.
Then who was it?
At a provision store.
Provision store.
Printed one candidate.
ಓ, ಫೋಟೋ ಇತ್ತ ಇವರು ಕ್ಯಾಂಡಿಡೇಟ್? ಎಲ್ಲದ್ರ ಮೇಲೂ ಇತ್ತ? ಬರೀ ಎಲ್ಲ ಪ್ರಾವಿಷನ್ ಸ್ಟೋರ್?
Not on the provision store. That is not the allegation. They have found some kits in a provision store. That's the allegation.
Where is the complaint, sir?
Complaint is page
35.
33.
Permission is taken?
Permission is not, 155(2) is not.
Their major, I'll have to verify my lord whether that. Look, the NCR has been registered. Whether subsequently permission was obtained.
Where is the complaint, sir?
Page 35, my lord, type of.
35. ಪ್ಲಾಸ್ಟಿಕ್ ಕವರ್ ನಲ್ಲಿ ಕಟ್ಟಿರುವ ಕಿಟ್ಗಳು. ಎಲ್ಲ ಚೀಲದ ಮೇಲೆ ಫೋಟೋ ಇತ್ತ ಇವ್ರದ್ದು?
Not on the covers.
ಮತ್ತೆ ಎಲ್ಲಿತ್ತು?
That's not the allegation. Only covers were found with provisions in it.
ಅಕ್ಕಿಯ ಕವರ್ ಪೇಜ್ 36 ಅಲ್ಲಿ.
And in any case, what 171 requires, if your lordships kindly see 171 and this court has held.
171B defines what is bribery during election.
Howdo. 171B requires person giving and receiving to be there.
Mere keeping of it will not.
ಕೊಡ್ತಿದ್ರು ಅಂತ allegation.
And not even my premises. It's not the allegation that it's my premises. And 155
Heard
is
the
not.
learned senior counsel Satyanarayana appearing for the petitioner. Sorry, Suryanarayan appearing for the petitioner. The learned additional SPP is directed to accept notice for the respondent. Petitioner copy untala?
Yes, ma'am.
Respond ibru nivena?
Yes, ma'am.
Also. The learned senior counsel would take this court to the documents appended to the petition to prima facie demonstrate that the ingredients of sections 171H is not met in the case at hand.
171 E and H.
E and H
H
are,
doesn't anyway apply to a
E
candidate.
and H are not met in the case at hand. The learned senior counsel would submit what was found in a provision store, in the warehouse of a provision store, was certain packets, food packets,
Food
food
Provision
products,
pack, provision.
food products in packets. The allegation is that it depicted the photograph of your one, is it?
No, independent.
You lost, depicted the photograph of the candidate who was contesting the election. The learned additionalist, he would further contend that there is no compliance with subsection 2 of section 155 of the CRPC in the light of the offences that are laid against the petitioner being non-cognizable. On the aforesaid two grounds, till the learned additional SPP would secure instructions and make his submissions, there shall be an interim order of stay of all further proceedings in charge sheet ಆಗಿದೆಯಾ?
Agide.
In CC so and so. Yes, list on
This may be
26.
connected, my lord. There's a similar matter where your lordships have passed an interim order, page 77, criminal petition 5615. Same offense, 171 E.
ಅದು ಪ್ರೆಷರ್
Page-
ಕುಕ್ಕರ್ ಇರ್ಬೇಕು.
Page 77. Illa, that's a case where
Page
77, annexure H. Criminal
Interim
petition
order.
5615.
interim order.
ಹೌದು
ಇವರೇ ಅಪಿಯರ್ ಆಗಿರೋದು.
ಹೌದು.
Same
Both
petitioner.
may be connected
Yes.
and
Tag the petition along with ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ನೆಕ್ಸ್ಟ್ ಅದೇನದು?
ಅದು police act ನಲ್ಲಿ 109.
So tag the petition along with page 77 ಇದೆ. List them both on 26th. Yes. 8 ಏನು?
8 is under 109 of the police act.
Music.
Music
No allegation as to which provision, which
ಇದೇನು
condition I have violated.
DJ.
No allegation.
Yes. Heard the learned counsel, learned senior counsel, Sri TS ಅಲ್ಲ?
T. Suryanarayan.
T. Suryanarayan, appearing for the petitioner. In the light of the allegation not meeting the ingredients of section 109 of the Karnataka Police Act, albeit prima facie, there shall be an interim order of stay.
155 also in this case.
ಅದರಲ್ಲೂ ಇಲ್ವಾ?
ಅದು ಇಲ್ಲ.
ಅದು ಹಾಕ್ಬಿಡಿ. ಹಿಂಗ್ ಮಾಡಿ. The learned senior counsel would take this court to the documents appended to the petition to demonstrate that none of the ingredients as necessary under section 109 of the Karnataka Police Act are met in the case at hand, as also the fact that there is violation of subsection 2 of section 155 of the CRPC, as the permission of the learned magistrate prior to registration of the crime is not obtained in the case at hand. Therefore, till so and so. ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ ಅದೇ ತರ. Yes, next.
9.
Great.
A respectful submission, my lords, a case of a vexatious and a malicious prosecution.
The
My lords.
the allegations are for the last 7 years, is it?
7 years back, my
Ah.
lords, we would give a complaint. What would happen is, my lords, certain, pictures of the Swamiji, which was sought to be circulated, my lords, an attempt of extortion. Complaint is given, my lords. Crime number 14 is registered. Now, this crime number 14, my lords, should get in the second volume, my lords, at page 484, my lords, annexure E.
These are matters of trial.
Allah, my lords, kindly notice this, my lords. After this, what happens is, my lords, two persons who are named in this FIR, they are the persons behind the present complaint, because now they're shown as CW 6 and 7, my lords.
Where
Now,
is-
in the present
Where
complaint,
is the complaint?
the present complaint may be noticed, my lords. my lords, whether it comes within the category, whether any person with prudence would believe this to be true.
Who is the dermatologist? No, your government is you had some skin disease.
That, my lords, Dr. Rupa, that is different, not that, my lords. Now the question here is, my lords, on the complaint, if my lord sees the complaint, they try to give a very elaborate complaint. What this complaint says is, my lords, she at the time of giving the complaint is 20 years, my lords. She would say, my lords, several years back, she would first go to the mutt along with her parents, my lords.
No, no,
Or the,
several years back and how many years?
my lords, she would say it is about 2017. 2017, my lords, she would go to the mutt for the first time with her parents, my lords, because she was suffering from health problems. They would suggest you have this kind of puja and so on and so forth. Then her narration is, my lords, in 2017, several times she has gone there, and that is where an attempt had been done first by A2 and then by A1, 2017. So the narration ends with 2017 and then next narration is 2019, my lords. Now, post 2019, my lords, all that they say, 2024, my lords, we received one phone call asking us to come there along with our aunt. That is when we have gone and given this complaint. Now, in that context, please notice this complaint, my lords. A person coming and giving a complaint after about 7 years from when it is supposed to have taken place, my lords, and going to the ashram along with parents every time. Now, my lords, if it is 2017 onwards that she has been going repeatedly to the ashram.
Jagdish,
164 statement, page 90, man.
hello, if it is 3 years old,
That's correct.
okay.
But
What stage is proceeding?
My lords, the charges would be framed, deferment of charges till this is heard at least.
Will you go through the papers and make your submissions?
page 19 ಅಲ್ಲಿ
19.
90.
ಅಲ್ಲ ಅದಕ್ಕೆ 3 ವರ್ಷ ಸುಮ್ಮನೆ ಅವಶ್ಯಕತೆ.
Something else. Just after the date, my lord, 25/3/2017.
It's a replica of the complaint. The dates are relevant. my lords. My lords, 93 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ತಾವು ನೋಡಿದ್ರಿ, my lords. ಲಾಸ್ಟ್ ಲೈನ್.
ಇದೆಲ್ಲ ಪೂಜೆ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ ನೀವೇನಾ?
My lords, in fact, my lords, this is an out, if CW 6 and 7's evidence is seen, my lords, their statement, everything comes to light. Complaint given against them, they become witnesses here. They were ex-employees of the ashram, my lords. Now, since they're removed from the ashram, this complaint comes saying 7 years back, such an incident.
We'll see. Yes, go through it. Heard the learned senior counsel, Sandesh Chowta appearing for the petitioner. The learned senior counsel would project several grounds to contend that the crime so registered or the investigation that has taken place is all a act of wreaking vengeance against the petitioner for having registered a crime against
CW 6 and 7.
against CW 6 and 7. The learned senior counsel would further submit that the acts alleged are several years prior to the registration of the crime itself, and therefore it is not an act that can be believed. The learned additional SPP is directed to accept notice for the respondent, secure instructions, go through the papers and make his submissions. List the matter on 26th September till such time, 20th September. The learned senior counsel would submit the matter slated tomorrow, slated to be listed tomorrow for the purpose of framing of the charges. In the light of the matter requiring consideration, the concerned court shall defer its act of framing of charges till the next date of hearing.
Tomorrow, though they have kept it technically for HBC, my lords, it's kept technically, but it's
Yes.
mainly, my lords. Oblige.
Yes. There appears to be something in this. Not genuine.
ಆ ಡೇಟ್ ಅನ್ನು ಓದಿದ್ರೆ then
ಹಾ.
according to them they have to die in 2 days and then
17 and 80 of KP Act, my lordship.
ಏನ್ ಕವರ್ಡಾ?
ಹೌದು.
ಗ್ಯಾಂಬ್ಲಿಂಗ್. ನೀವು ನೆನ್ನೆ ನೋಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ.
Same station,
ಸೇಮ್
same station, so one more club.
ಆಲ್ ರೈಟ್, ಕ್ರೈಮ್ಸ್ ಬೇಕು ನೋಡಿ ಇದು
ನೋಡಿ.
ಜಗದೀಶ್. ಸ್ಯಾಟರ್ಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Obliged.
ನೆಕ್ಸ್ಟ್
Producing the degree certificate, madam.
ಅವ್ರ ಡಾಕ್ಟರ್ ವರ್ಸಸ್ ಡಾಕ್ಟರ್.
Yes.
ಹಾ ಅಂತ ಹೇಳಿ ಮೇಡಮ್. ಯು ಆರ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್.
File wakalat for respondent, ma'am. Kindly direct it.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇವ್ರ ಜೊತೆ ನಿಮ್ಗೆ?
Whatever the
There was some-
certificate
huh?
is produced, all fake, my lord. I got clinching evidence against him. Without possessing a required qualification, he conducts surgery with BMS certificate.
ಸರ್ಜರಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No patient has filed a complaint. He is selling, my lord.
No, no.
Let him suggest the name of the patient who has stated that
ಕೊಡಿ,
conducted surgery.
ಸರ್ಜರಿ ಮಾಡಿದಾರೆ ಕೊಡಿ.
I'll show the photo, my lord.
ಹ್ಯಾವ್ ಯು ಕಂಡಕ್ಟೆಡ್ ಸಮ್ ಸರ್ಜರಿ?
Not me, my lord.
ಅಲ್ಲ, ಅಬೌಟ್ ಹಿಸ್ ಸರ್ಜರಿ.
No, no, yeah. Kindly produce.
ನೀವೇನು ಸರ್ಜಿಕಲ್ ಸ್ಟ್ರೈಕ್ ಮಾಡಿದಿರ ಕೊಡಿ. ಎಸ್.
And I obtained RTI also, saying that the certificate is not genuine.
ಆಪರೇಷನ್ ಥಿಯೇಟರ್ ಅಲ್ಲಿ ಫೋಟೋ ತೆಗೆಕ್ ಬಿಟ್ಟಿದ್ ನಿಮ್ಗೆ?
No, no,
ಯಾವ್ದು ಗೂಗಲ್ ಇಂದ ತಗೊಂಡ್ರದ?
not Google.
ಮತ್ತೆ
I am one of the partner in the hospital, my lord. I have brought to the notice that
ವಾಟ್ ಸರ್ಜರಿ ಇಸ್ ದಿಸ್?
I have knee surgery, something like that.
I have not conducted any surgery. my
ಒನ್
lord.
ಮಿನಿಟ್ ಸರ್. ನಿಮ್ದು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ರಲ್ಲ ಈಗ?
ಆ ಸರ್ಟಿಫಿಕೇಟ್
ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಮಾರ್ಕ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅವನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಇವಾಗ ಕೊಟ್ರ ಇದನ್ನ?
ಹೌದು, ನಾವು ಸ್ವಾಮಿ. ದಿಸ್ ಇಸ್ ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್.
ಇದ್ರಲ್ಲಿ ನೀವ್ ಯಾರು?
ನಾನು ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ನೀವಿಲ್ವಾ?
ಸ್ವಾಮಿ, ಐ ಆಮ್ ನಾಟ್ ಇವನ್ ಟ್ರೈನ್ ಟು ಡೂ ಸರ್ಜರಿ. ಹೌ ವಿಲ್ ಐ ಡೂ ಸರ್ಜರಿ, my lord? They are talking about making surgeries.
who is
When I'm
doing
not
it is-
trained to do surgery, how will I do a surgery?
ಒನ್ ಮಿನಿಟ್ ಸರ್. ಮಾರ್ಫ್ ಪಿಕ್ಚರ್?
No, my lord.
Then?
I'll prove it because let him serve this petition copy. I'll file a detailed objection.
And one more submission, my lord. He is not even a doctor, my lord.
I am not claiming to be a doctor.
Then how can he come inside the operation theater if he is having the photo?
I am the administrative member. I am the partner. How
He is
can-
not a
then I
partner.
accept-
He is saying, my lord, he has invested.
I'm not
certain-
interested in your personal squabble, sir.
That's-
Because of your if you have no qualification, you have no business to hold the hospital or conduct surgery.
Well, I have not conducted.
Public should not be
First page,
facing
my lord.
problems because of you.
No patient has filed a complaint saying that I have conducted surgery.
You're a homeopath. Huh?
Yes, my lord. No patient has filed a complaint. The dispute arose because of sharing of revenue, my lord. He has issued me a legal notice. Have you given a legal reply?
Bachelor of Homeopathy Medicine and Surgery.
That's
Homeopathy surgery na.
ಅವ್ರದ್ದು ಹೋಮಿಯೋಪತಿಕ್ ಇದೆ. But I am not trained.
ಅಲ್ಲ, ಯಾರು ಕೊಟ್ರು ನಿಮ್ಗೆ ಈ ಡಿಗ್ರಿ? ಹೋಮಿಯೋಪತಿ ಅಂಡ್ ಸರ್ಜರಿ, ಹೋಮಿಯೋಪತಿಕ್ ಮೆಡಿಸಿನ್ ಅಂಡ್ ಸರ್ಜರಿ.
ಫುಲ್ ಫಾರ್ಮ್ ಅದೇ ಸ್ವಾಮಿ ಬರೋದು.
my lord.
BHMS ಅದೇ.
ಹೌದು ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲೂ ಇದೆ ನೋಡಿ ಸರ್, ಪೇಜ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಶನ್
What
ಕೊಟ್ಟಿದ್ದಾರೆ.
kind of surgery?
ಹೋಮಿಯೋಪತಿಕ್ ಕೈಂಡ್.
ಹೋಮಿಯೋಪತಿ ಯಾವ ಸರ್ಜರಿ ಇದೆ?
Take
I produced my
certificate.
mark sheet also, my lord.
All right.
I have obtained
ಎಲ್ಲ ಕಾಪೀಸ್ ಇವ್ರು ಕೊಡಿ.
Yes, my lord.
petition, maybe
Petition copy and everything. You keep this and file your objections.
absolutely.
In the previous date, my lord, court had passed an order saying that not to take any precipitative action in the garb of investigation, my lord. I furnished a copy to the police also, my
They
lord. After that, again, they are calling, come for investigation, my lord. In
You should
spite of-
cooperate with the investigation.
I've given all documents, my lords. Only to harass, my lord, whole dispute, my lord, they want me to settle with the complainant, my lord.
We'll see.
The dispute is regarding
I
amount.
told you, I'm not interested in your dispute. No public should be harmed because of your act of having qualification of homeopathy
No,
and conducting
My lords,
surgery.
no public has filed a complaint saying that I have conducted surgery.
We'll
I'm
see.
the owner of that hospital, my lord.
We'll see. Yes. The learned counsels on ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ರು sir.
Counsel so and so submits that he has entered appearance for the respondent. Hey, Chandrasekhar ಅಂತ ಇದೆಯಲ್ಲ already. Yes, counsel Chandrasekhar for the second respondent seeks 2 weeks time to file statement of object, file everything.
You can give the.
Yes,
direct-
and they should also
File
give that
statement
copy.
of objection, petitioner to serve all the papers that he has filed before this court, even in piecemeal,
Yes, ma'am. And
to the counsel for the respondent forthwith. Yes.
the copy which they served, ma'am, that also
I'm
copy.
with objections, I'll give.
Objection ಹಾಕ್ತಾರೆ ಅದನ್ನ.
Until then, my lord, police, my lord, in spite of the order, they'll again
The
calling me.
interim protection that is granted earlier
There's
stands
no
extended.
interim
till-
protection, my lord.
There's an order passed, my lord.
Absolutely.
There's
What
an
is-
order.
Protection granted earlier shall stand extended till the next date of hearing. Illa andre illa. Yes.
Date.
List on 23rd in the fresh matters list.
Orders? 12?
Yes, Tahir, what is this?
There is accused number 4, Lordship, non-executive manager, non-executive director, Lordship. 420, 406 and 420 the offense, Lordship. Lordship,
I
the
have
coordinate bench is
read-
already dealt with the matter and consider
No,
the
it's
case of
my
the same petitioner.
detailed interim order of
Detailed
granted.
interim order is there. Lordship, the issue is that police verification is not able to clear for the employment. For that reason, I requested last occasion for the
Will pass over ಇವತ್ತಾಗಲ್ಲ Saturday ತಗೊಂತೀವಿ.
and CL number 49 is also connected, Lordship.
Tag this petition along with 49. List this matter on Saturday, awaiting the appearance of the counsel for the respondent. Heard the counsel for the petition, mail ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ. Saturday. Well,
They will be extended.
interim order stands extended to the next date. Yes, Ajay.
The offense under 304A.
Hmm.
My lords, I was one of the members of the NCC camp. In which NCC camp, my lords, one of my.
Zipline.
Please, my lords.
Zipline, is it?
No, zipline. My lords, companion, my lords, my companion in the camp, my lords, would drown and my lords breathe his last. Thereafter, my lords, the management of the college would promise the.
No, who was in charge of the affairs on that day?
The in charge of the affair, my lords, was supervisor who is accused, who is, my lords, arraigned as accused number A. My lords, who had preferred a criminal petition before this honorable court. And my lords, in order, my lords, speaking through your lordships. This honorable court, my lords, has ordered stay of further proceedings.
Tag this petition, so and so. List them both on 26th. On notice agila.
Notice, it is coming up for the first time, my lords.
Office objections.
My lords, the council submission is given, my lords, the application of discharge was also challenged, the order of discharge was also challenged.
No.
The office objection is the public prosecutor has not filed objections. to
Accepting the submission of the counsel for the petitioner. Office objection stands overruled. List the matter on Monday in the fresh matters list.
Lordships may consider-
ಅಲ್ಲಿವರೆಗೆ ಏನಾಗಿದೆ?
The matter is coming up, my lords, for recording of evidence.
When?
On Monday.
All right, ಅದನ್ನ ಹಳೆ order ಇರ್ಲಿ, yes.
My lords, may I just make one submission? The previous order of stay, my lords, passed by this honorable court, is, my lords, on a submission that was made by the supervisor that he is taking steps, my lords, for payment of compensation. Insofar as the petitioner before your lordships is concerned, I am one of the companions, my lords, in the camp, my lords.
We'll see, it's before me only.
Very well, I'm great.
Yes.
14?
Serial number 14, I pay for the petitioner's counsel.
Report has been filed, my lord.
B report, I just wanted to bring that to your lordship's attention. I'm told B report is filed on 5/6/23.
B report. Yes.
Lordship.
You're in the office?
Yes.
Yes.
15? You are now.
Right.
In terms of.
15?
Hearing for petitioner. Section 19(1) of Seeds Act, my lord. One judgment is there, rendered by your lordship, my lord.
Accepting the
Playing the
submission of the counsel for the petitioner. Office objections stands overruled. List the matter on Monday in the fresh matters list today. File hakire. Next.
15?
Post immediately after service of notice upon the respondent. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಇಂಟಿಮೇಟ್ ಇಲ್ಲ ಸರ್ DC Parameshwara informed me that he is going to file a wakalat for the respondent.
ಯಾರ ಹೆಸರೇನು?
DC Parameshwara.
So and so.
Any date may be fixed.
List the matter on 24 ಅಲ್ಲ ಇದು? List the matter on 18th September. Next.
Please.
For 18?
Needful has been done, my lord.
Lieutenant counsel submit needful has been done office to verify. Enter ಮಾಡಿದ್ಯಾ?
Intermodal, ಇಲ್ಲ sir. Date may be fixed, my lord.
Office to verify. Notice ಆಗಿದೆಯಲ್ವಾ?
Notice ಆಗಿದೆ. Date
Post
may be-
immediately after service of notice. First needful ಮಾಡಿ.
My lord, it's
Service
done,
of
my lord.
notice
Have the
upon the
endorsement.
respondent.
Have the
ಇವತ್ತು.
endorsement. ಇವತ್ತು, my lord.
ಇವತ್ತು.
Please.
ಮಾಡಿ, yes.
Lord, I humbly request for a date, my lord.
Earlier notice ಆಗಿದೆ ಯಾವತ್ತು?
During the in the
Seven?
vacation.
7/5. Notice ತಗೊಂಡಿಲ್ಲ. ಇವತ್ತು ಕಟ್ಟಿದ್ದೀರಾ?
My lord.
And urgency. Let it come. Post immediately after service of notice upon the respondent. Next.
19?
For respondent number 2, my lord, we have filed an wakalat yesterday.
So and so. Madam. So and so. Admits that she has entered appearance for the respondent, registered to print the name of so and so. Therefore, service of notice is complete, lists the matter for 2 weeks. Intermodal, yeah? Yes. List the matter of 2 weeks. Next.
For petitioners, my lord.
Hmm.
My lord, ಪೋಕ್ಸೋಗಿದೆ settlement ಅಂತ ಹಾಕೊಂಡಿದ್ವಿ.
9th.
First case, my lord, there's a proclamation.
17 years. Why do you get the parties?
My lord, the matter is listed.
Have I told you?
My lord, we filed an IM, my lord, for stay, my lord. Consideration of that IM, my lord. Because in.
What is the age of the victim on the date of the incident?
17 years, 6 months, my lord. I produced the documents, my lord.
Yes. Hmm.
Lordship has taken all the matters on.
9/9 third.
Meantime, my lord.
We'll stay till now, till then. Our dismiss Manana. List on 9/9 along with all connected cases. In the meantime, there shall be an interim order of stay for the proceedings square the petitioner till the said date.
Serial number 21, investigations time.
21, same. Other line age,
Same cases.
same, all
Same
right,
cases.
yes.
Same parties.
Next.
Different victims, same accused. 19 and 20.
Ah.
2021, same accused, the different victim or same accused. Victim.
Same victim.
ಎರಡು ಯಾಕೆ ಮತ್ತೆ? Approach. Why 2 cases?
First case was registered, charge sheet has been filed.
Hmm.
Again, the victim girl went to the house of the petitioner, then father of the petitioner complaint has filed second FIR. Again,
Same,
same.
facts are same.
Same facts.
All right, yes.
ಮನೆಗೆ ಹೊಂಟೋದ್ರು ಅಂತ second FIR.
Aye. Next.
22.
22, yep, petitioner. 306 and 34 is my lord, the offense alleged. I am accused.
Office
number 2.
objections in.
I will comply it through the course of the day. Yesterday I went, my lord, but the list was closed, so I could.
List on Monday in the fresh matters list.
He's in custody, my lord. He's been arrested after a span of 2.5 months from the time the FIR was registered. My lord, may I kindly produce
Seek bail.
Hakide, my lord, 10 days it's been, it's been 10 days since I've applied for bail. I'm not with.
Bail ಸಿಕ್ಕಿದೆಯಾ?
Illa, I have not yet obtained. Case number 19 is the complaint, my lord. I am a 19-year-old student. And the allegation is, my lord, that I had an affair with the wife of.
17 years.
19, that's the office objection. Adin unrectified.
ಮಾಡಿ.
Please,
Monday ತಗೊಂತೀನಿ ಮಾಡಿ. Yes.
very good.
List on Monday in the fresh matters list. Comply with it immediately. Yes, next. Yes, Ramchandra. Office objections ಏನು?
ಅದೇನಿಲ್ಲ ಅವ್ರನ್ನ
Accepting the submission of the counsel for the petitioner, office objection stands overruled. List the matter on Monday in the fresh matters list. ಅಲ್ಲಿವರೆಗೆ ಇರುತ್ತಾ? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಅರ್ಜೆನ್ಸಿ ಇದೆ
ಹಾ, ಹೇಳಿ.
ಇವತ್ತು ಅದು ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಆಗೋಗಿದೆ.
ಯಾವತ್ತಿದೆ?
ಇವತ್ತಿಗೆ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಏನ್ ಹೇಳಿ?
ಅದು ರಿಲೀಸಿಂಗ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾವು ಐ ಆಮ್ ದಿ ಬ್ಯಾಂಕರ್ ಮ್ಯಾಡ್.
Releasing of property ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಇವತ್ತು ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ದಿ ಕಾಂಪ್ರಮೈಸ್ ದಿ ಕೇಸಸ್ ಇವರನ್ನ ಸಿನ್ಸ್ ಅಲ್ಲಿ ಅಫೆನ್ಸ್ ಇಸ್ 420. ಸೊ ಬ್ಯಾಂಕ್ ನಾನು ಐ ಆಮ್ ದ ಸೆಕ್ಯೂರ್ಡ್ ಕ್ರೆಡಿಟರ್. ಸೊ ಅಕ್ಯೂಸ್ ನಂಬರ್ ದಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಮ್ಲಾಡ್ he had pled the gold. And after 6 months, the case has been registered by the respondent number 2, alleging that certain cheating have been done by the so and so. So based on that, my lord.
What stay can I grant now?
ಈಗ ಏನಾಗಿದೆ ಅಂತ ಈಗ ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಒಡವೆ ಅವರಿಗೆ
I may stay the investigation as you have sought. What else?
ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
What proceeding?
ಈಗ ಅಲ್ಲಿ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ
PC
ಏನಾಗಿದೆ?
365 of 2023, I may stay. What accused are you?
ಐ ಆಮ್ ಎ ಬ್ಯಾಂಕರ್ my lord.
You are any accused?
I am not an accused.
No.
ಅಲ್ಲ your lordship kindly see
You
that.
file application under 451, 457.
No, lad, 451, 451, that is the complaint have been
You
filed.
are not an accused. How have you maintained
Your
dispute?
lordship kindly see that. Accused is also filed an application, his application has been dismissed.
You contest it there. You have sought stay of all further proceedings before the court in which you are not an accused at all.
Your lordship kindly see that, since I am not made as a party in that proceedings, my lord, I am.
Alle, you implead yourself there and get an order from
No,
them.
lord, that has been already passed, my lord. Now the
Passed?
magistrate. No. The 451, 457 order has been passed.
ಯಾರ ಮೇಲೆ?
Complainant ಗೆ ಪರವಾಗಿ ಕೊಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್ ಇದು?
ಅಲ್ಲ ನಾವು Manipal Housing Syndicate Finance.
But you are not a party there, sir.
I am just a witness in that case. The properties have been recorded. Kindly, facts of the case is that, my lord, I am a banker, my lord,
ಇದು GML ಹಾಕ್ಬೇಕು, not in 482. You are not an accused in anything.
I am not an accused, my lord. My lord, I am.
Nor you are challenging an application and filed under 451, 457.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. The order has been challenged in this case.
Which order?
Order 6/10/2022 ನಲ್ಲಿ ಮಾಡಿರುವಂತದ್ದು. Annexure D.
6/10/22.
Please, my lord.
It's 2 years old again.
ಏನಾಗಿದೆ?
What has happened? We
No,
don't
no, no.
know.
During investigations, the police have been promised
Just
that
look into
investigation
it, what
ಆದ್ಮೇಲೆ-
stage it is.
ಅಲ್ಲ ಸ್ಟೇಜ್ ಇದೆ ಸರ್. I am producing the copy.
No, no, no.
No, ಅಲ್ಲ.
2 years ಆಗಿದೆ, yes.
ಅಲ್ಲ ಅದು 2 years ಅಲ್ಲ. ಇವತ್ತು
You
ಏನಾಗಿದೆ?
are not a party. I will not grant any order to a not to who is not an accused. GML ಹಾಕೊಂಡು ನೀವು ತಗೋಬೇಕು, 482 ಬರಲ್ಲ. Yes. 451, 457 ಆರ್ಡರ್ ಆಗಿ 2 ವರ್ಷ ಆಗಿದೆ. They would have delivered everything by now.
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಅದು ಡ್ಯೂರಿಂಗ್ ಸೀಸಿಂಗ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಲ್ಯಾಡ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಇಶ್ಯೂಡ್ ಎನಿ ನೋಟಿಸ್ ಅಟ್ಲಿ ಅರ್ಲಿಯರ್. ದಿ ಕೇಸ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಟ್ಸ್ ನಾಟ್ ಎ ಚೀಟಿಂಗ್ ಕಮ್ಸ್ ನಾಟ್ ಅಂಡರ್ ದಿ 102 CRPC.
Just look into it and tell me.
ಅಲ್ಲ ಇವತ್ತಿಗೆ
Saturday. Yes, list on Saturday in the fresh matters.
ಅಲ್ಲಿ
Yes.
you will kindly see that today it is posted for
No,
the
sir, I will not grant any order.
ಅಲ್ಲ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಅದು ಅವ್ರಿಗೆ
ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. That's all right. You can't come here. You are not even a party anywhere. Come to this court and take an order against persons who are accused or compromising the issue.
So I'm the banker, my lord. My interest has to be
You
safeguarded.
should have implemented there, sir.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಿದೆ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ
Sir,
ಅಪ್ಲಿಕೇಶನ್.
did you file an application before the court?
Earlier I'm not filed, madam. Assuming
Only
that, my lord,
Before the
investigation
before, sir, before the magistrate, have you filed any application?
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಏನಾರು ಆಗಿರ್ಲಿ, ನಾನು ಕೇಳಿದ ಕ್ವಶನ್ಗೆ ಆನ್ಸರ್ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಹೌದಾ ಇಲ್ವಾ?
ಅಲ್ಲ ಆ ರಿವಿಷನ್ ಅಲ್ಲೂ ಕೂಡ ಅದನ್ನ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲಿಲ್ಲ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ನಾನು ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್.
Sir, did you file an application before the magistrate that it belongs to you, it should be with you, you are the secured creditor ಅಂತ ಹಾಕಿದ್ದೀರಾ ಏನಾರು?
ಏನಾಗಿದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ವರ್ಗು
No,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
not
ಆದ್ಮೇಲೆ
at
ರಿಟರ್ನ್
all.
ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ದೇ ಆರ್ ಗಿವನ್ ಎ ಫಾಲ್ಸ್ ಪ್ರಾಮಿಸ್.
No, no, sir.
That's why we are waiting there.
Nothing, nothing. You are not a party. Saturday, ನೋಡಿ.
Please.
Next,
24.
clarification. Oh, ಇದು CA. Yes, sir.
I request for a pass.
ಪಾಸ್ ಓವರ್. ಇವತ್ತು ಯಾವ ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ಹೇಳಿ.
My contention is that the prayers.
ಒಂದು ನಿಮಿಷ, ನೀವೇನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಏನು?
Clarification, my lord, your lordship allowed the writ petition, directed them.
ಇದು ಚಾಲೆಂಜ್ ಆಗಿಲ್ಲ, ಫೈನಲ್ ಆಗಿದೆ ಇದು.
But in fact, in compliance with the order, I have
They have
given them
issued membership from
Ah.
10 to 23, instead of 10 to 23, my lord, they have issued membership from 21/12/23.
10 to 23?
From 21/12/23, my lord. The Supreme Court, my lord, allowed the writ petition on 7/12/23. I have submitted the application for issuance of membership. They have issued.
You
the
are
membership
entitled to from what date?
From 10 to 2023 ಇಂದ ಕೊಡ್ಬೇಕು ಅವ್ರು membership. Instead of that, my lord,
retrospective membership ಕೇಳ್ತಿದ್ದಾರೆ. In compliance with the order of this honorable court, within 2 weeks.
I have
they
held
give
your
them-
action to be wholly illegal.
Yes,
So it dates back to the date on which he was entitled for membership.
my lord, but the prayer and the writ petition was not that, and they depend on a new cause of action, an email dated 8/1/2024.
No, no, sir. 1 minute. What was the prayer in the writ petition?
prayer
Wash-
writ petition to
Wash
quash.
1/5/2023. What was 1/5/2020? ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ? Yes, sir, you can't do that. Respondent,
Page 63. ಲಿದೆ.
no, you can't do that. Once it is set aside, the right flows.
But in the guise of seeking clarification, they're seeking some additional prayers is my contention. Because admittedly, there is no error that is there in the order.
1 minute. Enrolling her
I also.
as a
find-
member bearing in mind the observations made in the course of the order.
Yes,
You have given it.
Paragraph
Now
30.
why are you fighting, giving it in accordance with law? Cost impose ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ. May I request your lordships to kindly see my statement of objection.
ಇದಕ್ಕೂ ಹಾಕಿದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್ಗೆ? Then cost definite. Yes, sir. ಅಷ್ಟೇ ಅಲ್ಲ?
Adral one, I have mentioned some form numbers.
Saturday, in the fresh matters list, yes. The fresh matter ಅಲ್ಲ, in the same stage, clarification, yes. ನೀವು ಅಷ್ಟರಲ್ಲಿ ಪೇಜಸ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ಎಲ್ಲೆಲ್ಲಿದೆ ಅಂತ. 2 ದಿನ ಸಾಕಲ್ಲ? ಎಸ್.
Question 25.
Chips matter putting to NDPS Act related to gunpoint search and seizure of certain small quantity of
Ganja?
Ganja. There's a point involved regarding section 50 of the NDPS Act. Couple of connected matters stays already there. In my matter, there's no stay on chips.
Section 50.
Section 50 violation, gazetted officer who was also part of the raid party. And he himself does the search and seizure.
2022 in the stay ಇಲ್ವಾ?
ಇಲ್ಲ stay ಇಲ್ಲ. It was
ಈ-
connected subsequently. ಆದ್ರೆ 25 serial number 25 stay ಇದೆ.
ಅದೇ ಒಂದರಲ್ಲಿದೆ ಇಲ್ಲಿ.
ಒಂದ್ರಲ್ಲಿ ಇದೆ ನಮ್ಮಲ್ಲಿ ಸರ್. The trial court is insisting, threatening to frame charges.
Threatening.
Coercive steps have been directed, that's why.
Section 50.
Section 50 covered, yes. ಅದೊಂದು ಯಾವ್ದು ಇತ್ತಲ್ಲ, ಯಾವತ್ತು ಹಾಕಿದೀವಿ?
There's a Vijay Sinha judgment 2007
Yes, sir, that is
constitutional bench.
ಲಿಸ್ಟ್ ಆನ್ ಅದು ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ಮೇಡಮ್? ಇಬ್ಬರದ್ದು ಇತ್ತಲ್ಲ, ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಒಂದು ಮಾಡಿದ್ರು, ಯಾರು?
31st.
2 ಮ್ಯಾಟರ್.
31st.
ಐ ಥಿಂಕ್ 31st
31st.
ಇದ್ರೆ ಅವತ್ತೇ ಬರ್ಲಿ. Interim order, in the light of the interim order subsisting in. Oh, this is that policeman,
That is one.
which I granted an interim order in 22.
ಹೌದು ಅದು 25 ಅಲ್ಲಿ 25
Television ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು then ಹೋಗಿ, that's the.
correct.
Ah,
Which is my case is different facts. ಆದ್ರೆ
Right, anyway, that was
section
the
50
case.
is involved. My case is also similar point of.
Yes, yes.
Lordship's interim order in 25.1.
In the light of the interim order subsisting in 25, there shall be an interim order of stay in 25.1 as well, till the next date of hearing, 31st.
Lordship, serial numbers are mentioned, the trial court may not be
ಇನ್ನೇನ್
interpreting the right manner.
ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು? In the light of ಅಂದ್ರೆ interim order ಇದೆ. What is this?
Gratefully.
I cannot write orders to the satisfaction of the trial court.
Gratefully.
It's your duty to satisfy the trial court.
I'll do my best.
Yes.
26.
The petitioner, one is the husband and 2, 3 are the parents of the petitioner and 4 is the uncle of the petitioner, my lord.
3 ಎಲ್ಲಿದ್ದಾರೆ?
Please, madam. 3 is abated, madam.
ಮತ್ತೆ 2, 3 ಅಂದ್ರೆ?
2 and 4.
2 and 4.
4, madam. On the
498.
498, madam. On the earlier occasion, notice was issued to the complainant, madam. Lordship had directed that will be considered on the appearance of the parties.
Not my orders. Not my.
No.
Yes, madam. Charge sheet ಆಗಿಲ್ವಾ?
Charge sheet ಆಗಿದೆ.
ಯಾಕೆ ಇನ್ನೂ ಮಾಡಿಲ್ಲ?
ಆಗಿದೆ ಮೇಡಮ್.
ಆಗಿದೆಯಾ?
Charge sheet has been, allegations have been,
CC.
CC number 175 of 22 Manoj.
Yes, sir. Next.
Please.
Challenge.
Please.
Interim order ಇಲ್ಲಲ್ಲ ಹೆಂಗು?
27.
Okay, for petition this. Now, the offense section 406, 409 and 420 mil. Now, the allegation against the accused number 2.
ನಿಮ್ದು ಯಾವ್ದು sir? ಶ್ರೀಧರ?
Yes, madam. Now, the accused number 1, the petition number 1 is being FDA. The petition number 2 is a ARO, Assistant Revenue Officer. The petition number 3 is a Assistant Executive Engineer. Now, based on the representation given by one Ramesh, the GP out of 70 Sola, they verified, then the original record is not traced. Then this petitioner ordered to put up the original record by collecting all the document. That is only allegation. Now, I have produced the document in page annexer email 129. There is official memorandum. When the original document has been lapsed and destroyed.
Who is the complainant?
Complaint is a commissioner.
Second respondent.
Housing board.
Housing board.
Why against them?
No,
Wait.
Malad on one side, Malad 63. As allotted to on 23/7/77, 23/7/77. Site number 63 in Yelahanka. One Charanjit Sola. subsequently 23/3/2015 sale deed executed. 6/3/2015 another sale deed executed by the one the Sola is executed sale deed M Mahadev Murthy. Again the 28/4/2015 A1 appeared for sale deed for to the exhibit housing board. But again 14/8/2015 second time sale deed again one P Ramesh Pai. Concluding with accused 2/12/22 the complaint is filed one side two persons sale deed executed by the accused one. Present prisoner.
ಈಗ one side ಎರಡು ಸೇಲ್ ಡೀಡ್
one side 63 ಎರಡು ಸೇಲ್ ಡೀಡು. ಅದ್ರ ಮೇಲೆ next see 21/12/2015 they filed complaint before the police. ಅದು CC 2 of 2016 registered and charge sheet is filed on 22/2019. ಈ enquiry trial requires trial ಮಾಡೋದಕ್ಕೆ therefore the CRP the criminal petition will dismiss with direction to trial court to consider all the evidence and
ಹೇಳಿ ಅವ್ರದ್ದಾಯ್ತು.
Now, the very same set of two parallel proceedings has been initiated.
ಏನ್ parallel proceeding?
The one complaint has been lodged by the Madhav Murthy. That has been.
Who is Madhav Murthy?
Is the subsequent purchaser.
All right.
Subsequent purchaser. Has lodged the complaint, the private complaint. That matter has to be referred to the investigation. The investigation filed the charge sheet against the accused number 1 and the person who created the GPML. The same is pending for adjudication. Now this official complaint lodged by officially complaint lodged. The only allegation is that kindly peruse the complaint. There is no averments against the petition number 2 to 4 million, 1 to 3 million. That's one. Even sanction also. There is no detailed explanation in the sanction. Page number 101 million.
No, is it a fact that accused number 1 has executed sale deeds of a particular property twice over?
Yes, very same parties, my lord. Very same party.
Very same party.
Very same parties, my lord. Earlier.
ಯಾರು accused number 1 ಯಾರು ನೀವಾ? ಈ ಕಡೆ ಬನ್ನಿ ಮೈಕ್.
It has been misrepresented to the court, my lord. Now, this site was allotted in the year 1977
To whom?
to Charanjit Sola.
All right.
Now, in 1995, there was a sale deed that was executed to Charanjit Sola. That is correct. Now, Charanjit Sola executed another sale deed in 1995 only to said Madhav Murthy. Now, what happens, my lord? I was transferred to Yelahanka branch in 2012. Now, before 2012, in the year 2000, between the year 2000-2002, many files were misplaced. Now, there is an official memorandum
To that effect?
to that effect.
All right.
And how, page 41 of
So
my petition, my
because
lord.
the files were missing, you executed another sale deed in favor of the Madhevappa or whatever?
Yeah, not, no, not because the sale deed was missing, my lord, because there were no records of this site number 63. There was an official memorandum which said,
Any endorsement that first time sale deed was executed in your records?
no, my lords, I have produced the proceedings at annexure.
Which that record that captures the sale deed executed?
No, my lord, I have produced annexure HLE. I have produced the details proceedings of site number 63. Considering the fact that even these documents were
Idrinda
missing,
what have you gained?
I have not gained anything. I have not gained anything. Even provisions of 409 and 420 are not, ingredients of these aspects are not fulfilled or forthcoming in the complaint.
Yes. Yes, sir. They are your officers.
Yes.
But officers, that is true, madam, but they are not the government servants. They are not, the housing board is
Board
employee.
servants ತಾನೆ ಅವರು?
ಇಲ್ಲ, government servant ಅಲ್ಲ.
ಅಲ್ಲ, board servants.
Board servant, board servant, board servant.
ಆಮೇಲೆ they are your officers. Why against
ಅಲ್ಲ,
them? If they have not, if there is nothing has happened due to that act, or if what the council says is because to the same party that executed sale deed. What has become of that? ನಿಮಗೆ ಲಾಸ್ ಆಗಿದೆಯಾ?
ನಮಗೆ ಲಾಸ್ ಇಲ್ಲ.
ಹ್ಮ್.
ಈಗ ಅಲ್ಲಿ
ಬೇರೆ ಯಾರ್ಗಾರ loss ಆಗಿದ್ಯಾ?
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರ ಹೌಸಿಂಗ್ ಕಮಿಷನರ್ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕಾಯ್ತು. 10(5) ಆಫ್ ದಿ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಆಕ್ಟ್ ಮಾಡೋದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್, ಚೀಫ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಬೋರ್ಡ್. ಅವ್ರ ಪರ್ಮಿಷನ್ ತಗೊಳ್ಳದೇನೆ ಇವರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಷ್ಟೇ, ಪರ್ಮಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಅಷ್ಟೇನಾ?
ಪರ್ಮಿಷನ್
ಇಲ್ಲ.
ತಗೊಂಡಿಲ್ಲ.
ಈಗಾಗಲೇ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನಿಮಿಷ.
ಇಲ್ಲ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅವಾಗ ಆ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಸೇಲ್ ಮಾಡೋ
ಅಲ್ಲ, is that the only allegation that permission is not taken?
ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಇದು ಮಾಡಿದಾರೆ, ತಪ್ಪು ಮಾಡಿದಾರೆ, ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು. ಹೌಸಿಂಗ್
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ.
ಅದು ಆಗಿದೆ ಸ್ವಾಮಿ. My
ಅದ್ರಲ್ಲಿ
increment
ಏನಾಗಿದೆ?
was also, my increment was deducted because of this mistake.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
ಅದು ಈಗೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ
ಅದಕ್ಕೆ 482 will not vanish.
ಅಲ್ಲ ದಿ
Yes.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಕೊಡಿ, ಕೊಡಿ. Give it, sir.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
Evidence ಇನ್ನೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಸ್ಟೇ ಇದೆ ಇಲ್ಲಿ. ಸ್ಟೇ ಇದೆ, ಹೆಂಗ? 2 years in the stay ಇದೆ, ಕೊಡಿ. Matter to be stayed also. ಆಮೇಲೆ
ಹೆಡ್ ನೋಟ್ ಇದೊಂದೇ ಇದ್ರಲ್ಲಿ ಹೆಡ್ ನೋಟ್ ಬಿ ದಲ್ಲಿ
ಹೆಡ್ ನೋಟ್ ಬೇಡ, ಪ್ಯಾರಾ ಓದಿ. ಹೆಡ್ ನೋಟ್ ಇಸ್ ನಾಟ್
ಪ್ಯಾರಾ 32 ಮಾಡಿ 32.
ಹಾ. ಫೋರ್ ಏಯ್ಟಿ ಇಂಟರ್ಫಿಯರ್ ಆಗಬಾರ್ದು.
ಹೌದು, ಇಂಟರ್ಫಿಯರ್ ಆಗಬಾರ್ದು ಅಂತ. ಅಂದ್ರೆ ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆಗಿ ಎಲ್ಲ ಆಗಿದೆ. ಟ್ರಯಲ್ ಒಂದು ಇದರಲ್ಲಿ ಏನಾಗಿತ್ತು, ಇದರಲ್ಲಿ 482 ಕ್ವಾಶ್ ಆಗಿತ್ತು. ಇದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋದ್ರು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಅದು ಸೆಟಿಸೈಡ್ ಮಾಡಿ ಕ್ವಾಶಿಂಗ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಈಸ್ ಇಂಪ್ರಾಪರ್ ಅಂತ ಹೇಳಿ
ಹೌದು, ಕರೆಕ್ಟ್.
32 and 33 ಪ್ಯಾರಾ.
Because ingredients of 406 and 420 were met in that case. ಇಲ್ಲಿ they are not met. 409, 420 ಬರೋದೇ.
494
ಏನಾರು ಆಗಿದ್ರೆ ಹೇಳಿ. Unjust enrichment ಏನಾಗಿಲ್ಲ. They are officers, sir. If some bona fide mistake has happened and they are punished departmentally for that, what criminal case? If they have looted something out of this, tell me.
ಇದ್ರ ಮೇಲೆ ಏನಾದೇನು
what is this, sir?
ಏನು ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ.
ಅದನ್ನ ಮಾಡಬಾರ್ದು. ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಇನ್ಕ್ರಿಮೆಂಟ್ ಕಟ್ ಮಾಡಿದ್ದೀರ ತಾನೆ? ಮತ್ತೆ ಸಾಕು ಬಿಡಿ. Yes, we'll try to dictate on some other day. List the matter on 13th September. Interim order subsisting shall continue till the disposal of the petition. Yes, next.
28.
Lordship, this is a petition by one of the police officers wherein he is only the brother-in-law of the complainant's husband. Lordship, the petitioner here in your lordship, his wife's brother is in a family dispute with the complainant. And the complainant aggrieved by the fact that her husband filed a divorce petition. The very next day proceedings start. Because earlier they were-
Accused 1 yaru, madam, 2 yaru.
your lordship, both the 2 is the sister of the husband of the complainant. That is the sister-in-law. And accused one is the husband, that is he's a constable, your lordship. And in view of the fact that she was not able to get the husband to come around to a settlement, now the idea is to go after him specifically. Your lordship may kindly see, she filed, the MC filed at page 128, your lordship.
Yes.
Page 128, your lordship. Kindly see.
One
128.
MC petition.
Please, in this, she's the complainant is the respondent.
All right.
Your lordship, in this, he
In relation, what are you to the husband?
to the husband, the accused number 1 is the brother-in-law and accused number 2 is the sister.
The allegation appears to be 354.
Please,
That's at page 52.
please,
On the brother-in-law.
on the brother-in-law, all the dates on which he has been in duty, all the details of which has been
ಮೈ
extracted.
ಕೈ
between-
ಮುಟ್ಟಿ ಎಳೆದಾಡಿ ಮಹಿಳೆ ಆಕೆ ಅಂತ all that is there.
Please, your lordship, and for that exact time he's been in duty, your lordship may kindly see page 102, 108 and 109.
What about the second one?
Please, Your Lordship,
Interim order ಇಲ್ವಾ?
interim order,
ಇದೆಯಾ?
please. For two, Your Lordship had granted, for one, Your
That's
Lordship
what.
had.
Two have granted.
Please.
Hmm.
But in this matter, exactly page 128 and 129, if Your Lordship may kindly see.
Hmm.
At page 131, they specifically even mentioned details.
Oh, this is that policeman.
Policeman.
Ah,
And now the man, they have proceeded on suspension as against him. They've even passed orders, everything at a pace that he is unable to match. And the idea is that if he loses his job, maybe the brother-in-law will come around
For settlement.
for settlement. And here the accused have been pleading with him, please just get back with her, at least then these cases would be withdrawn. He's flatly
Oh, this
refusing.
is the departmental inquiry order. Oh, you've been dismissed.
Please, Your Lordship, for absolutely no fault.
No, after inquiry.
Your Lordship,
After inquiry.
inquiry, the inquiry, Your Lordship may kindly see the details.
The service jurisdiction. Yes.
Even, let alone a speaking order, it has absolutely nothing in it, Your Lordship. They extract what the allegations are and pass an order.
ಶಿಸ್ತು ಪ್ರದರ್ಶಿಸಿ.
No, these dates which the senior counsel mentions, my lord, is only about that one particular day where inspector supposed to have sent them back to the house. It is not that all the dates.
I think I've heard it at length where the policeman was involved in,
Supposedly involved. Your Lordship,
allegedly involved in.
Your Lordship, at page 129 is on 25th. Lordship, the previous page might be kindly see. Page
120?
120. Your Lordship, I had taken Your Lordship towards the, to the petition, MC petition. That is filed on the 25th.
There is no allegation.
The
Filed by
allegation
them.
is as against the wife, wherein he says, I went to her house and took her back. But the very next day, the brother files a case against him. Your Lordship may turn back to page 124.
Two, yes, there's no problem. But this policeman difficult.
Might I then request Your Lordship, as against two, if it's quashed, against one,
I will
a
definitely.
a time-based trial, reason being, if he's jobless, Your Lordship.
I
for
know,
the
that I
dispute of
understand.
this, Please.
We'll fix a time for the trial.
Please.
Otherwise, these are a plea of
I
alibi.
understand.
You have to take it before the consent
Please.
court. I cannot say you are somewhere else.
Please stand free.
354 it may be.
354 second petitioner ಮೇಲೆ ಏನ್ ಮಾಡ್ತೀರಾ ಸರ್? She herself is a lady.
323.
ಏನ್ 323 ಏನಿಲ್ಲ.
In fact, produce with a.
Not against the second petitioner.
With a memo, I have
Investigation
produced
ಮೇಲೆ-
details of all the cases. The complainant's father is a murder accused.
No,
And
I would have straight away accepted all the plea.
please,
But for very explicit finding in the charge sheet that you have indulged in.
Your Lordship, for that, not even once his phone has been seized. Your Lordship, what kind of evidence?
All those will be a matter of, illi I can't say
Matter
anything,
of trial,
because what I see in the charge sheet is quite explicit. That's the only thing. Otherwise, definitely case
There's
for
a
person.
history, Your Lordship. Already she has attempted 10 different cases as against the mother, the mother-in-law, everybody. Now I think the people behind it, that is the police station who have helped them so far and even helped them dismiss him, they have formulated it in such a good manner this time.
We'll see. I'll direct the court to.
It's 79, my lord. 164 statement. Last 3 lines.
Three 23. Parke,
Your Lordship.
broomstick.
His page 102, 108 and 109 clearly shows that he was at work, his work duty, his signatures, all of them are.
That is, I cannot here look
Please.
into it. Heard the petitioners accused, 1 and 2, no? Accused 1 and 2 in CC 28561 of 2021 are knocking at the doors of this court in the subject petition, calling in question the said proceeding, registered for offences punishable under section 323, 354, 506, read with 34 of the IPC. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner, the counsel for the respondent, and the learned additional SPP for the state. Facts in brief, Germain, are as follows. It is the case of the prosecution that a complaint comes to be registered by the second respondent complainant on, what is the date?
26/8/2021.
2021.
On 26/8/2021, alleging certain offenses, alleging certain alleging certain ingredients of the offenses that are alleged against these petitioners. The police is said to have conducted investigation and filed a charge sheet against against the petitioners accused 1 and 2. The filing of the charge sheet has driven these petitioners to this court in the subject petition. The learned senior counsel for the petitioner would contend that marriage between second respondent and the brother of petitioner number 1, which took place on 29/5/2020, floundered. On the floundering of the relationship, the brother of the first petitioner and the complainant are in dispute before various fora. The learned senior counsel would seek to contend that the present complaint has emerged immediately after the brother of the petitioner filing MC 4261 of 2021 against the complainant seeking annulment of marriage. She would contend that it is a counterblast to what the brother of the petitioner has initiated against the husband. The learned senior counsel would further contend that on the alleged date of the incident, which is on 26/8/2021, the first petitioner was on duty as he was then working as a police constable, is it? As a police constable. In the light of the fact that him being on duty, he could not be present at the scene of crime, and the allegations of Section 354 of the IPC are all imaginary, and it is only to wreak vengeance against these petitioners or bring about a settlement between the husband, the present proceedings are initiated. She would seek quashment of the entire proceedings. Per contra, the learned counsel appearing for the second respondent would refute the submissions contending that the first petitioner was in fact present in the scene of crime. If he is claiming a plea of alibi, it is for him to prove on the basis of evidence before the concerned court and not in a petition under Section 482 of the CRPC. He would further contend that the second petitioner also was present in the scene of crime, though 354 would not get attracted against the second petitioner. The other offenses, i.e. Section 323 and 506, would undoubtedly get attracted. He would seek quashment, he would seek dismissal of the petition. The learned additional SPP would toe the lines of the learned counsel appearing for the second respondent in seeking dismissal of the petition. I have given my source. The aforenarrated facts are not in dispute. The relationship between the petitioners and the complainant are that the first petitioner is the brother-in-law of the complainant and the second petitioner his wife. The marriage between the brother of the first petitioner appears to have floundered, and on the floundering of the relationship, the brother of the petitioner has instituted certain proceedings seeking annulment of marriage. And the wife of the the brother of the petitioner has instituted certain proceedings against the husband. Those are facts which are not, which need not be noticed in the case at hand. A complaint comes to be registered on 26/8/2021 on against these accused. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Page 49, 49-50. The complaint narrates certain instances of ingredients that would become an offense under Section 354 of the IPC, prima facie, against the first petitioner. Against the second petitioner, what is alleged is when the complainant returned back home, she was assaulted by a broomstick. Barring this, there is no allegation against the second petitioner, while there are allegations against the first petitioner. The police, after investigation, have filed a charge sheet. Column number 7 of the charge sheet, hyphen the summary, would read as follows. Page 52, 53. ಎರಡು ಕಡೆ ಬರುತ್ತೆ, ಎರಡು marking. A perusal at the summary of the charge sheet also would indicate that the allegations that would become the ingredients of the offense under section 354 is against the first petitioner, who is first petitioner, and not against the second petitioner. Insofar as the other allegations, i.e. of section 320 of the offense punishable under section 323 and 506 of the IPC, they do not meet what is needed as ingredients of those offenses qua the second petitioner. Therefore, finding no allegation that would touch upon any of the ingredients of those offenses alleged against the second petitioner, permitting further proceeding against the second petitioner would undoubtedly become an abuse of the process of the law and result in miscarriage of justice. In that light, I deem it appropriate to obliterate the proceedings against the second petitioner. Insofar as the first petitioner is concerned, the submission of the learned senior counsel is that on the date of the alleged incident, i.e. on 26/8/2021, the first petitioner was on duty and seeks to place reliance upon several documents which would prima facie demonstrate that the first petitioner was on duty. Therefore, the plea of alibi is projected by the learned senior counsel before this court. It is settled principle of law. Plea of alibi is always a matter of evidence and cannot be accepted to quash the proceedings in exercise of jurisdiction under section 482 of the CRPC. The submission of the CRPC, therefore, all the grounds that are projected qua the first petitioner in the case at hand are necessarily to be projected before the concerned court at the relevant point, at the appropriate time, at appropriate stage, and at the appropriate stage. The learned senior counsel would further submit that the first petitioner has lost his employment, all because of the present crime that is registered. He has been dismissed from service on account of him being charge cheated in the subject crime. In
He's not in
subject
subject.
CC28, ಅದೇ ಇದೆ ಇಲ್ಲಿ. ಎನ್ಕ್ವೈರಿ ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, he's been dismissed because of the other
Inquiry was.
case against him.
ಬೇರೆ ಇತ್ತಾ?
CC 255618/21.
ಅದ್ಯಾವುದು?
That is filed against him.
ಇನ್ನೊಂದಿದೆಯಾ?
Yes, has been.
He has been dismissed from service ಅಂತ ಮಾಡಿ sir. The reason for dismissal inter alia is the present proceeding, that is present proceeding. In that light, I deem it appropriate to direct the concerned court to endeavor conclusion of the trial in as expeditiously as possible, at any rate 9 months, 6 months,
6 months.
6 months
3 months.
from the date of receipt of the copy of the order.
Your Lordship, this is the only case against. There's absolutely nothing.
ಇಲ್ಲೇನೋ
else, Your
ರೆಫರ್
Lordship.
ಮಾಡಿದ್ದಾರೆ ಬೇರೆ
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
ಆರ್ಡರ್ ಇದೆಯಲ್ಲ?
It's the same. Enquiry is also conducted in this only. There is nothing.
For the
else.
same offense.
255618 of 21 CC.
Either the CC.
That's a difference there. Two CCs and mentioned.
They have mentioned.
Page
All
1
right,
and
anyway.
Incorrectly mentioned, Your Lord.
I have not recorded that anyway, yes.
Your Lordship, just one correction. Your Lordship, in one place where it says the brother of the petitioner, that would be the second petitioner's brother. And in the other one, Your Lordship, wherein the petitioner is the brother-in-law, Your Lordship, actually the second petitioner would be the sister-in-law of the complainant, because it is her brother who is the husband.
All right, ಸ್ವಲ್ಪ ಇನ್ನು
It's a little
ಬೋಲ್ಡ್
complicated.
ಮಾಡ್ತಿರಲ್ಲ ಮಾಡಿ.
So husband of the sister-in-law, Your Lordship.
We'll see, I'll correct that, yes. ಅದಕ್ಕೆ ಅದು ನೋಡಿ ಸ್ವಲ್ಪ ರಿಲೇಷನ್.
29.
Yes, Manmohan.
Lords, offense under 500, despite the interim order, not publication was taken out. Lord said, ask me to file dates and events, and Lord should dictate the order. Lord, the only ground on which not the cognizance is taken,
ಇಂಟ್ರಿ ಆರ್ಡರ್
the
ಕೊಟ್ಟಿದ್ದೀನಿ.
interim order, nane complainant to, there was an interim order granted by the trial court not to publish.
They proceeded with further publication defaming not the.
ನೀವೇ
petition.
ಕಂಪ್ಲೇನೆಂಟ್.
ಹೌದು, ನಾನೇ
Why
complaint.
are you before the court?
Not the learned magistrate not refuses to issue summons and dismisses the complaint. On the ground not that there is no intention. Page
How
one
can you decide
77.
about intention? Page?
Page 177, not. Para 10.
When is the respondent served?
Respondent served not, I think,
Madam,
made.
ಸರ್ವಿಸ್ ಯಾವಾಗ ಆಗಿದೆ ನೋಡಿ?
57,920.
Long ago. Then let restore.
Yes.
We'll see. Well, time permits will dictate.
Great.
Pass over.
30.
CH moved.
Your Honor, second respondent, why 498 case has been initiated by the second respondent. There is a pending of stay in this case, Your Honor.
Stay ಇದೆಯಾ?
There is application pending for stay, Your Honor.
ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಈಗ?
No, Your Honor, this respondent number 4 and 5 are the doctors who are the resident of Mumbai, Your Honor. All the way they will have to come to Tumkur every time for the hearing, Your Honor. That is why except I will not press for petitioner number 1 who is a husband in this case, Your Honor.
1 minute, sir. 1 moment.
Please, Your Honor.
Page number.
49. 4 and 5 ಮೇಲೆ ಅಂತ ಏನೂ ಇಲ್ಲ. ಮುಂಬೈ ಟು ತುಮಕೂರು.
General allegations.
ಆಮೇಲೆ 2 and 3.
2 and 3 are, Your Honor, parents.
Correct. ಅವ್ರ ಮೇಲೆ ಏನಿದೆ?
Only general allegations, Your Honor.
The demand for.
Because they are this.
Madam, except one, Kashkan.
Please, Your Honor.
Yes.
Highly obliged.
Next.
31.
Paper, petitioner, my lord. That is 323, 354, my lord. The complaint
appearing,
after
madam?
2 days after the alleged
Am I
incident.
kindly permitted to undertake to file wakalat in respect of R2 Millar?
Learned counsel, ನಿಮ್ಮ ಹೆಸರು madam?
Care Satish Millar.
So and so undertakes to enter appearance for the second respondent registry to print the name of so and so appearing for the second respondent. List on 21st September. Yes, next.
32.
Taken next week.
Move ಮಾಡಿದ್ಯಾಕೆ? Where is your file?
My junior was supposed to bring the file.
Where is your file?
Due to some
Take
emergency.
somebody's file and stand.
Due to.
File ಇಲ್ದೆ ನಿಂತ್ಕೋಬೇಡಿ. I will adjourn it by 10 weeks now.
Yes, I apologize.
ಹಾ.
Due to some emergency, my lord, he went to Kolar, my junior colleague.
All right. List the matter on next Friday ಹಾಕಿ.
Please.
Next Friday ಇಲ್ಲ. 13th ಹಾಕಿ. Yes. Next.
Appearing for the petitioner, my lords.
The
only allegation against me is that I did not exercise due diligence at the time of creation of the company.
The allegation is?
The only allegation against me in the complaint is that I did not exercise due diligence at the time of due diligence. And I have been charged, made an accused in a PMLA offense.
Next week, I called it. Objection is ready. Taking cognizance has been challenged, my lord.
Enforcement, why? PD ಯಾಕೆ?
419 is attracted. He has, my lord, incorporated 4 companies, bogus companies and registered, my lord.
All right, file your objections. Again, list on 13th. Objections if any.
I seek a grant of stay, my lords, because
Next
proceedings are
month
going
ಅಲ್ಲಿ
on.
ಇದೆ case.
ಯಾವತ್ next date ಯಾವತ್?
29/9
26/9.
26.
All right. 13th is before, 13th is before 26.
Please.
List on 13th. Next.
34.
34 ಅಲ್ಲ?
34.
I am for the petition, my lordship, in this case. Office objections ಇದಾಗಿದೆ, ಕಂಪ್ಲೈ ಆಗಿದೆ.
Comply ಆಗಿದೆಯಾ?
ಒಂದು ಆಧಾರ್ ಕಾರ್ಡ್ ಕೇಳಿದ್ರು ನಾನು ಹಾಕಿದ್ದೀನಿ. DC ಅವ್ರದ್ದು ಒಂದು ಏಜ್ ಒಂದು ಬರ್ದಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಕಂಪ್ಲೈ.
Office objection ತೋರಿಸಿದಾರ ಇಲ್ಲಿ?
4
Counsel with the petitioner submits office objections have been complied with office to verify. ಏನಿದು?
This is the case, my lordship, in this case.
Warrant CL-7 ನಾ?
ಅಮ್ಮಮ್ಮ.
Respondent ಯಾರು?
DC, Deputy Commissioner.
List on Monday in the fresh matters list.
Senior is on receiving. Yes.
Madam, Monday fresh matters list, yes. Next.
Oblige.
35.
Offense is under section 420. This petitioner arrived at accused number 3 to 5. The allegation is constitute only accused number 1.
There is no representation way of the petitioner. Court ಗೆ ಬರಲ್ಲ. ಎರಡು ಸರಿ no representation.
Yes, some other court, madam, that time.
Huh?
I held up in another court, madam. Sorry, madam.
Held up in other court.
Sorry, madam.
Monday, fresh matters. Yes.
36.
I represent for the petitioner, my lord.
For respondent number 2, my lord. I'm buying time for yes, filing objections.
ಯಾಕೆ? Objections ah?
So section 406, 420 and 506, my lord.
2 weeks. Counsel for the respondent seeks 2 weeks time to file statement of objections. List the matter after 2 weeks interim order subsisting shall continue to the next day of hearing. Yes.
37.
Number 2 in this case, my lord.
Petitioner Milord. Offense under section 306 Milord. And no material against me, Milord. I'm working as an employee in Bangalore, Milord.
Submit.
I'm working as an employee in Bangalore, Milord. Incident, date of incident also, I'm working as employee. I'll produce the documents also,
Sir,
Milord.
306 ಗೆ ನೀವು ಫೋನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಸಾಕು.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ
ಎಲ್ಲೋ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ಬೇಕಾಗಿ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ I'll read the complaint, Milord.
Yes, Ramesh.
I need some time to
For what?
take instruction from the respondent number 2, my lord.
You're out on bail ಅಲ್ಲ?
Yes, Milord. After
List the
Saturday, Milord. Documents before April, I'll move this petition.
List the
for
matter on
settlement. After that party's complaint is not coming, Milord.
list the matter on 11th in the fresh matters list.
Okay.
Yes. Settlement move ಮಾಡಿದಿರಾ?
April, I'll move this
Before that, it
settlement,
says,
Milord.
before earlier.
Earlier in April.
306 settlement merits ಅಲ್ಲ. Yes, next.
Your lordship, for the petitioners, your lordship, requesting short accommodation, your lordship.
30?
30.
Idar problem.
We're ready to argue the matter, my lords.
Interim order ಇದೆಯಾ?
Today, your lordship.
Yes, 11th.
Move the memo few
11th
times before, my lords.
11th as a last chance in post the matter in vacating stage illala. List the matter on 11th in the fresh matters list.
Much obliged.
Next.
39.
Appearing for petition.
Respondent.
ಇವತ್ತು ಆಗಲ್ಲ. ಏನ್ ಹೇಳಿ?
Swami.
Vacating stay ಇದೆ.
False and misleading
Saturday.
submission ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Saturday. ಶನಿವಾರ. List the matter on Saturday.
Possible on 5th, my lord.
No, Saturday, yes.
40.
Notice ಯಾರು ಮಾಡಿದ್ರೆ ಇದರಲ್ಲಿ?
Lord, I appear for first petitioner and petitioner number 3. Petitioner number 2 is a father. I am appearing for husband and mother of a husband. In this case, my lord, the petitioner, the respondent has filed the PCR on 15/9/23 in respect of a complaint that she has lodged against the petitioners on 12/9/23. Whereas
Alright.
before this complaint,
We'll continue if time permits. Yes. ಬೇರೆ ಯಾವ್ದು ಕರಿಬೇಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ? ಓ, ಅದರ hearing ಆಗ. ನೋಡು. ಸ್ವರದ್ ಬಿಡಿ.
46.
Offense.
56.
Offense.
323, 504.
ಸಾಕು.
Husband and wife, now.
Husband and wife atrocities act.
Now filed a
ಹೌದು.
joint mutual consent petition filed before the family court.
ಎಲ್ಲಿದೆ? Settlement.
Milord, we are filing memo, Milord, to, we have no objection to quash the process. Since the joint petition filed by the parties, it is.
ಎಲ್ಲಿದೆ joint petition?
Joint petition, not joint petition for MC filed before the court is placed. before
Mutual
the
divorce
court.
petition.
Where is that?
That is page number
68, my
66.
lord. It is.
ಅದರಲ್ಲಿ ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿದೀರಾ?
ಹೇಳಿದೀವಿ.
Yes, Milord,
Agreed.
para 8, my.
All right, all right.
Para 8.
68.
So and so parties were before the concerned court in MC 4531 while agreeing for giving consent for mutual divorce. The parties have agreed to cooperate with the quashment of the present proceedings. The observation reads as follows. Page 68, I'll mark portion. In the light of the offense being the once punishable under so and so except atrocities, ಮಿಕ್ಕಿದೆಲ್ಲ ಹಾಕಿ, I deem it appropriate to accept the ಈಗೇನು ಕೊಟ್ರಿ affidavit ಕೊಟ್ಟಿದ್ದೀರಾ?
We are filing only memo, my lord.
ಒಂದು affidavit ಆರ್ಬೇಡ. So deem it appropriate to accept the submission of the counsel to the petitioner to compound the offense against the petitioner. The other offense that is alleged is the one punishable under section 31 R&S of the Atrocities Act. Since the issue is between the husband and the wife, I deem it appropriate to quash the same in the light of the settlement, in the light of the conditions of cooperation for quashment of the proceedings as observed here and above. Yes, next.
Oh, yes.
Settlement in.
ಇನ್ಯಾವ್ದು settlement ಇದೆ? Any other settlement? Yes, Shamsundar sir, why are you waiting?
47 will at least down.
You will have to wait madhyana, I doubt.
My lord, kindly have it done 31st.
ಅದೇ ಇವತ್ತು ರೀಚ್ ಆಗದ್ರೆ 31st ಹಾಕಿ.
31st.
ನಿಮ್ದು ಕೇಳಿಸುತ್ತೆ. ಇನ್ನಿಲ್ಲ ನಿಮ್ದೆಲ್ಲಿ ಸರ್? So
3 morning, we got R4 night.
All right.
R5, no reply.
All right.
Honorable Governor, no reply. Now, let's, of course, if I go on, then it has to be without prejudice to dealing with any rejoinder which counter which
point.
closes. That's
the point. Yes.
I mean, it's not my fault, but it's an odd procedure. My lord is kept the whole afternoon, etc. Two of them have not filed a reply. R5 is not, and the governor is not.
No, if you want to go on, you can. Not
Yes.
behalf.
Yes.
I
Now,
am appearing on behalf of the
He is
learned
accepting
Solicitor
it.
General.
On
behalf of.
I will do this, Walets, that I can go on for a while, and in the light of any reply they make orally, in the meanwhile, I'll have to file a rejoinder in any case. I'm not
That's
giving.
that's exactly
Because
the
otherwise,
point.
it would be,
See,
Walets,
if
I
there
would be the one prejudiced because they gave me reply yesterday night.
no, there are some.
Not
If,
yesterday.
if objections, wait, sir.
Please.
If objections are filed and which would necessitate a rejoinder, then you may as well do it. If you want to submit, submit, no problem.
No, therefore, Walets, I was really advised to do a dual procedure if it is possible. I've not done it
all right.
normally. I argue for a while, Walets,
All right.
but in case I have to deal with, I mean, there are so many things they've said here. So obviously, Walets, I'll have to have a right to file that in the course of, Walets, whatever the next date of hearing, etc. Because otherwise, Walets, I'd be prejudiced. And in any case, two parties have not filed anything at all.
That's the governor and
Governor and R5.
On behalf
Another
of
complaint.
R5, let me make the position.
R5 complainant.
Complaint, respond number 5.
All right.
But I have examined the petition copy
Huh.
and the annexures which have been filed along.
All
Insofar as our the arguments are concerned,
Huh.
we will be relying upon the documents which they have filed along with the writ petition.
So you're not filing
There is
any
nothing
objection?
else for us.
You're
to
not
file
filing
on
any
record, nothing
objections?
else on record.
That should be
All right.
recorded.
Insofar as we are concerned.
One is over.
Questions of law have been raised and the documents have been filed along with the statement, writ petition. We will
All right.
be relying.
All right.
Those
As far as the
statements-
learned governor is concerned, if I may interject, Malad, I am appearing on behalf of the learned Solicitor General.
Huh.
Since a question of law has been raised, the office of the learned governor will be assisting this court on question of law. If required, my lords, we will produce the file of the honorable governor, which led to the decision making. My instructions are to state that as of now, we are not going to file a reply and we'll assist the court on
Yes.
the questions of law raised. We'll file written
All right.
submission during the course after hearing Dr. Signi's submissions.
Only
Our
delete
only
the word.
submission is that the hearing should not be delayed, my lords. My lords
No, no,
were
wait. Yes, sir.
Only delete the word as of now.
Please, my lords, the statement.
One line was required. I'm not filing a reply. I've noted that for both R5 and for Honorable Governor.
R5 and
My lords, may
Caveats
respond.
as of now, etc.
But in all fairness to the petitioners, they have produced practically every document possible, which led to the decision of the honorable governor.
All
Therefore, Lord, will be relying.
I'm so happy that I've
No, I must
obviated
say, no,
the
I must say,
counter.
no, when I said that, but I meant it. I meant it in all fairness. They have produced everything possible.
No, I am also taking it as a compliment that my comprehensive petition has obviated the need for counter from at least two parties.
No, I'm talking of the documents
So I
which have been
think if
produced.
those two are not filing the objections and
And in the course of whatever the next date is, I'll file the rejoinder to the other two. Malad.
if you want to submit, you can submit.
Yes, yes.
Yes.
So, Lordship, I record, Malad, there are no replies from these two because I don't want to be ambushed later on this.
Yes,
point.
that I will
It
record.
will be said later on that is unrebutted allegation, this, that, etc. I don't want that. Malad. I want to be.
I will record the submissions. Yes, let me just record that. The learned senior counsel, Shri Prabhulinga Navadgi, representing the fifth respondent, would submit that they have no objections to be filed in the case at hand as the question, as what revolves around the present challenge is pure question of law. He would further add that all the documents that are necessary to be relied upon is already produced by the petitioners and no further documents would be required. The learned counsel representing the Solicitor General, who represents the second respondent, would also submit that since pure question of law is involved in the case at hand, no objections need be filed, but the file relating to the grant of approval under 17A would be produced for a perusal of the court. That's your submission, right?
Please, my lords.
Yes.
That's right.
Now you can, yes.
My third statement that I have received these other two.
The learned senior counsel, Shri
Day before one
Abhishek,
yesterday.
Abhishek Manu Singhvi, representing the petitioner, would submit that the objections filed by R4 and
And R4, 3 and 4.
R3 and R4
Yeah.
have been served upon them, one of which is served the 48 hours ago and the other about 24 hours ago. Therefore, he would seek, in case rejoinder is required, he would file the same in due course. The submission is placed on record.
Would my lords also record that we will be filing written submissions on points of law?
On points of law, all right.
Yes.
The Ali second respondent ideyalla, Ali. The learned counsel would submit that written submissions with regard to the point of law would be filed in due course. Yes.
Same with
well,
me as well.
Ibardu ade ಹಾಗೆ. Both, yes. Yes, sir.
Now, let's on just to go point wise and to focus on the narrower issues, because ultimately.
Have you filed any synopsis, written submissions or something, anything?
I was actually frankly waiting for the counters and I would have covered everything in a comprehensive thing. So
All
I
right.
will, when I file my rejoinders, I will put in written submissions also.
Yes, sir.
But I thought I'll deal with all together. So I was waiting.
No problem, yes.
Now, let's, your lordship may just consider this point by point. Your lordship remembers I started last time with 17 capital A
Yes.
when I came.
PCI.
Now, let me break up some of the interesting facets of 17A, which I submit by itself. I don't want to oversimplify. I don't want to exaggerate.
Yes.
By itself, this one point would be sufficient to allow the petition without oversimplifying. And well, it's fortified significantly by the replies we have received. The replies we have received are very interesting. I would, in fact, I don't want to sound facetious. Were it not a serious case, the replies make it quite comic and make it very interesting and make out my case completely. And on the basis of the reply, not that I'm asking you to decide on the basis of reply alone. On the basis of reply alone, this petition can be allowed. Let me explain why. 17A first. Now, my first point when I opened last time, without the benefit of replies from R3 and R4, which we received yesterday, etc. The point I had made was that 17A needs prior approval. A, let me break it up point wise. B, prior approval is mandatory under your lordship's established several judgments. And C, the textual ingredients of 17A, leave aside anything else, even the textual ingredients of 17A were ex facie not satisfied, and yet the governor has granted sanction. Two of the textual ingredients of 17A not satisfied were only on the application of an investigating agency / policeman. That is one. There is no application by any investigating agency or policeman in the present case. And that I submit is a condition precedent of a mandatory provision of the textual language. And the second was that it must relate to a decision taken or a recommendation made by a public servant. Now, these two ingredients follow from 17A. Your lordship saw it last time with me.
Yes.
No police officer shall conduct any inquiry open with police officer or inquiry or investigation into any alleged offense alleged to have been committed, where the alleged offense is relatable to any recommendation made or decision taken by such public servant. So opening is police officer or investigating agency, and recommendation made or decision taken is the second ingredient. Both are not only admittedly not satisfied, not invoked, cannot be satisfied, cannot be invoked. They don't arise. And the public servant here has neither made any decision nor any recommendation in any capacity as CM or Deputy CM, etc. This is my first point.
Right.
Your lordship would see my law index alone. I'm surprised, all the cases, this is worse than carrying coal to Dhanbad. All the 3 judgments I've got, I did not realize it till I saw them.
Yes.
I believe authored by your lordships. I'm not going to actually carry coal to Dhanbad. But your lordship see the law index. There are
Yes.
3 judgments cited by me in the opening.
Yes.
The first proposition is Ashok versus Lokayukt. Second is Yashwant Sinha versus, not that.
That's Supreme Court.
That's the third one was Shirupa. And most important, fourth one, Praveen Kumar.
Fourth one was the first one. Rendered.
That's right, that's right.
Yes.
This put wrong in the serial. Now, these ballots make it clear that this is mandatory, this is clearly necessary, and that it has these ingredients. Well, the relevant para of this Praveen Kumar is para 14 to 16.
That is with regard to application of mind.
Mind.
Yes.
And it said 138 ballots. Would my boss want to read it? Because I don't think it's necessary. The Lordship has seen that it's.
Yes.
These are not ballots altered, appealed, challenged in terms of what variation. I don't know if the
I
challenge or
think
not.
these
but
judgments have become final.
Final. I mean, but certainly not varied in any manner. I don't know if they're lying in some challenge here or there, but they're not varied
Yes.
in any manner. The Srirupa is para 23 to 28.
Yes.
And that starts in my compilation at 106.
Yes.
And the third one is Ashok, para 15, which
Yes.
starts at page 5 of the compilation. So first point, ballots, the language history. Second point, the 3 cases. And 2 additional points before I come to what has happened now, which is very, very interesting, virtually almost comic. The circular at 260 of the paper book, which is the circular of the Honorable High Court of Karnataka at 260.
That is implementing Ashok.
So that your lordship has noted. And then, Malas, there is a SOP, a procedure
Of the Government of India.
of the Government of India dated 3/9/21 at page 703.
Yes.
Which my lord saw with me last time, para 2 and 3.
Yes.
These were the 5 points I made in the opening, QA 17A. Now, Malas, there is something interesting, a lot of interesting developments on 17A alone. We stick to 17A for the time being. And your lordship will note those developments. Malas, one of the, I would say, the principal complainant, if I may give him that special post and position, I mean, even amongst complainants, there should be a hierarchy. The principal complainant has now filed a reply saying that
Which respondent are you addressing?
R3.
R3. Who appears for R3? Aniva. Yes. R3.
Reply, which I'll be presently reading in a minute, says variously, there is itself is a bit of a fudge, but and I'll take it both ways. He says no 17A is required. And then he adds 1 or 2 places, just a word. He says unconditionally no 17A is required. I'll read that verse in a minute. And then he says not required at this stage. So he takes both, please.
Objections. List of citations.
I will take it either way.
Understand?
Objections of R3.
Yes, it's here. Yes, sir.
If your lordship will turn to that verse in particular at page 60 and 61, and I'll take the liberty of reading this a little slowly. Para 20 at 60.
Yes, sir.
In the private complaint filed before the special court, the stage of court taking cognizance has not yet reached. And R3 in his private complaint has only sought for reference to the concerned investigation officer for investigation under 156(3) of the CRPC in accordance with law. Therefore, the question of taking cognizance at the current juncture does not arise before the special court. It is submitted that on this ground also, R3 need not obtain sanctioned as envisaged and 218. Currently, the private complaint, which is an unnumbered one, is posted for hearing before the special court. Nevertheless, the R3 applied for sanction. Mark this word. Nevertheless, R3 applied for sanction to the governor, in adherence and compliance of the honorable judgment in Ashok, as the same is currently the law of the land, as an adherence exercise and a procedural formality, not any substantive requirement, a procedural formality, pursuant to the circular issued on 4th of July. Now read the next 4 lines.
Yes.
Although the order of sanction from the competent authority under 17A is not required for the instant case, and the sanction under 218 is not mandated at this juncture. Now, Milits, I have 3 or 4 points here. And I don't want to sound facetious. The whole writ should be allowed, or he should withdraw his complaint, rendering the sanction complete waste of time, and the governor should first impose costs on him. And then later on, your lordship should impose costs on him. Your lordship, why? I'm not making a facetious comment. Now, this person, your lordship, read his pleading. It's on solemn affidavit filed in the court, given to us yesterday, day before. That's why I said, were it not serious for me, it would be comic. This person, Malaz, like Alice in Wonderland, applies to the Lokayukt. The same person. Please turn to Malaz. I'm sorry, Malaz, to the governor.
Yes.
At page 48. Page
Was it
48.
applied before the Lokayukt also?
Also
Not
the
in
Lokayukt.
compliance with Priyanka Srivatsal's case.
I'll do that
Complaint
also.
was lodged.
First, come to the governor.
Complaint was.
Complaint was lodged.
Apparently, Malaz, the entire machinery must waste time on his facetious complaints, which he says, I don't need to make a complaint application. Why should I trouble the Honorable Lokayukt and Honorable Governor? Come to Malaz, page 43 first. Sorry, 48 first.
Of the objections?
Of the Malaz, of the petition, of the paper book. Volume.
Yes.
Now, your Lordship just read his affidavit. Now read this. His Excellency, the Honorable Governor, on 26th of July 2004, first line, request for sanction for prosecution of Mr. Siddaramaiah, etc., etc. And read the 4th line under 17A and 19 and 218 also, Manas.
Yes.
Also, Manas, end this at 69.
Yes.
Which is the last para. Wherefore, it is requested from your good office to directly grant sanction for the prosecution of Siddaramaiah.
Yes. What is this? Illegally gaining rupees 55 crores, is it?
Where is it written?
No, the complaint is about that.
Please.
55
Yes,
crores.
yes.
Application for sanction.
He makes a
is about that.
quantification of this whole issue and says this is illegal. At the moment, we are on his affidavit and we are on this. Right? Now, again, this is not just a single swallow in the summer, not a single bout of madness. It is a consistency. Page 200. Same volume. This is Honorable Lokayukt.
This is to the Lokayukt. This is 154-1 complaint.
Please.
Yes.
Information of so and so, so and so. Where is it? Why did you give me Lokayukt? Does it have?
Yes.
Does it mention sanctions? You have to give me only when it's sanctioned. Now, whereas here he has made a complaint where he does not say anything about 17A. Is it there? Oh,
No, this is only a complaint.
complaint, correct.
It need not comply with 17A in this.
Right. No, I'm just saying, Wallace, he's come all this way to the governor, etc. He makes no mention about anything.
Yes.
Now,
This is earlier to the governor's.
that's right. That's right. Now, Wallace, I, Wallace, put it like this. He has made a complaint. He seeks sanction. Governor grants sanction. It's not a suo motu governor action. The governor action is based on my on XYZ's complaint. That complainant says not necessary. Well, then, Malas, obviously, since he will not withdraw it, your lordship should, Malas, treat that application for sanction as non-existent on this basis alone, on the counter affidavit. And therefore, the basis and the foundation of sanction goes. We are not here to answer academic questions. We are not here to balance the entire foundation of the sanction order goes. And this is not balance, this is balance, a person who is facing this, like me, the petitioner, has every right to say this is absolutely a farce. I didn't mean it lightly when I said the governor should, before sanctioning prosecution against me, impose costs against him. If he has the power, certainly your lordship has the power. I don't know if the governor has power to impose costs. So this is the short point on which on the second aspect of 17A, and it's a full point, because I submit with respect, that this cannot be just that you come to system, you set a whole thing in motion, and then you say not required at all. Well, then you have to be straight in your stand. You take your chances. What is the problem? You go ahead, prosecute, we'll see whether sanction is required or not. You can't have it both ways. You get a sanction, when I come to court, you tell the court in the counter affidavit, I didn't require a sanction.
Don't you mean to say that they can proceed with it without sanction?
They should. They should, Balas. They should have the courage of their convictions. I'm not saying anything. I'm only defending. Imagine, Balas, that's why we say, Balas, that's why. No, there's another facet to it. In practical, not in law also, Balas. People like the governor should be restrained. That's what happens when anybody walking about the path makes an application. Well, should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. Well, if anybody on the road comes to him and says, give me sanction, he's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
When
not-
was the complaint registered?
First, the sanction was sought.
Amal complaint registered. All right.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, Malas, this is Malas very serious. He's playing ducks and drakes, A, with the governor, who has actually granted his prayer, and B, with the court. And Malas, the only legal consequence of this is, of course, I'm not saying that he's going to withdraw, should be his withdrawal on the basis of his affidavit. He can't, Malas, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should, Malas, treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, Malas. Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is the phrase used in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. Well, he has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why actually
A particular paragraph mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Kannadiga to read it. Your
Maybe
lordship.
some restraint, my lord, on
Wait,
usage
wait.
of words.
When sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
No, my lord. On usage of words, my lord. There may be some restraint.
About
my lord.
what?
Some fellow, Alice in the
that-
Wonderland.
yes.
My lord,
Sorry.
it's not, my lord, there's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable court is utmost important.
If
The-
literature of Alice in Wonderland
No, the revenue
standards
code,
are
my lord.
objectionable,
No,
unparliamentary words, I
it's
plead
such
guilty,
language.
Willis. I
You may
plead guilty.
address them as respondents, that's all. Yes.
Now, Willis, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on
So
what?
he has not applied. That is a fact.
That's fact. Now, we'll just see that. Just see that at 376, his application. It's quite remarkable. 5th of July,
Whose
2020,
application?
R4's. To the governor, which is now Well, we have got only, well, with this reply,
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections.
Now, Milits, I made them read it to me slowly and I was happy to note that I could understand most of the slow reading of Karnataka. But I can't read it to your lordship, so my learned friend Mr. Ravi may kindly do the honor of reading.
This
just
is
the
the Snehamayi Krishna. R4 is it?
R4. The last, just the relevant portion.
Just subject and
Yes.
the prayer.
First see the subject words. Yes.
376. 376.
I'm sorry, I should Kannada.
All
I
right.
only said Kannadiga. Kannada.
In your subject ನೋಡಿದೆ.
Apologies.
Kindly come to prayer.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
380.
ಅದೇ ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
Yes. I'll read it.
Yes.
My learned friend is also able to understand Kannada. When they read it slowly.
No, I understood when they read to me slowly in conference. I understood most of it. I was happy to note.
Yes, sir.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು ನಾವು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ನೀಡಿರುವ ದೂರರ್ಜಿಯನ್ನು ಆಧರಿಸಿ ಕೂಡಲೇ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕರಿಗೆ ಸೂಕ್ತ ಆದೇಶ ಮಾಡಲು ಹಾಗೂ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ಪ್ರಭಾವ ಬೀರಿ ಮೊಕದ್ದಮೆ ದಾಖಲು ಮಾಡದಂತೆ ಮಾಡಿರುವುದನ್ನು ಸರ್ಕಾರಿ ಯಂತ್ರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸುಳ್ಳು ಮಾಹಿತಿಗಳನ್ನು ನೀಡಿ ತಾವು ಮತ್ತು ತಮ್ಮ ಕುಟುಂಬ ಯಾವುದೇ ಅಕ್ರಮ ಎಸಗಿಲ್ಲ ಎಂಬುದನ್ನು ಸಾಬೀತುಪಡಿಸಲು ಪ್ರಯತ್ನಿಸಿರುವುದನ್ನು ಗಮನಿಸಿದಾಗ ಸದರಿ ಪ್ರಕರಣದ ಮೇಲೆ ಮುಖ್ಯಮಂತ್ರಿಯಾಗಿ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರು ಪ್ರಭಾವ ಬೀರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರನ್ನು ಕೂಡಲೇ ಮುಖ್ಯಮಂತ್ರಿ ಸ್ಥಾನದಿಂದ ವಜಾ ಮಾಡಲು ಕಳಕಳಿಯ ಮನವಿ ಮಾಡಿದೆ.
Now, it's just this much shows I'm not interested in R4, who have not even filed. It shows complete non-application of mind of R2. Complete, total and absolute on that short ground, the sanction must go.
One clarification. No, 1 minute. One clarification. Here there is, he is not seeking sanction at all here. He's only asking the matter to be referred for investigation to the hands of the CBI. And inter alia, he says that he should step down.
Correct, absolutely.
So this is not a question of sanction at all.
Correct. He goes to the governor passes an order on this. Sends me a show cause based on this.
No, show cause notice is not issued on this.
Not on
No
this.
show cause notice is
Not
issued on this.
Then, Malas, the order says I'm.
A paragraph
That's
refers
right.
to this.
That's right.
But no show cause notice is
No,
issued to you on this.
One of facts. This morning, along with the memo, we have filed a communication dated 31st of July 2024, which we have submitted, my lord, to the honorable governor, which seeks for sanction. Kindly see that memo.
When was that given?
31st of July. This is after this letter, another communication.
Governor's order.
That is what I want to point. So, my lord, to say.
Governor refers to this, you mean?
By date, the governor may not does not refer to it by date, but to say that no sanction at all was.
Why you did not file this along with the statement of objection?
No, Malas, I'm very happy. Please let them, Malas, oh, these webs we weave, we become, Malas, caught in them. Please record this. Kindly record this, Malas. This is an official statement. I'm not talking about counsel, I'm talking about his client. He says he did, so he said this is not, but I filed on 30th or 31st of July. Kindly record that.
Yes. No, anyway, it is getting recorded, not a problem.
No, what I mean to say is not record in that sense, but it's a stand now.
Yes.
Now, that 31st of July, so by my point till I heard Mr. Raghavan intervening was that there is complete non-application of mind by the governor. Now I hear him intervene, possibly to say, no, the governor did apply his mind. But my point remains the same. The governor in his sanction order does not recognize, mention or note 31 July, which I have heard for the first time 1 minute ago. So my non-application of mine is improved. Oh, these webs we weave. That is the point, fellows. That's what Shakespeare said. More you weave a web, the more you get caught in it. So, to try and cure the lack of application of mine by the governor, a statement is made that we did give him a sanction application. The governor doesn't notice that sanction application in the order sent to me and does not issue me show cause on that.
No, all that the governor says at paragraph 2 is
Yes.
2 more petitions from Pradeep Kumar SP and
Yes.
Snehamai Krishna
Yes.
have been received at my office in respect of the same allegations.
So,
So date is not mentioned
three
nor
things,
the
three
content
things.
is mentioned. Yes.
We do not know when given, how given.
So that's what now
Don't
is
know.
sought to be produced.
Now it is produced. It is quite astonishing, to put it mildly. That's my third sub point here. It is more than astonishing that a man who files a 100-page rejoinder forgot to say this in his counter, forgot to say this in his counter. At the moment, I'm trying to use words of studied moderation. We have all been, we are lawyers. Your lordship has been a lawyer. There are lawyers all over the place here. A person who files a counter yesterday or day before has omitted to mention Hamlet in the Prince of Denmark or Prince of Denmark in Hamlet. But this is his complaint, this is a foundation. Till now, we don't know about it. Your lordship doesn't know about it. Realizing that he is apparently curing the governor's defect, but not realizing that the governor doesn't tell your lordship whether he's acting on this complaint which I have read just now or the 31st July complaint. It is quite unclear. He has not, why should I not say that he acted on the complaint I have read to your lordship and not on this? Why should I not say it? And why is it not fortified by the fact that the first time this has been mentioned is on the 29th of August in the middle of arguments? Well, it's 31st July. When did I argue the matter first? I argued it 1 week ago, I think. 19th August, 31st July, 19th August, 29th August. In between on 27th and 28th August, counters are filed. Well, there are 4 occasions. I'm sorry, Balaz, I'm being a
So
little...
let's see whether the omission would cut at the root of the matter.
It would, Balaz, because this is a Balaz, your lordship takes a holistic view. No single straw breaks a camel's back. But Balaz, this is very, Balaz, to put it in the mildest word, is strange is not a good enough word, Balaz. This is amazing. And even taking this letter as it is, we do not know on what the governor acted. We are on the, ultimately, governor's sanction must go. Governor's sanction must go for all these reasons. We have no idea what he acted on, apart from, of course, never sending us a show cause. And that point I had made last time without knowing about this letter.
So you have to say that on this he asked for sanction. Just read the sanction. On this 376 he asked for sanction. Now he is getting intelligent and saying what. Just read.
Now, Malaz.
But one,
let me go.
sorry, one clarification.
Yes.
17A, does it contemplate issuance of a show cause notice against whom sanction is, approval is sought? Does it contemplate?
Well, it's
application of mind we'll consider, but the submission that you're trying to make is governor has referred to these 2 and show cause notice was not issued.
It was
That-
issued.
No,
We also
only against one
the
complaint.
principle of issuing R3.
R3's
the
complaint.
principle of issuing show cause is accepted by the governor himself.
No, true, but whether law requires is what I'm.
Therefore, Malaz, I would say yes, natural justice. Your lordship now, Malaz, has Malaz, let me digress for 2 minutes. For the answer, I'll be dealing with it separately. Let me digress. This is a direct question from the bench. I'm obliged to. Let's digress for 5 minutes and answer.
Yes.
Well, it's not now, but from 1967. Your lordship has this felicitous phrase, adverse civil consequences in
Yes.
Bina Pani Day.
Yes.
And your lordship did not have very big constitutional principles in 1967.
Yes.
When your lordship elevated saying all this quasi-judicial, judicial, administrative, we go by adverse civil consequences. That is 67. Now, Malaz, your lordship has traveled a distance, 2 recent judgments, one of which I had the privilege to assist the court. That even, this is exactly the same argument raised, Malaz, that before you declare an account fraud, not Malaz NPA.
No, fraud.
Fraud.
That is serious civil consequences.
this
Notice has to be there.
no, the argument was to declare it as fraud is like filing an FIR. You don't need a show cause. That was a specific argument of Solicitor General who opposed me. It's recorded.
That is,
Now, well, the FIR, you don't require a show cause.
no, FIR you don't require a show
The
cause at all.
argument is that before you declare criminal fraud, an account beyond NPA, you don't need natural justice. And the people in that batch, which we argued, Balas, were apparently allegedly owing hundreds of thousands of crores. The court set aside a batch on the principle of natural justice. My answer to my lords, respectfully, is that natural justice is now elevated to an Article 14. It's now part of Article 14, which is not earlier. Today, Malaz, when you do something with very serious, the most serious adverse civil consequences, you are granting sanction to a public servant, in this case, the highest public servant of the
Approval.
state. No.
Oh, sanction is also mentioned.
No.
Yeah.
Sanction, oblique approval, let us call it. You are granting to the highest executive of the state, and you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have Malaz relevance in the first chapter. Therefore, Malaz, you should have dealt with it. On balance, as of today, the law would, Malaz, be interpreted in my favor. But here, Malaz, I'm on something else. To come back to the point here, Malaz.
No, I thought it fit to ask you that for the reason that no notices were issued on these two complaints is what you said.
Malaz,
That's the reason.
The reason is this.
Yes.
That he felt that he had issued one. Malaz, the reason is hurry and lack of application.
That's all. Yes.
That's the real answer.
That
Let us be practical, Malaz. The real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice on that complaint to him. I got two more. I said, I already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well.
But Malaz, I must now come back to this. This is
Yes.
very, very interesting.
I wanted clarification.
No, I'll be
That's
dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll
Yes.
cite those two judgments because the court has gone very far there on natural justice, telling your lordships how important it is. Therefore, there are three. One more thing I want to say on natural justice before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy
Those,
plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute. Your
Then we
lordship
will have to
was-
read into the
In
statute.
Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there's no question about it in this case. But let me come back to this intervention by Mr. Raghavan just now.
Yes.
Well, as your lordship will see the number of occasions and how strange this is. You have now, just now told your lordship that I did apply for sanction. Right,
Yes.
Wallace? And this document which Mr. Singhvi is reading is of course not the sanction because I'm reading a document that doesn't seek sanction. Now, Wallace, this document I read just now, I didn't read one and read in Kannada, Wallace,
Yes,
is actually attached to the objections, right, Wallace?
it is.
Now let us see what the objection says. It says this is the application for sanction. This is the problem. When you make up the story as you go along, the problem is this, fellas. Truth has a very strange way, Malas, of getting you caught up in all kinds of webs. Now, let's come to para 55. That was the intervention 2 minutes ago. Now, you should see what your deponent has said.
Para 55.
Yes, page 43.
Mm. 43 of what? Sir?
What is this?
Objections.
Private complaint filed here. Before trial
where?
court, which is here, this is the next year before trial court, in the talk of 31/7 October.
We are now considering a proposition. Just note what are these 4 dates. The original complaint by application by Mr. Ibrahim, that is R3. Then Malas, the application by Mr. R5. Then the order of sanction, show cause. Then the sanction order. Then Malas, my petition to your lordships and detailed hearing on that. Then 2 days ago counters, and then today's hearing. In between, there is also a police complaint filed, Malas, PCR. None of them mention 31 July. I forgot to mention on 8th of August, PCR is also filed. I'll give you a list
There is no mention about this.
of this. But the mention in the affidavit, which will prevail on pain of perjury, is this, para 55. We have to go by this, not by Malus, what is said orally. Since the accused one is the present Chief Minister of Karnataka, the competent authority to accord sanction for prosecution is His Excellency. This is the averment to which this is annexed. The competent authority to accord sanction for prosecution is the Excellency. Accordingly, the complainant has also sought for the sanction and permission from the governor under 19, under 55, under 197, under 218, under 200, which is pending consideration. It is pertinent to note that since the allegations against the named accused persons are not in relation to any action taken or recommendation made by accused one or other named accused, there is no requirement of prior permission of approval from the competent authority under 17A. This court can consider the complaint on merits without any legal impediment. The copy of the same is appended as 35. This 35 is 376.
Yes.
Whereas I counted 6 dates from the first date. Again, Wallace, I'm not meaning facetiously. There is a saying, 6.
This is 28, all the documents are there. There's no 317 here.
Give me the date of the application, 2 applications. Whereas in between these dates, write down the dates in a piece of paper. Write it here. In between, on 8th of August, I forgot to mention, a PCR is filed before the trial court. And Wallace, that PCR on 8th of August.
That is where you read from. Para 55 is the part of that complaint.
That's right.
Yes.
It's an X there.
Yeah. No. Now you read 55.
Yes.
At page 43 of the objections. That is
That's
a part
right.
of the complaint itself.
That's right.
PCR.
And it is not, Wallace, noted anywhere about 31 July. Stop this.
No. All the documents say there is 317.
And Wallace, the document index, what is this volume?
It's the same R4.
Wallace, this R4's reply has a list of documents which runs up to Wallace serial number 35. You see the list of documents. Obviously, I can't show negative. There is no 31 July whisper of a mention.
That's not there.
Therefore, Wallace, this by itself, again, I'm sorry that these are analogies which are arising from the natural course of conduct done by the respondents, not me. There's a saying, the first time it is happenstance. Second time it is coincidence. Third time it is enemy action. This is the 6th time, not 3rd time. Therefore, Mullahs, 17A today on R3 and R4 and R5 has not filed any reply. And I don't have any documents about him. Today, Mullahs, is clearly. Then, Mullahs, the 4th sub-aspect of 17A is a very, very strange and quite amazing aspect. The argument is that this offense allegedly took place in Mullahs, whatever, 2005, 2007, 2010, whatever date you take. Various dates can be. In 2010 or 2005, etc., you cannot apply 17A retrospectively.
That's his submission.
Well, with great respect, this argument has to be only stated to be rejected. Because if you choose to file a complaint after 10 years, 15 years, or whatever years, and then you have it both ways, I will file a complaint today but not comply with the law of the land today, which is of some, hoary antiquity already now. Then, it's an argument which has to be stated to be rejected. These are, my 4 or 5 sets of arguments on 17A, on which I submit alone, not that this is the only ground, but alone, this entire thing falls to the ground and should be set aside, etc. Now, the Next point I wish to come to, brothers, is to remind your lordships about the statement made by the governor just now, a little earlier, saying that, look, I don't wish to file any reply. Your lordship remembers that we had said that the governor has specific names and dates with investigation, after investigation of Malad's complaints pending. And if your lordship will turn to Malad's, well, I don't have to give your lordship the note, just note the details, Malad's. Annexures from 693 to 696 and 701 to 702. These are much prior complaints, in some of which investigation is complete, charge sheet is filed. The names are Malos Sashikala Joli, Murgesh Nirani, H.D. Kumaraswamy,
Charge sheet is
Nathan
filed.
Reddy.
Charge sheet is filed.
Investigation is complete in any
Complete.
case.
Charge sheet is not yet filed.
In one Malos, I'm told. In one
Because without sanction, charge sheet cannot be filed.
take out details. What is it? Yeah, but it's investigation complete, therefore a charge sheet is filed subject to the sanction. That is the correct.
Charge sheet is also filed.
Yes, yes. Yes, yes.
All right.
Today, Malas, when I say that anybody comes to you and you immediately grant, well, the person who granted has at least these 4 names I have given. And the pages are Malas 693 to 695, then 696 and 701. This is an article 14 point straight away staring you in the face. Now, Malas, there is no reply and none. And in fact, last time orally it was said, orally, that we will let you know about this. Specifically said.
No, he has now also said that he will produce the records complete.
So, Malas, that is, no, but the fact of the, correct, no problem. Records are between the court and there, no problem. But the fact of the matter is that these 4 are actual real human beings, actual real complaints and applications, actual real pendency, much earlier dates, investigations complete. That's all that I'm saying. I don't think the record, whatever is produced, can be different. Now, Malas, the next aspect is another simplest, straightforward point without meaning to over-amplify or oversimplify. The sanction must go. I'll tell you why. Your lordship has now held absolutely crystal clear that sanction is fully reviewable. That is beyond doubt. The law has got well ahead of that. It's completely and totally judicially reviewable. The 2 judgments amongst many Amalas, Mansukha 1997 and Yedurappa 2015. My compilation has them. I'll just take your lordships to them. So it is completely reviewable like judicial review of Malas administrative public law action. Be it Malas for ulterior motives, lack of application of mind, Wednesbury unreasonable, etc., etc. My lord knows that well. There is, apart from that, Malas, I have given detailed additional law also, and I will, Malas, cite some of that. Well-established principle. Rameshwar Prasad, State of Gujarat, R.A. Mehta, and of course, very homely flavor of Karnataka, S.R. Bommai. Directly, Malas, they say, it's fully reviewable. I've got the paras also. 9 judges down to division benches. Now, Malas, the beauty of this case is that the governor has not applied his mind or dealt with a single point on the merits of the sanction. I repeat, that's why it's a simpler case. Not applied his mind or dealt with. Whereas you can even deal with the subject, which shows that you dealt with it without applying mind. It is possible. But for not applying mind, for me to show non-application of mind, I must show that you've dealt with it. The governor has not dealt with a single point. One point he deals with. I am not bound by the cabinet advice. So let me for a minute accept the Honorable Governor and proceed from there. I'm not accepting this, but I'm just saying, please proceed for a minute. You are not bound by the cabinet advice. Let us take it as it is. Therefore, you are acting on a tabula rasa. The tabula rasa is that this man has applied, this application has come,
No, this requires an independent decision. Sanction against this, the chief minister or other
Therefore,
functionaries.
I'm for a minute
It is an
accepting.
independent decision of the governor. He cannot fall back upon or need not fall back upon the advice of the ministers.
I am almost proceeding on that basis.
Yes.
There are some nuances in Navam Rebia.
Ah.
It is, but I'm not arguing that. I want to make it simple first. For a minute, please assume against me and in favor of the governor, as my lord felicitously put it, independently decides. He's the cabinet, not bound by the cabinet.
Yes.
He's the complainant. He or she comes to me. I'm the governor.
In this particular issue,
Yes.
not in every issue. He is definitely bound by the bound
No,
of
we
to
are
follow
talking of
aid and-
sanction. We are talking of
aid and
sanction.
advice definitely is there.
No.
But
On the sanction,
on the
regarding a
sanction,
chief minister.
yes.
So well, we need not trouble ourselves for a minute. For this purpose, at the moment, I am assuming against myself. So, Malus, what happens? I am the governor. He or she complains. As a lordship used the word independently, I have to give. Now turn to page 41. There's nothing.
No, that will.
There's nothing.
That you have told. Yes.
What do I show, your lordships? There is nothing. There is only one point. I received a complaint. I received an advice. I am not bound. Hence, I grant sanction. I don't want to exaggerate, but I repeat. Is that not sufficient to quash the sanction? My lord used a milder word just now, independent.
No,
It has to be an objective consideration with reasons, with application of mind reflected in the order. There must be something. It can't be that because I'm not bound by you, therefore I must grant sanction. That's what the order says. Therefore, Manas, this on the merits is the most strong ground on the merits of the sanction I'm now. And it is sufficient to set it aside. Now
Yes.
let's just pick up that bunch, only the index. I'm not going to read it. To
The
let's give the index. Of the
judgments?
Yes, just to tick it, just so Lordship knows where is what. Is it all here? Where is sanction is reviewable? Sanction is reviewable. Where? Which one? The index where? Well, let's here. There are some of them which are separate. So I have to little scattered. May I make my lords just stick it? In this large bunch, one is scattered at serial number 2 at big, I'm sorry, you should not have put new serial numbers every time. Why do you make an index like this? Not the index. We have put Wallace fresh numbers each time, so it creates some confusion. If your lordship sees Wallace page 2.
Page 2, sir.
Of the index.
Yes.
So one is Wallace Mansukh Vithaldas Chauhan.
Yes.
And the paras of this Wallace are. The paras don't make me wait. You are a complete mess.
17, 18 and 19.
Para 14 to 18. In fact, 14 to 19.
Yes, sir.
Take out. These are
Of Mansuklal Vital Das.
That your lordship has picked one of the number 2. I'm sorry, my index should have had continuous numbers, but we don't have.
No, that's
So it's
all
number
right.
2.
No problem. Yes.
Then Wallace Yedurappa
22
is on the next page, number 5.
22 to 30. 22.
Yes.
Here, Wallace, para 22 to 30. But I have also culled out the more specific paras like 27, 28, 30. Wallace.
Yes.
I will also Wallace, give a lordship a digest of just the paras with the extracts to make it shorter. Later on.
That's better.
Will you make a note of that? Just not all, just the relevant ones, the underlining highlight. Just, otherwise it's much easier. Now, Wallace, in addition to that, point 11 below. The other judgments, Wallace, which talk of judicial reviewability very clearly is the Constitution Bench of Ramesh. Where is the bunch?
Yes.
This is Wallace, a volume 2. These are high-powered numbers in terms of benches. Wallace. The numbers are larger. Constitution benches are 9 judges.
Yes, sir.
So one is Wallace Rameshwar Prasad, which is the number 4 serial on the first page.
Yes.
Here your lordship may write on the margin, I'm sorry. Maybe I have to give it to lordship writing. Was 128 and 129. This is a constitution bench, 5 judges.
Yes.
And Wallace 140 to 145.
Yes.
Para numbers. The previous 2005 Rameshwar Prasad, para 7 will suffice.
Yes.
So 2 Rameshwar Prasads.
Yes, sir.
Both are constitution benches. Well, the state of Gujarat. Where is state of Gujarat? Well, I'm very sorry. What we'll have to do is extra, because we've given them all over the place. So I'll give the
It's all
extras.
right, no problem. Yes.
There is well, a state of Gujarat, which is 2013, 3 SCC, page 1, para 68. I had the privilege of assisting the court here.
So all of these are concerning Article 356.
So, Malas,
What is that you want to rely on?
so I'm saying, Malas, governor's actions.
Huh.
The narrow ones I've given you first two are Mansukha and Yedurappa.
Yes.
But Malas, I am saying governor's actions are fully reviewable even in the A for sure I category,
No,
totally and completely.
I have no doubt about
That's right.
it.
That's
Yes.
it. So I'm just, Malas, this is 45. That's why I'm not reading it.
Yes.
I'm not even reading it, Malas.
Yes.
I'm giving a lordship this idea, and it's capped. It's capped by Bommai in Malas the paras. So what I'll do is, with your lordship's permission, I will take Malas extracts and only some of them and underline them and give it to your lordships. I am not even reading them.
Yes.
It is too well established. Now, Malas, on the natural justice part, please note the 3 dates first. Yes. Whereas note 3 dates, a show cause is given to me on 26/7/24, which is at page 265.
Yes.
And Malas, what? Date of my reply. Date of my reply. And Malas, meanwhile, in the interstices of the government, the AG has given an opinion on 31st of July 24, as the documents now show, at page 267. And the cabinet note is at 1 August 24, which also attaches the AG's opinion at page 336. But what is missed out here is that I separately replied on 3rd of August 2024 at page 630. And I was also cited a lot of law and all the details, etc., etc. Now, all of this is decided by the order at page 41, dated 16th of August 2024, which, as your lordship has already noted,
Yes.
adds this gratuitous sentence that R4 and R5, which is para 2 of that document, page 41, para 2, which is when I first learned of it. But Malas, this is one part of natural justice. Natural very many parts. Malas. This is A. Part B of natural justice is that all the points I have raised, forget the cabinet, Malas, you're bound or not bound, I'm not bothered. I have raised these points of diverse nature. You have not dealt with any. Any. That's point number 2 of natural justice. It is, your lordship has the order 41 to 46. I can't add to it. I can't subtract to it. Nothing. Files also, Malas, which are uncommunicated, can't, as far as the final order is concerned, add reasons. You can't say that I wrote an order like this, that I had 28 reasons in my file back home. That is not an order. You can't justify, Malas. Now, in this light, Malas, your lordship put a question on the scope and nature of natural justice. So before I read those 2 judgments, take them out, keep the paras ready. I want to, Malas, just give your lordship first principles, 3 or 4 points, then your lordship will. One is adverse civil consequences, Bina Pani Day. Second is the consequences here are much beyond adverse civil consequences. Because, Malas, it is not only the person who is the chief executive of the state. I have said in the opening that the larger constitutional issue is that if you are elected with a full-throated election where huge amounts of money are spent by the opposite side, but still you lose. Somebody is elected. He may be bad governance, fellas. He may be a horrible governor. Only the people who elected have a right to remove him. If you can use this methodology to remove him or initiate removal, then it's a negation, which is why all safeguards have to be read. Obviously, Malas, if somebody is steeped in crime and you have material, yes, give reasons and start removing him. But Malas, every filtered safeguard must stand at the threshold because you are negating the mandate of the people. If you accept this larger principle, and Malas, your lordship state, Karnataka, was the first to make basic federalism part of basic structure in Bommai. It's very interesting. We digress for a minute, Malas. Federalism, if your lordship Googles the constitution, is not a word found anywhere in the constitution. I gave a lecture once, I examined it. There's no word called federalism. The word federal comes up because it's a federal court we had.
No, because we are
Court.
quasi-federal.
No, that's all right, but even quasi-federal has some elements of federalism. Kenneth Weir called it quasi-federal, first Australian jurist to use it. But federalism, you only get reference in the text of the constitution to federal court or federal. Federalism, without being mentioned in the constitution, your lordships and 9 judges Bomai held to be a part of the basic structure of the constitution. So, this is another aspect of assaulting federalism or negating federalism if you can remove elected chief ministers. The third, which is why your lordship must read in all safeguards. Third aspect is that famous phrase of Mr. Ambedkar. You cannot have two swords in one scabbard.
That you told me.
Elected, unelected. Therefore, keeping that in view, your lordship will just see in natural justice, you are having a plethora of material which you in your independent sovereign decision making has a right to overrule, but with reasons, with material, with thinking mind. Nobody is grudging you a right to act, but we are grudging you a right to do it in a proper way. That is what natural justice is, not hearing only.
Decision making process.
That's a much better word for. Oh, I heard you. I sat like a sphinx, like a statue. I heard you. Now go home. I've written the order already in my desk. I take it out, give you the order. That is also natural justice. I heard you. It's not hearing. It's the decision-making process, that's exactly the correct word. Now, in the light of that, turn to, let's first turn to Rajesh Agarwal, paras, which is, 2023, 6 SCC, page 1. Kindly hand it over to me. You give me this, then you come to mark copy. Because this is the things you given to judge. Volume 2, Malas.
Yes.
Now, just kindly note, I chose this first, not because I appear in it, Malas, but because the facts were purple. They said that these are defaulters for whom I was appearing, who have crores and thousands of crores, and they must be declared fraud. But they're very interesting. RBI circular says NPA is one part, but you must declare them fraud so we can take criminal action. Now, the process of declaration of fraud, they had already got notice about NPS. Natural justice was satisfied. Bank said, why should we have another natural justice? We've already declared them NPA. These are fraud people. So they declared them fraud without natural justice. Now, the arguments for us, therefore, are very useful in that light.
It's para 36 onwards.
Yes, I'm grateful. And this went on for quite a while President Chief Justice was in court too,
Yes.
He was the senior most puny judge. Starts with 41, if your lordship will turn for a minute, Audio alter starts with 36, my lord rightly notes. But come to page para 41, which is the Bina Pani Day. That's why I don't have to cite all of it.
Yes,
Lordship
yes.
gets it all there. So this is how the court, your lordship applies natural justice in the larger decision is a subject neutral concept. It is subject neutral. It cuts across the entire law. Then 42, Canara Bank. Administrative actions involving civil consequences. And see the italicized portion at para 45, italicized by the Supreme Court, not by the SCC. Even an administrative order which involves, so administrative order also. You are talking of much more serious orders here. This is not an administrative order. Then let us come to 46. Consistent pattern, not merely property or personal rights, civil liberties, material deprivation, non-pecuniary damages, every order, civil consequences. So, Bina Pani Day is the anchor which is now built upon very much widely by this judgment and other judgments, very much more widely. Now come to 67, that master circular of RBI starts at 48, etc. I'm skipping all that and bringing.
What is held it as para 81?
Well, that's true. I just want to take 2 minutes more on 67.
Sir.
67.
Exclusion of.
Now,
Right.
This is that principle, express exclusion, express inclusion. But you must read into it the interstices. And there, your lordship will see Swadeshi. Just see, just see the third line of 67.
Yes.
This is what I was saying, It's taken from that Cooper v. Wandsworth.
Yes.
The common law will supply the omission of the statute is the principle, where it is silent on granting an opportunity of hearing to a party where rights and interests are likely to be affected. Then Swadeshi, then come to the next page. See the first few lines of para 44 quoted at page 37 of the SCC. In short, the general principle as distinguished from an absolute rule seems to be that where a statute does not in terms exclude this rule of prior hearing, but contemplates a post-judicial hearing amounting to full review, then such a statute would be construed as excluding the audio alterum at the pre-decisional stage. Conversely, the statute conferring the power is silent with regard to the giving of pre-decisional hearing to the person affected, and the administrative decision taken by authority involves civil consequences of grave nature, and no full review or appeal on merits is provided. All of it applies to me, Malas. All of it. Courts will be extremely reluctant to construe such a statute, excluding the duty of affording even a minimal hearing, shown of all its formal trappings. Your Lordship is in Malas at the worst in virgin territory, where your Lordship must lean in my favor. Is my humble submission, reading the way it is written, Malas. Yes, if there's a exclusion, different matter. The court must make every effort to salvage this cardinal rule to the maximum extent possible. Then Malas Swadeshi goes on in 69 and leave that and come to Malas 70. Mangilal is important, Malas. 70.
Yes.
Even if a statute is silent and there are no positive words, kindly see this, Malas.
Yes.
In the act or rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that will be passed, and making it a requirement to follow a fair procedure before taking a decision. More important is fair procedure, not only well as the formality of the hearing, as my Lord rightly put it, decision-making process, and making a requirement, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the contrary. No form of procedure should ever be permitted to exclude the presentation of a litigant's defense or stand. Then, Malas, 5 lines later, where the statute is silent about the observance of the principle of natural justice, statutory silence is taken to make compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express words of statute or necessary intendment. Its aim is to secure justice or to prevent miscarriage of justice. Principle of natural justice does not supplant the law, but supplement it. Then, Malas, look at the argument of RBI. Malas, I had the privilege of arguing for the respondent, which succeeded. RBI and lender banks have contended that the principle should be excluded in cases where there is promptitude or exigent action. Then, Malas, I'll skip that and come to Malas, para 74. Swadeshi, they Malas, distinguish and apply, they do both things, Malas. Then 78 is Kesari. Now, Malas, now this is on that investigation. Your Lordship doesn't need to actually give natural justice in that sense, is the commonly assumed belief. But they said, no, you must give all the material. Please see. In Keshav, this court was dealing with the issue of takeover of the company after completion of, I mean, these are much minor cases compared to what is happening to this man here, the petitioner. Much more minor, I would say, in relative terms. Completion of a full investigation into the first. The issue was whether the report of an investigating body appointed by an administrative authority should be made available to the person concerned before the authority takes a decision. Your Lordships could brush aside a case diary. It's an investigating agency. Don't give it to it. What does it matter? No. The court said, no, you must give it. We'll just see page 41, where they say, unless the report is given, the party cannot make any effective representation about the action that the government takes to pursue. Malas, what I would have said in addition regarding R4 and 5 is up to me. You never gave it to me. Then Swadeshi again is cited. Then Malas, Tulsi Ram Patel is 80. I will skip that. And Malas, then come to straight away 81 onwards, Malas, and then finally 89. You put here 89, suddenly 85. 85, Malas, is fairness in action. Now, this is a larger principle of natural justice. Is it fair? What is this tearing hurry if you've got 12 other complaints or 6 other complaints pending? Why this tearing hurry? This is all your holistic approach. The Lordship, the writ court looks at it holistically. Fairness in action requires that procedures which permit impairment of fundamental rights ought to be just and fair. The principles of natural justice have a universal application and constitute an important facet of procedural so-and-so. Violation of Article 14, etc. Now, the natural justice is not part of Article 14 in the early years. Now it is part of Article 14. The most powerful article in our Constitution, I would say even higher than 21 is 14, but at least on par with 21. 14 and 21 are the two Malas, most biggest Brahmastra which this Constitution has. Then Malas, para 89, your Lordship says that even a statutory provision should be read to lead in favor of natural justice. On the other hand, that's 89. And then Malas, CB Gautam was Malas, is a very good example. Your Lordship knows 20C, now it's gone. Compulsory takeover of property.
Yes.
Why should you have to give notice, Malas? You are almost dealing in a quasi-penal context. You are Malas saying something is wrong with your income tax returns, we are taking over, etc., undervaluation. Still, And this was completely not there in the Act 20C, which was introduced. See what the court says, para 90. Whether a show cause must be issued to an intending purchaser and seller of property before making a compulsory purchase. Chief Justice Kania said that where the validity of the provision would be open to serious challenge for want and opportunity to be heard, courts have read such requirement into the provision. And here you have a judicially reviewable. Well, what is the point of a judicially reviewing something between the governor and your lordships? The man affected has no role in it. What is the judicial review lordship will do? Malas only just whatever he has said, your lordship will sit on that. He has no malas. The learned judge will have no inputs from me to the governor. And then malas, it goes on. And then ends malas in please. And then malas, they ask you in 94.3 and 94 to say you must first follow the fairness, then pass a reasoned order. Now see that 93. It has been elucidated in the preceding paragraph that the classification of a borrower's account as fraud in accordance with the procedure laid down in the Master Directions on Fraud entails significant civil consequences for the borrower. Since the Master Directions on Fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account, the rule of odd alterum partem has to be read into the provisions, etc. Then, before concluding, we also want to address the argument by the borrowers that the requirement of passing a reasoned order must be read into. They relied on JAR developers where it was said that this must be made by a reasoned order. And then, they say, of course, you must give reasons. But of course, it's not like I'm asking you to write a judgment. You're not a judge, but you must give reasons broadly. That is okay. I mean, nobody's saying that you're a judge who has to give a reasoned judgment. Well, to the same effect is the more general case, which has been cited now in all your lordship's cases, including this one, Dharampal Satyapal. That is 2015. In the compilation, it is the previous one, 2015, 8 SCC 519. Para 27. It's a frequently cited judgment.
Yes.
It brings to speed all the case law on this. Now, one of the other facets is, what does it matter even if you heard me, the result would be the same. Lordship is dealt with long ago. Now, even if you hear me, result would be the same. Why should I waste time hearing you? See, 42. Important question posed by Mr. Sarabji as to whether open to the authority which has to take a decision to dispense with the requirement of the principle of natural justice on the ground that affording the opportunity will make no difference. To put it otherwise, can the authority dispense with the requirement of issuing notice by itself, deciding that no prejudice will be caused to the person against whom the action is contemplated? Answer has to be in the negative. It is not permissible for the authority to jump over the compliance of natural justice on the ground that even if hearing had been provided would have served no useful purpose. Because Gandhiji's old dilemma, means and ends. He always insisted on the means, fellas. Ends are okay, but means, that's important. Then, 43, they again affirm that principle of prejudice. One is that no difference would happen. Second is prejudice. Both are affirmed. We still need natural justice. And then it goes on, to deal from para 41 onwards to 44. And ultimately, they give primacy to natural justice. Now, my next point relates to as a reminder for 2 minutes only of the very remarkable dates in this case, which your lordship noted with me last time. Lordship notes will bear it out. There are very few dates. May I just remind your lordship of those 6-7 dates? Correctly typed? Well, I had oralized it, your lordship, and
Yes.
I've got a 1-pager just to put it on this here. Give to other side also. Same person.
Yes.
Well, these are all in Kannada, but of course we have Kannada experts here. Well, 1992 is the notification. 98, it is denotified. And was right through, not a single file.
No. What happened after denotification?
This will what is coming up. It's coming up. I'm just saying one general thing, Manoj. Not a single file came to him in any capacity as Chief Minister, Deputy Chief Minister, or the relevant minister.
That
He was never holding that portfolio. Never. Survey is denotified through the government notification. Then Manoj, 3 is 2004. Records show the change of land ownership from Devaraju. Manoj, first was Ninga. Ninga's son is Devaraju. And finally comes Mallikarjuna Swami. Now, Ninga and Devaraju, which is for 20, 30 years earlier, have no connection, no relation with the Chief Minister. None. In Malas 2004, the sale deed comes to my brother-in-law, whose name is Mallikarjuna Swami. That is 2004. So the entire sequence of denotification, purchase in auction, denotification, acquisition, etc. is all Malas before it was anything to do with me at all, with my family also. Much later in 2004, this fellow's brother-in-law buys it from sale deed. Then 2005, conversion is done. Gift deed comes to my wife in 2010, his sister. And then in 2014, an application is filed to allot an alternative area because no compensation, because the admittedly that whole thing has been used or otherwise encroached upon, etc., or dealt with. So they say, look, this whole thing will to reverse the whole thing and to give pristine land again. Therefore, alternative is asked. It is done for a large number of people, and then 2020 and 2022, the sale deed. This is the broad picture. Today, you are having in 24 some kind of a outburst as if some massive scam has happened, which is not open to anything. This is just a perspective. I repeat, with great respect and humility, and this is important, I should have said so in the beginning. And I'll be making it as the first point in my rejoinder when I file it. I am always dealing with these facts on and off because I don't want my lords to feel in conscience that I'm suppressing or avoiding anything. But I'm very clear that these 2 counters we have received yesterday in day, full of facts, as if your lordship is hearing a criminal trial. Now, my respectful and humble submission is that I am not required to answer a single fact. Don't misunderstand me when I give your lordship these dates. They are landmark dates. I am A, not required to, B, I am not obliged to, C, I am not going to reply to these facts. Why? Because the issue is the sanction.
Yes.
Now, I am not required to do that because the validity or otherwise of the sanction depends on the argument of the applicant, the argument of, if I may call myself the non-applicant or the objector, and the governor. There is no list in a counter affidavit in the High Court that your lordship will give a civil or a criminal decree on these facts. Your lordship will pass a criminal law order. Your lordship will find a guilty. Your lordship will give a civil decree. This is not the job. Question is what you are today, this is important, Malas, what you are today arguing in these 2 objections full of facts is not what the governor did. Is not what the governor did. The governor passed a simple 4-page order. Today, you are not a super governor to justify that governor's order by giving all these facts.
No, it is on the basis of their requisition sanction is granted.
Correct.
So they are defending.
No, of course they will defend, I understand. But I'm just saying, my necessity to rebut individual facts, to say that, look, this is criminal, this is not criminal, this is culpable, this is not culpable, doesn't arise. Because your lordship has no reasoned order. Yes. Suppose one of the governor had passed a reasoned order. Lordship has dealt with many cases like this. Sanction is not a new thing. Governors pass reasoned orders. Then possibly I'd have to say, look, this is where the governor has said 2 + 2 is equal to 5. And he's wrong. Because on that date, I did not exist or something I could say. But there is no need for that because there is nothing to, I'm not here to answer a list on a civil or a criminal side with the private people, complainants. That's the perspective I'm urging my lords to keep in mind. So whatever I say, I say it really more from the purpose of disabusing and creating the fact that your lordship is, I'm not keeping away anything, but not because I'm obliged to or required to in this proceeding to answer anything. The facts, otherwise, just to end on the facts, show the overriding point that public servant whom you are seeking to prosecute. Has your lordship ever seen a public servant? And now, of course, we have repealed that section also in the PC Act, where for this long period when this person was born, this brother-in-law, in which year? Which year the brother-in-law by? 2004 till now. I have never dealt with the file. I'm not the portfolio minister. I have never passed any order, and the decisions taken of denotification otherwise have been passed for a number of people, not for me alone. And yet after 20 years, 24 is 20 years after 2004, this is happening. So that has to be kept in perspective. No, no. Now, the other aspect is, this 218, your lordship's old 197.
Yes.
Broadly. Now, my short point, this is more or less what I said earlier, because nothing major has come for me to deal with in the counter. But broadly, the points are threefold, if I may ABC tell your lordships. The granting is under 218 also at page 47. The lordship noticed that last time,
Yes.
page 47 specifically. Now, this section has to have some specification of the ingredients of the offense. What offense, how offense, which way the ingredient of that section is fulfilled.
That's
before you
quasi
get-
sanction.
That's right. So, I'm just saying that specification is nowhere there. I am not concerned. I'm not saying that you had to grant. You didn't have to grant. It's possible to say, I don't have to grant now, I'll grant later. That's not what he's saying. He has granted. My question to myself is, he has granted on what? Well, the ingredient, I say 420. So you have to say that I'm granting for 420 because in this way I came to him, I represented to him or misrepresented, I got movement of property, etc., something. There is nothing. It's established that 218, etc., must make out the attempt to make out at least the ingredients of the offense. That is missing. That's separate, and independently as fatal as the submissions I have made, regarding 17A.
Yes.
Now, I'll just end in a minute. Give me. May I say that since I've argued most of the matter, let me just note the paras. It's a
Of-
more
of the
intellectual.
judgment?
No, so I've done with the matter. I'm just, since it's more of an intellectual thing, I'm not arguing it. But this submission that he's not bound at all may be a larger legal issue. which
Not
your
bound
lordship
of
may-
what?
By the cabinet.
That will.
Let me oralize it for
So
lordship.
that's a
I'm
prima
not,
facie, we will see.
Yeah,
Well,
yeah.
Yes.
but only why I'm saying it, I'll tell you. There is a judgment of MP establishment which suggests otherwise. As simple as that. My learned friends rely on that. Now, Nabam Rabia, which is a constitution bench,
Para 156.
is the conclusion.
Yes.
But it cites, the conclusion says you can only act in your own discretion in 3 cases. It lists them. I read you last time, 156. 155? 155.
155. right,
Now,
yes.
admittedly,
Yeah.
this doesn't fall on those 3 on the text. Clearly. Now, MP is also 5 judges. Nabam is also 5 judges.
Yes.
Nabam is later.
Later.
But Nabam, with the conclusion in 155, saying only these 3 categories in which we don't fall, cites MP in 7-8 paras. Just note the paras because it's a very long judgment.
Yes.
140 to 142.
Yes.
You don't say what these paras are. I didn't say stop in between the sentence. I'm sorry, but just cut out that para. It is cited in the following paras, 116, 118, 128-29, 315, 317, 2 more paragraphs, 326 and 337, and lastly 362. Now, a later judgment citing the earlier one And my lords, coming clearly to a conclusion in 155, which categorizes three things where we don't follow. At least the High Court, my lords, should prefer to follow the later one, but that at the moment I don't argue. I'm just pointing out that not that, my lords, it's a frivolous argument. I'm not that, my lords. Yes, yes. And my lords, your lordships have, of course, this is obvious, my lords, I don't need to, a 5-judge full bench of your lordships, Karnataka High Court, said that when there is some apparent variance between an earlier 5 judges and a later 5 judges.
Later will prevail.
And you will follow that. That's your lordship citation of 1979.
No, that's-
SCC online. Many of them are there. Whereas I would therefore say that, of course, reserving fully my right to not only file, but to argue a rejoinder fully. This case is a fit one, whereas this sanction cannot be there.
Yeah.
What they do in future, what they find, what is applied, etc. This sanction must go. This sanction actually can and should go on the admission of some of the complainants themselves. But whereas that apart, I'm not dependent on their admission. Your lordship is entitled to say on both counts. It's not that your lordship can say because of those reasons it doesn't stand, but I otherwise go into it, otherwise also find this. This sanction is, well, it must go for the separate reason that there is no reason. None at all. Those balance are my submission, very deeply obliged. I reserve all those rights
All right,
because
yes.
I'm sure some, in the light of my arguments, your lordship rarely has that I finish my argument. Then a new
No, no,
counter
you
will
can-
come,
you
and a
can
new
explain-
angle will come, and that new angle I can't do, so therefore
No,
your
that's
lordship
all
got there in
right.
mind.
Yes, anyone today or
Well, I am ready, my lord, but if the Solicitor General, my lords, it would be appropriate if lords
is
hear
is
him.
there?
I have a
Yeah,
suggestion.
my lord, I'm here, my lord. Am I
I have a
audible?
suggestion which on one of the rare occasions, Mr. Mehta may agree with, I don't know, Manas. It may be a rare day, but he may agree. Well, Saturday, I'm told is a working Saturday for.
Yes. It is.
This Saturday.
Mutual benefit.
Yes, this
yes,
Saturday
this
is a-
Perhaps you did
Saturday.
not know, Mr. Mehta, so your agreement will be in our mutual benefit.
No, I don't go by the benefits, Dr. Singhvi, but Saturday is fine with,
Saturday is fine.
Saturday is fine.
subject to Mr. Maninder Singh is also appearing, my lord, my learned friend.
Where is?
Somebody can start. Manas, let it
Yes,
go on.
yes.
I may be
Finish.
permitted to start. Please.
It won't finish anyway, so then.
No, Mr. Singh, would
Fine.
it be possible?
Saturday is fine. No
Yes,
difference.
yes, Solicitor General's convenience is important.
Can't hear.
So that is 20.
First.
Now, whoever wants to submit, then you will have to resubmit on when the rejoinder is filed if needed.
Please, correct.
But what if you want to submit, you can submit.
Yes, please.
We are talking of this Saturday, 31st.
Yes, this
31st, yes, my lord.
Who are you? Intervener? Intervening as what? Petition? For what? Your fundamental right, who has taken away? So first, what is your right that is taken away? Hmm.
Can I interrupt for 30
No,
seconds?
this is not.
There's an old saying, Malas, sometimes, Malas, your friend can be your worst enemy. Please don't think that I have set up anybody, Malas. I'm not interested. The problem is, Malas, anybody comes and argues, people blame me.
No, I don't think you,
No, that
I don't
happens.
think you need a friend to be set up.
No, Malas, a friend is worse than an enemy sometimes. That has happened many times in litigation.
Where does this road lead to? The caterpillar would say, you don't know where you want to go, it would be there. We'll see, we'll hear. Not in this, it is, no, not.
Lord, if lordships are to start hearing us from Saturday.
Wait, sir, damage will be caused to the state.
No, I would assist the
That-
court on behalf of
No,
the
no, sir.
governor. Thereafter, Mr. Maninder Singh is there.
We are not hearing a PIL here. It's an order of the governor that is called in question by the person against whom the order is passed. Ah. All right, we'll see. Wait. No, your application is, you have filed it. We'll consider it. Yes.
If Saturday, my lords, if the Solicitor General wants to start,
Huh.
it would be appropriate, my lord, that he
Yes,
finishes
sir.
it and thereafter I continue. Yes,
Is
but
there?
if he
Mr.
has
Maninder
something-
Singh is
he'll
also
argue.
there.
We are ready.
Let it be
Whoever-
10:30. I will complete and Mr. Singh can start.
Yes,
Please.
Today,
No, my lord, Saturday, my lord, if you allow.
Saturday, all right.
deeply obliged, deeply obliged.
10:30, my lord, can it be at 10:30?
We'll start it with 10:30 and conclude it. Yes.
Please.
And all of your, the rejoinder later on.
Well, Legion will have to be later because they will be having a lot of things, but
I
one
know.
day more I'll finish it off. One day more.
That's all right. Yes.
So
I'll
Saturday,
take account of everything and make my note also accordingly.
Yes. Let
As
the
single
respondents,
note, yes.
respondents finish.
Yes, yes.
Hope all of you will finish on Saturday.
as much as possible, we'll finish Saturday.
All right.
Just be allocate time for us, so that we know how much time we'll have.
It's all right.
Each of you.
No, it's all right, my lord.
Each
We'll,
of us will not allocate.
All right. I don't think each of you are saying something contrary to each other.
no,
Then-
Absolutely not.
but two broad issues, my lord, we will address that, subject to what there are and Solicitor.
No, then Solicitor General will start first.
He'll start.
And all of you will
We'll follow.
next follow. Yes. Then we'll do it on Saturday.
Yes.
Yes. Heard, that I will do. That we will do.
Grateful to your lord.
Heard the learned senior counsel Abhishek Manu Singhvi, who has completed his submissions for the present and would reserve his right of rejoinder submissions. Once the submissions are concluded by the respondents, the learned Solicitor General submits that
Saturday.
the matter would be taken up on 31st. He would complete his submissions on the said date. Records may be required, sir.
I will keep, my lord, my record present.
Yes,
which
sir.
can be-
Would complete his submissions on Saturday. List the matter on Saturday at 10:30 a.m. Interim order granted on 19/8/2024 shall continue till the next date of hearing. Yes. Wait, yes.
One of the record, including the other application, status of the other applications also, your lordship.
What applications?
You have produced 4 other complaints which are pending.
No, every record will be produced.
Not only passing of this order, my lord.
Oh, you mean from the office of the governor?
Yes, yes. They had said,
Plus
my
4
lord,
applications also. What
I
is
have
the
named them.
status
I have
of
named
those?
those applications.
No, I'm unable to see who
That
is
is-
requesting.
That is for the perusal of the court. They will do it.
The
Yes.
perusal of the court, my lord.
No, it's my contention, so lordship can peruse it, of course.
We'll answer.
My
But it is
contention
a
is writing.
state has nothing to do with this, my lord.
Governor
Accused,
has everything to do with it,
potential
my lord.
accused and the
is
governor
the one who
will.
has passed the order, sir.
The complaint that have been referred to by Madam Secretary are under 19. They are not under 17
No, I asked the senior counsel that they are all after investigation
Exactly.
and wanting sanction to file a charge sheet.
So there's,
No, the problem is 218 is also referred. That's the reason.
Lord,
And he would say 218 is referred for the reason that IPC offences are there in that.
That
in
cannot
fact,
be
That should be submission.
Lord, much emphasis, my lord, was laid on pendency of sanction applications, my lord, in connection to 4 legislators, my lord. Now, my lord, pursuant to the dictums laid down by the Honorable Apex Court, my lord, what precluded, my lord, my learned friend, my lord, the Chief Minister of the State of Karnataka, my lord, to, my lord, pass directions to approach this Honorable Court seeking necessary directions to the Honorable Governor, my lord. No, my lord, because the governor was termed as a friendly governor. Now, my lord, with all liberty, I would call the Chief Minister as a friendly Chief Minister.
To those complaints.
Chief Minister,
Certainly.
my lord, unlike the governor.
Certainly. Now, my lord,
Friendly to the constitution.
my lord, they have quoted pendency, my lord, since so many years. My lord, nothing
No,
precluded
let's
them.
see what is pending and what is not pending. The office of the governor would place the files. We'll answer. A contention is taken, we'll answer it.
Please.
That's all right. That doesn't mean we play.
No, my lord,
you
now
want
this
to play
vote
a
is
friend-
acting on your head.
No, it doesn't mean you want to play a friendly match here, right?
Certainly not, my lord.
Now, can I make one request? Can your lordship accommodate me on Monday? The others can argue. So, but I am.
All right, let them finish. We don't know how much time everybody would take. Then when senior counsel Singhvi would again come back, that's on Monday, sir. Monday or Tuesday, whenever you want. The same day we will,
Convenient on Saturday, that's reason.
you would require 30 minutes.
No, but I require about an hour.
Huh?
I require about an hour.
All right. So 1 hour each will allocate them. Yes, sir. we'll take it on
Saturday.
Saturday. Yes,
Grateful to your lordship.
this on Saturday at 10. And General Counsel Maninder Singh sir is also there.
Yes,
That is for whom?
one of the, I think,
He's appearing
complainants.
for, I think,
One of the complainants.
Complaints, all right. Yes. I will record presence ಎಲ್ಲಾರ್ದು record ಮಾಡಿ madam.
I think, sir, ನಿಮ್ ಜೊತೆ ಸಾಗವನ್
ಯಾವುದು?
ಫಿಫ್ತ್ ರೆಸ್ಪಾನ್ಸ್, ಫೋರ್ತ್, ಥರ್ಡ್
Who? R3 is appearing party in person.
My lord, there was an IA filed, my lord.
You filed an application?
We are not pressing that application.
Not pressing.
Please.
IA 2 of 2024 filed by the respondent in person. R3 nadu?
Please.
R3 in person. The respondent in person would submit that he would not press the application seeking to appear as a respondent in person. In light of the said submission, the application stands disposed as not pressed.
Much grateful.
Obliged to your lordship.
Yes.
Grateful.
Madam. Yes, sir.
Please.
On Saturday at 10:30. Then we have the list still. ಎಲ್ಲಾರ್ದು ಕೊಡಿ. Give all the list. Don't miss out anybody like last time. Give all the list. And whenever you give list of authorities, I have time and again told you, you should mention the paragraphs in the index. Correct that and mention paragraphs in the index and give. I did not want to tell it in front of senior. Yes, do it. Madam, ಬೇರೆ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಾ ಇದೆಯಾ?
Next one, continue.
Lords, till number 41. Lords, I pay for the petitioner, Lords, challenge is the proceedings and for the offense punishable under section 27C of Drugs and Cosmetics Act, Lords. There is no compliance of 23(4) of the Act, my lords, in so far as.
One minute, madam. Madam, ಇದು ದೇಶಿ ರೆಡ್ಡಿ ಇತ್ತಲ್ಲ ಎಲ್ಲ. ಅದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಜೊತೆಗೆ. Yes, heard the learned counsel of ಇದು identical matters ದೇಶಿ ರೆಡ್ಡಿ ಅವ್ರದ್ದು drugs and cosmetics. Along with that, we will hear. Heard the learned counsel appearing for the petitioner. List tag this petition along with the numbers she'll give you. Tag this petition along with. Post it for further hearing. Interim order subsisting shall continue till the next date of hearing. At the hour date is ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಹಾಕಿ. There are similar issues with this. Yes. ಯಾವತ್ತಿದೆ? 4 ಪಂದ್ರ ಜೊತೆಗೆ ಹಾಕಿ.
Then 42.
Petition, my lord. Press for time.
Press for time, no grants time. Yes.
Senior operation agide.
Why time?
Senior operation agide, madam.
Operation.
Yes, my lord. My entry matter extend.
The learned counsel appearing for the petitioner submits that His senior is indisposed due to surgery. List this matter after 2 weeks. Interim order granted earlier stands extended to the next date of hearing. Yes, Avinash.
I appear for the petition, my lord. Petitioner is a complainant, my lord. 138 proceedings have been initiated, my lords. The tax is, my lords, we deceived the property, my lords. By paying, we were told to pay 7 lakhs as advance, my lords.
311 application.
311 application.
Iradil. Don't go on merits.
My lords,
It is rejected.
on the ground, only ground that we have not annexed the documents what we have to produce in the reason for recall, my lords. On that ground, it has been rejected. My
Where is the
lords.
respondent?
Morning, they were present, my lords.
Morning they were present. When is the next date?
Tomorrow, my lords.
When is the next date? Not my date, sir. Court,
31.
trial court al nale idea.
Please, my lords.
I will take it tomorrow. We'll take it on Tuesday. Heard the learned counsel appearing for the
There is no
petitioner.
stay
List the matter on Tuesday in the fresh matters.
There is
Till such time further
my lord-
proceedings before the concerned court
My
shall
lords,
remain
there
stay.
is no stay application.
Application ilva?
Application.
ಯಾಕ್ ಹಾಕಿಲ್ಲ?
It's our case, my lords.
ಬೇಡ. List on Tuesday in the fresh matters.
Monday, my lords.
ಪರವಾಗಿಲ್ಲ, Tuesday.
Please.
ಅಪ್ಲಿಕೇಶನ್ ಹೆಂಗೋ ಹಾಕಿಲ್ವಲ್ಲ? ಯಾವತ್ ಬಂದ್ರೆ? Yes, sir.
Please. Lord, after the conclusion of the evidence, Lord, the court Lord, allows a supplementary report
Covered by Vinubai, Kodi, sir.
covered by Vinubai. Lord, in fact, in Mariam's case, my Lord, recently, my Lord, which was referred to, even Vinubai was referred in that case. Lord, this is a case, my Lord, further investigation should be something new, my Lord. You cannot reassess an earlier.
Whatever it is,
please.
after the framing of the charges and commencement of trial, there cannot be supplementary charge sheets filed. Unless it is only producing a document in the name of supplementary charge.
Yes, yes.
One judgment, my lord, which say that what in case if the investigation officer has purposefully avoided or the accused make sure that the charges have been framed, trial has been commenced, and then
This court,
one
not
judgment
173. No, see Vinubai, 3 judge.
that I've seen.
Yes. It's the what the apex court says, the right freezes. Once the trial commences to file supplementary charge sheet under 173A to the CRPs.
No, but
Will Vinubai Kodi?
But I have not carried it.
What?
Sorry, my Lord. My Lord, in
1918
fact,
SEC page 1.
Oh.
Yes.
subsequently there's
my
one more
Lord,
judgment.
2023, I think what Jagdish is referring to, Lord, is that CBI matter in 2023. Lord, wherein, my Lord, it says that under circumstances, my Lord, it has to be assessed.
Vinubai is 3 judge
They
bench.
It's a 3 judge, please.
They have quoted Vinubai, my lord, and then they say that what in case is purposefully to defeat the.
No, then it goes on case to case basis.
That's
It
correct.
goes on a case to case.
Sir.
My Lord, in this case, my Lord, there are directions given by this honorable court.
Hmm.
Lord, wherein the court has to give a finding as to why that is required. Lord,
What is required?
why the additional charge sheet is required.
Now, what has happened now?
My Lord, what the learned magistrate says, Lord, he says whether or not that charge sheet is having any prejudice on the accused is a question which has to be determined because the accused gets an opportunity to cross-examine. Lord, against, my Lord, the directions given by this honorable court.
Oh, you are referring to page 62.
My Lord, page 77, Lord, criminal petition 5702 of 17, dated 8/2/18, my Lord.
Justice Panindra avardala.
Justice Panindra avardala. My Lord, para 7 at page 76 and 77, my Lord. Page 77. At first, the court has to consider the relevancy of those documents. And thereafter, the question is as to the admissibility of such documents and then reappreciation of the evidence.
Were the same parties?
Please, my Lord, in this very same case.
Yes.
And my Lord, the order of the learned magistrate, Annexure K,
Page.
page 86, my Lord. At para 17 at 87. Mere producing the above said documents at a later stage would not cause any prejudice to the accused because they are always at liberty to cross-examine the persons who have issued the same during trial. So far as appreciation of evidence placed on record by either of the parties arises only after trial, and that too at the time of passing the judgment. Therefore, I am of the considered opinion that the documents produced by the IO, along with the additional final report, has not violated the above said circular and are also not prejudice, cause any prejudice to the accused. Hence, I answer the above points in the negative.
He has not taken the.
Please, my lord, the directions of this honorable court that you have to give a finding in view of the circular.
In Jagdish Ore, in the other case, you filed, 173(8) supplementary charge sheet was filed only for the purpose of production of a transcript CD.
Yes.
65B certificate ಬಗ್ಗೆ ಇತ್ತು, but I said that could be produced that as a document because he objected to it. Here also what is asked is production of documents. Would it be termed as a supplementary charge sheet or it's only production of documents, no other mode of producing documents?
It's a supplementary charge sheet, my lord, is only the form of saying.
That is what, are we going by the title or what is done?
It seems to be, my lord, it says that only documents have been produced.
My lord, this is a case, my lord, where a government agency gives a negative report on the documents, but subsequently, my lord, they get it done by a private lab.
We'll answer this.
Please.
Again, stay there.
Stay there.
The issue of
may have to-
private labs, my lord, that this court
A
also.
truth lab though.
This court also has issued a direction not to go for private labs. Pursuant to that, there is a circular issued
So
by.
merely because it is titled Truth Labs, should we take it as truth?
No, that's where, my
The
lord. that-
private lab.
That's where, my lord, this court has warned the police officers not to.
Why do these police officers go to Truth Labs every time? Every case I see it.
Yes. In fact, there is a circular also issued to that extent saying that
ಅದನ್ನೊಂದು ಬರಿಬೇಕಾಗುತ್ತೆ. Departmental inquiry initiate ಮಾಡಬೇಕು if these are.
probably something like that.
Illa, on the basis of that circular and that judgment itself, my lord, Justice Panindra, my lord, directed the magistrate to look into it.
Not look into it. We will direct investigate the departmental inquiry against his investigating officers who refer it to private laboratories. ಅದು
What they
ಯಾಕೆಂದ್ರೆ in your FSL 2 years, 3 years reports ಬರೋದೇ ಇಲ್ಲ.
That is one of the reasons.
FSL should be strengthened, sir. There should be increase in number, increase in so many cases, FSL remain the same.
That is one of the reasons they go. But
That also
unfortunately-
should increase. Otherwise, if it doesn't increase, then this is the problem.
In fact, one of the case, my lord, which the CID has investigated, properties which was seized by the court, mobile phones, another thing which was sent for extraction, have been sold to somebody else and those mobile phones.
That is why when you give it to private labs, there's no accountability. That will see. It will stay.
In fact,
ಇದೆಯಲ್ಲ?
stay there.
Then answer
In
ಮಾಡು.
fact, my lord, what is further investigation again? My lord, you cannot unearth an already which you have investigated. It has to be something new. My lord, in fact, in that CBI judgment, I think which Jagdish is referring to,
No,
Lord,
no,
what the
fur-
apex court says,
Further investigation, when is directed by this court, it
Yes.
can start the whole hog.
yes,
Not
if
there.
it is directed by this court,
Not there under 173.
yes,
No, but-
under 170, if it is something new, only then they can do it.
73 also says, my lord, if the moment you come across with any document, there is nothing precluded the investigation is to place it before the court. It is like dead man walking.
If it
straight.
is something new, they can do it, my lord. But if it is revisiting an old thing, so re-investigation,
Let's-
PO or
Not
this thing.
permissible.
21st will answer. List on heard land counsel for the petitioner, learned additional SPP. Yeah, respond private ಯಾರಿಲ್ಲಲ್ಲ?
Illa, it's a state.
List on 21st in the fresh matters list, 21st September. Interim order subsisting will continue till the next date of hearing.
Grateful.
Yes. Yes, madam. 45 ನಿಮ್ದೇ ಅಲ್ವಾ? Vandana is your name?
47.
Invite ಮಾಡ್ಬೇಕಾ?
I'm sorry, my lord.
Hmm.
We were under the impression it's 147.
45.
47, I'm sorry.
ಅಲ್ಲ ವಂದನಾ ಪ್ರಿಯಲ್ is her name, right?
Yes, yes, yes. My lord, the wholly, my lord, even by factual bounds, my lord, covered by
306, sir.
David D'Souza's judgment. In David D'Souza's, my lord, the words that were uttered, go and hang yourself. In this case, go and die. Aste, nenilla. By facts, my lord, it is a tailor-made, my lord, case to be applied to my lord, to be traced to David D'Souza.
What were the facts?
Kindly, my lord, see the facts. Only so much, my lord, all that ಮದ್ವೆ ಮಾಡ್ಕೊಂಡ್ರು, ಜೊತೆಲಿದ್ರು, ಎಲ್ಲ ಆಯ್ತು. ಮದ್ವೆನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸೋದಕ್ಕೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತು. 2 ಸಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ ಹೋಗ್ತಾರೆ. ಫಾರ್ ಸಮ್ ರೀಸನ್ಸ್ ದ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಡಿಡ್ ನಾಟ್ ಹ್ಯಾಪನ್. ದಟ್ಸ್ ಆಲ್. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಕಾಲಮ್ ನಂಬರ್ 17, my lords may kindly see. This is all, my lord, happens.
Page 27.
Yes. Registration ಹೋದಾಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಲ್ಲ. ಫಾರ್ ಸಮ್ ರೀಸನ್ಸ್ ದೇ ಕೇಮ್ ಬ್ಯಾಕ್. Admitted, what is also admitted is both went for registering the marriage. They were living together, ceremoniously married, everything, my lord, is admitted.
Ceremoniously married.
ಅಂದ್ರೆ ಈ ದೇವಸ್ಥಾನದಲ್ಲಿ ಹೋಗಿ
ಹಾ.
ಸೆರೆಮನಿ ಮಾಡ್ತಾರೆ.
ಹ್ಮ್.
Statutory marriage was to be registered for the purpose of them, my lord, traveling abroad.
ಹ್ಮ್.
2 times they went. For some reasons, the registration did not take place. For that, there was, my lord, this my lord, altercation between husband and my wife cannot be given a color of, my lord, animosity against each other.
So who else can it be given against?
That too, my lord. I can understand, my lord, the husband and wife were so estranged, falling apart, my lord, so dangerously that a bouquet of cases come in. 1 DP Act, 1 divorce petition, 1 498A, my lord. This is not such a situation. She dies, my lord. In column number 17, my lord, only thing what is said is only so much, my lord. Mananondu, last, my lord, paragraph on page number 28, my lords may kindly see. Maduveya Nantara, page number 28, my lord, only 4 lines I'll read, my lord, on the extreme right column. Maduveya, second line, Maduveya register ide endu heli, ಆರೋಪಿಯು ಬೆಂಗಳೂರು ಮದುವೆ ರಿಜಿಸ್ಟರ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು, ಈ ವಿಚಾರವಾಗಿ ಮನೆಯಲ್ಲಿ ಆರೋಪಿ ಮತ್ತು ಸಂಗೀತಾರೊಂದಿಗೆ ಜಗಳವಾಗಿದ್ದು, ಆರೋಪಿಯ ಪತ್ನಿ ರಾತ್ರಿ ಸುಮಾರು 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸಂಗೀತಾರನ್ನು ಒಬ್ಬರನ್ನೇ ಬಿಟ್ಟು ಮನೆ ಬಿಟ್ಟು ಹೊರಗೆ ಹೊರಟು ಹೋಗಿದ್ದು, ಈ ಎಲ್ಲ ಕಾರಣಗಳಿಂದ ಮನನೊಂದು, my lord, mananondu can never be, my lord, an allegation against, my lord, the husband. As per 306. By facts, my lord, this case, my lord, traces to David D'Souza, where, my lords, said, I can understand, my lord, if there is anything enigmatic, as my lords, employed.
Human mind is an enigma.
That punching words, my lord, which is being which is being celebrated by the bar in many of our draftings. I can understand, my lord, if there is any such enigmatic my lord, intentions, animosity, you will satodre nanigeno labha agutte. There is nothing like that in this case. Inviting 306, my lord, could be, my lord.
ಮತ್ತೆ ಮದುವೆ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಇಲ್ವಾ?
I am also mourning the death of my wife.
How long, sir? This is 2023. Still mourning.
In fact, my lord,
ಅಷ್ಟೇ, ಅದ್ರ ಬದಲು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು. ಮೌರ್ನ್ ಮಾಡೋದು.
ಹೋಗಿದ್ವಿ. For some reasons, my lord, the sub registrar says, it's like, my lord, I am not buying her a chocolate, she gets, my lord, sulkiness, my lord. And kindly see, my lord, she has always been in the habit of nan satogtini, and she would even send me on WhatsApp, my lord, I have appended that pictures. ನೋಡು, ಈ ತರ ಗಂಟೆ ಹಾಕೊಂಡ್ರೆ ಸಾಕ, ಇದು ನೇಣು ಹಾಕೊಳ್ಳೋದಕ್ಕೆ, ಈ ತರ ಎಲ್ಲ she used to, my lord, joke around. That's the charge sheet material. Charge sheet, in the charge sheet, the police would.
No, don't joke around. You lost a life.
In fact,
Yes.
my lord, I was not joking around. She used to send me, my lord, who would take it seriously? Every time I'd say, I will die today, I'll do this. If you don't come early home, I'll pierce myself. My lord, this is, my lord, something like this, my lord, enters into, takes a next level. My lord, husband cannot be held guilty for, my lord, 306.
I ask again, who else?
Could be, my lord, as your lordships rightly said, my lord, it's enigmatic.
No.
My lord, how a man's mind could be enigmatic, a lady's mind, my lord, is 10 times more enigmatic, my lord, than a man. In fact, my lord, men are never enigmatic as such. I think Jagdish would concur with me on.
They are only pragmatic,
That's a caste.
not enigmatic.
That's a sexist remark.
That's not correct, sir.
Depression allidru ಅಂತ ಹೇಳಿ ಬಹಳ ಸಲ treatment
No
ಮಾಡ್ಸಿದ್ದಾರೆ.
statements about man or a woman here.
I'm sorry.
They are equal, yes.
Your lordship may see the WhatsApp messages which they have attached along with the petition. He appears, my lord, he used to lock her inside the house and then go. She pleaded him, asking to come and open the door.
Could that be a reason for 306?
That's where human mind is an enigma. You don't know what propels commission of suicide. It may be in the spur of the moment, it may be factors that are lying dormant and burst like a volcano.
I understand.
Anything can happen.
I understand that, my lord. How careful, my lord, husbands, my lord, will not be the keepers of a glass jars, my lord. Every time, my lord, should I think, what if I say this, she might come. We are not keepers of crystal jars. We, my
No.
lord, treat them as wives. At the end of the day, my lord, if every small thing, my lord, if has to give
No,
me,
you don't
put
keep,
me on a caution.
no, you don't keep as a glass jar. You sit inside it. That's the whole problem.
If every, my lord, moment of my moments of my my life with my wife has to be so, my lord, cautious, careful. If I say this, what if she does, my lord? That's what is happening these days, my lord. The institution of marriage, my lord, is getting weakened because of all these things. What if I say, what will happen? Now, my lord, Jagdish is saying, because there is a WhatsApp message, there is some WhatsApp conversation, something which happened several days and months ago, my lord, is now being tagged to attach animosity. That too, my lord, abetment.
No, not some
Why would I?
cases,
Why would I enjoy, my lord?
Immediate.
My
What's your name?
kindly, my lord, see page number 105, my lord.
Gagan.
Gagan.
Whose chat is this then?
ಅವ್ನು ಅವ್ರ ಹೆಸರು ಈ ತರ ಸೇವ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ.
Allah, she saves him, my lord, with a nickname. In sir, adu nickname. Some, my lord, very
All right, leave it. Yes.
Kappe Raya. My lord, she herself admits, my lord, I am as innocent as a kappe.
Oh. We'll quash it then.
Kindly, my lord. If your lordship
Not
could
that. ಇದನ್ನ ನೀವು ಹೇಳಿದ್ದಕ್ಕಷ್ಟೇ. Yes, tell me.
kindly, my lord, have page number 105, my lord. I'll show this and, my lord, I leave it to your lordship's, my lord, discretion. My lord, there was such an incident on an earlier occasion. She would, my lord, give. My lord, I am not using it against, my lord, the departed soul. I am housewife, married 4 months ago. Husband was a software engineer. I was suffering from sleeping issue and anxiety issue, and I had also taken medicines in.
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಡೆತ್ ನೋಟ್ ಇಲ್ಲ. Previous history.
But there are
Previous
witnesses-
history.
Witnesses speaks.
Witness of what?
Their neighbors also speaks about their constant fight. CW5, my lord, at page 90.
How long were you married?
My lord, we were married 1 year.
Why did you not register it immediately?
In fact, my lord, we made such attempts. My lord, there are 2 ways of registering the marriage, as your lordships are kindly aware. One, my lord, we go and put up a notice, and after on a particular date, register it under Special Marriages Act. Secondly, my lord, we do a ceremonious marriage, and just for the purpose of record's sake, we register it with the Register of Marriages, my lord, which is a registration certificate given under the Hindu Marriages Act.
Solid. Whether that would amount to abetment, we'll consider.
4 months.
That's all, my lord, in this case. There is
Married-
nothing more.
Married for 4 months.
4 months.
4 months. Why would I have, my lord, any intentions of seeing my wife dead?
No, that may have happened. That's a different thing. It's not that.
If
you had-
there is
No, if
anything.
you had any intention, it would have become murder.
Howd.
So
Alla, if
It's not that.
witnesses also, they don't talk anything, my lord, any small, with regular fights between the husband and wife cannot be given a color of, my lord, leading someone to commit suicide.
No,
What happens, my lord, generally, it so happens, once the person is no more there, everyone, my lord, would give such statements, idagittu, adagittu, idagittu.
like how you are doing on the wife.
My lord, with great respect to the departed soul, but certainly, my lord, my lord, I'm not trying to, my lord, downsize anybody's affections, anybody's, my lord, emotions and feelings, but certainly not a case of 306, my lord. Hogi sai antu ಹೇಳಿದ್ರು. This is all.
ನಾವು ಇಲ್ವೇ ಹೇಳಕ್ ಏನೆಲ್ಲ ಆಯ್ತು ಅಂತ. WhatsApp communication speaks something else. You locked her inside, did not open the door. He asked her to come. She asked him to come and open.
No, the voluntary statement says otherwise.
There, all the voluntary statement, my lord, is there in the WhatsApp communication.
Yeah, whose voluntary statement?
My voluntary statement, which is made a part of the charge sheet, though it cannot be
Your
used for any
voluntary
other
statement.
purposes.
Your voluntary statement.
My voluntary statement, which is made a part of the, of course,
All
which
right.
cannot be used, which cannot be looked into for any other
How
purposes.
can it be used in your favor?
Yes, my lord. And
Yes.
the reason why I am saying, my lord, voluntary statements are those which have never been voluntary. It is, my lord, generally, the investigator writes something which, my lord, it's called a voluntary statement. If there were to
That
be
was-
something like this, the voluntary statement could have had something better.
Charge sheet ಇದೆಯಲ್ಲ ಅಲ್ಲಿ?
ಇದೆ.
No, but there are statement with page number 86, my lord, one of the witness. And marriage, my lord, it is not that marriage happened, but they did not, she insisted for registrations, and it is.
Marriage, you
Security.
married her in a temple?
Yes. At home. At home.
At
Which is
home.
all, my lord, accepted.
You live in a temple?
Alla.
Then? Marriage, you married in a temple ಅಂದ್ರೆ ಹೂ ಅಂದ್ರೆ at home ಅಂತೀರ.
ಅಲ್ಲಲ್ಲ, ಮನೆಯಲ್ಲಿ ಟೆಂಪಲ್ ಸೆಟಪ್
ಅವರವರೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಫೋಟೋಸ್ ಇದೆ, ಫೋಟೋಸ್ ಹಾಕಿದ್ದೀವಿ. If your lordships would kindly have, in the charge sheet, my lord, charge sheet material has, my lord, all these pictures. My lords, may kindly have page number 49, my lord.
65 is one such photo, madam. Marriage photo.
Page number 49, my lord. ಮತ್ತೆ ಲಗ್ನ ಪತ್ರಿಕೆ ಫೋಟೋ ಅಂತ 15 ಅಲ್ಲಿ ಅವ್ರ ಕಡೆಯಿಂದನೇ ರಿಕವರ್ ಮಾಡಿದ್ದಾರೆ.
ಇನ್ವಿಟೇಷನ್ ಇತ್ತ?
ಹೌದು. ಸಾಗರ, ಲಕ್ಷ್ಮೀ ಸಾಗರ ನಿಲಯ ಮನೆ. Generally, my lord, to be very honest, for the purpose of registering the marriage, my lord, post marriage, they ask invitation kodi, photograph kodi ಅಂತ.
Correct. Then invitation is just printed.
ಅದಕ್ಕೆ ಪ್ರಿಂಟ್ ಮಾಡಿ.
It's I wouldn't say, my lord, it's printed for the purpose of inviting.
No, it's not for the purpose of inviting at all.
ಇಲ್ಲ ಇಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲೂ ಅದೇ ತರ ಈ ವರ್ಷ ಏಪ್ರಿಲ್ ತಿಂಗಳಲ್ಲಿ ಮನೆಯಲ್ಲಿಯೇ ತಾಳಿ ಕಟ್ಟಿ ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದು ಅಂತ ಕಂಪ್ಲೇನೆಂಟೇ ಹೇಳ್ತಾರೆ.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
ಕಂಪ್ಲೇನೆಂಟ್ father of the deceased, my father-in-law.
Yes, Jagdish.
The witness, my lord, speaks completely.
Page 86 ಅಂದ್ರಲ್ಲ?
Page 86, my lord, one of the witness.
One moment.
ಶ್ರೀಮತಿ ರೇಣುಕಾ.
Neighbor ಇದು?
Renuka, my lord, is the mother of the
Deceased.
deceased. He narrates about the registration of marriage and he refusing to register the marriage. And then the neighbor, my lord, is at page number 90.
But ultimately it boils down to these statements. 12 ಗಂಟೆಗೆ ಗಗನ್ ಜಗಳ ಮಾಡಿ ಇಷ್ಟ ಇದ್ರೆ ನನ್ನ ಜೊತೆ ಇರು, ಇಲ್ಲವಾದರೆ ಎಲ್ಲಾದ್ರೂ ಹೋಗಿ ಸಾಯಿ.
Correct. And then page 90, my lord, one of the is a neighbor. He resides opposite to their house.
Let's see. Heard the learned senior counsel M.S. Shamsundar appearing for the petitioner and the learned additional SPP. List the matter on 21st September. Will dictate on that.
So
So
great.
further hearing.
So great.
D'Souza ಕೊಡಿ ಇದೆಯಾ?
D'Souza ಕೊಡ್ತೀನಿ. And I'll just give it to the court officer. ನನ್ನ ಹತ್ರ ಇದ್ರಲ್ಲಿ ಪ್ಯಾಡ್ ಅಲ್ಲಿ ಇದೆ.
Pad ಅಲ್ಲಿ ಇದೆಯಾ?
Since we envy your lordship's memory, my lord, we'll feel, my lord, guilty to give your lordship judgments.
ಹೇಳಿ ಯಾರು ಜಡ್ಮೆಂಟ್ ತರದೇ ಬಿಟ್ಬಿಟ್ಟಿದೆ.
ಹೌದು. In fact, my lords would have read every line of it and remembers it
Get that
also.
WP 48451 of 2023. 23 disposed on 22/4/24.
Then, my lord, I'll be scandalizing myself, my lord, if I offer a judgment of your lordships before your lordship.
22/4/24. 22nd April 2024. Disposal. ನೀವು ತಪ್ಪು ಬರ್ದಿದ್ದೀರಾ.
In fact, even in the previous matter, Sigvi was hesitating to read your lordship's judgments before your lordship, saying that is your lordship's judgment, we don't want to read. So great.
Next. ಇವ್ರು ಮೈಸೂರಿಗೆ ಹೋಗಿರ್ತಾರೆ. ಇವ್ರು ಮೈಸೂರಿಗೆ ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಎಸ್.
138 months.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ಅವ್ರು ಕಮ್ಸ್ ಫ್ರಮ್ ಮೈಸೂರಲ್ಲ, ಸಾಯಂಕಾಲ ಆಗಲ್ಲ ಅನ್ಬಿಟ್ಟು ಹೋಗಿರ್ತಾರೆ. ಸ್ವರೂಪಾನಂದ್ ಆಗಿಲ್ವಾ? ಯಾವ್ದ್ರಲ್ಲಿ? 46 ಅಲ್ಲ? ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. 47.
47, hearing for petitioner, a short accommodation given.
Why?
But due to some urgency.
Where is Swarup?
He's gone to another court, my lord.
You should get ready with another court.
No, he has gone to some other matter.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಮೇಡಮ್? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Okay, list after 2 weeks, yes.
Date may be given, my lord.
Date is today. Otherwise, date of the court. Yes, next. ಕರೀರಿ, ಸತೀಶ್ ಇದಾರಲ್ಲ, ಎಲ್ಲಿ ಬಿಡ್ತಾರ?
But the
Regarding sanction.
sanction by an incompetent, covered by my lord's decision.
ಯಾವುದು?
But
ಧರ್ಮಪ್ಪ.
B. Shivshankar.
ಹಾ, ಬಿ ಶಿವಶಂಕರ್, ಆಮೇಲೆ ಫಾಲೋ ಇಟ್ ಇನ್ ಧರ್ಮಪ್ಪ.
But in HR Krishnappa, my lord.
ವಾಟ್ ಎವರ್, ಸಮ್ಮಪ್ಪ.
But
ಯಾರು ಕ್ಯಾಬಿನೆಟ್ಗೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತಾ?
yes,
Please, Lord.
ಯಾರು ಮಾಡಿದ್ದಾರೆ?
but the
Commission.
ಕರೆಕ್ಟಾ?
Minister for Urban Development has passed an order. Has
ವಾಟ್
given,
ಕೇಡರ್ ಆರ್ ಇನ್?
came a selection grade.
ಅದಕ್ಕೆ ಮಿನಿಸ್ಟರ್ ಸ್ಯಾಂಕ್ಷನ್
But
ಕ್ಯಾಬಿನೆಟ್ಗೆ ಹೋಗ್ಬೇಕಾಗಿಲ್ಲ.
but above the rank of my lord KS senior scale
ಯು ಆರ್ ನಾಟ್ KS
or
KMS,
equivalent grade.
KMAS,
KMS.
ಅವ್ರ ಈಕ್ವಲೆಂಟ್ ಅಂತ ಎಲ್ಲಿದೆ?
But business transaction rules.
ಕೊಡಿ, ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಬಿಸಿನೆಸ್ ರೂಲ್ಸ್ ಕೊಡಿ.
Lordship,
Yes.
date may be fixed, your lordship, senior will make a submission. It's not
Let him
a
make.
by you.
It's an important thing. Yes. 21st ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್ ಆಗಲೇ? ಇದು 31st ಇರೋದೆಲ್ಲ 21st ಹಾಕ್ಬೇಕಾಗುತ್ತೆ. 31st ಇರೋದೆಲ್ಲ 21st ಹಾಕ್ಬೇಕು. ಮಾಡ್ಬೋಣ. ಹೌದು, 30 ತುಂಬಾ ಇದೆ 31st. ಹಾಕ್ಬೋಣ. 21st. Yes, list on 21st.
The interim order may be mixed.
Interim order stands extended till the disposal of the petition. Tahir. ಅಜ್ಜನ ಇದೆ. ಇವರಲ್ಲಿ petitioner in person ಇದ್ರಲ್ಲ.
Lordship, I pray for.
ವೀರೇಂದ್ರ ಅವರು ಇವತ್ತಾಗಲ್ಲ, 4:45 ಆಗೋದು.
My lord, 51 ಅಲ್ಲಿ ಬರೀ ಪಾರ್ಷಿಯಲ್ ಸ್ಟೇ ಇದೆ my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
51.
ಪಾರ್ಷಿಯಲ್ ಸ್ಟೇ ಏನು?
Only the special case has been stayed. There are other offences which have been.
No, atrocities. This is my order.
Yes, sir.
Atrocities. ಬೇರೆ ಎಲ್ಲ ಇರ್ಲಿ, ಆಮೇಲೆ ಮಾಡೋಣ.
But can I get a shorter date for that?
We'll see.
For 51.
Shorter date ಆಗಲ್ಲ. 21. Next date.
The
ಶನಿವಾರ.
Next hearing is on 28th.
21st is before 28th.
My lord.
Yes. 28th. The 21st. Yes. List on 21st. Both. ಎರಡಿದ್ಯಾ? ಎರಡು.
Again 51. 51 has a.
And on that day, I'm not granting adjournment. Be ready in the matter. Yes.
21st, my lord.
21st September.
Voting settlement, 52.
ರಾಜಶೇಖರ್. ಆಗಿದ್ಯಾ? ಕೊಡಿ. ಅಡ್ವೊಕೇಟ್ ಇದಾರಾ?
ಇಲ್ಲ ಇದಾರೆ, ಬಟ್ ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ ಸಿಗ್ನೇಚರ್.
ಮಹೇಶ್ ಸಿಗಲ್ಲ. ಎಸ್.
ನಿನ್ನೆ ಅವ್ರದ್ದು ಸಿಗ್ನೇಚರ್.
ಅವನು ಮಂಡೇ ಸಿಗುವುದು ನಿಮ್ಗೆ. ಎಸ್.
ಪಾರ್ಟೀಸ್ ಅಫಿಡವಿಟ್ ಎಲ್ಲ ಇದೆ.
ಪಾರ್ಟೀಸ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಪಾರ್ಟೀಸ್ ಬಂದಿದೆ. ನಿನ್ನೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವ್ರು ಮತ್ತೆ. That also I have produced.
Quashing the proceedings. We'll close it. 498. A joint affidavit court property, joint affidavit. But copy 10 days bit.
Aye.
No hurry for the copy, no hurry. No. ಇದರಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ.
ಪಾರ್ಟೀಸ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದೆಲ್ಲಿದೆ?
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಿನ್ನೆ ಆಗಿದೆ.
ಕಾಪಿ ಇಲ್ವಾ ಇನ್ನು?
ಪೇಜ್ 28.
20?
22.
ಏನ್ ಸೆಪರೇಷನ್?
Separation.
Naale then they should not create any problem. I have not agreed. Better, because reunion adre we will just close it, but not separation. Next week ಹಾಕ್ತೀನಿ, let them come.
Date may be.
List on 13th at 2:30 PM. Notice, you will get the wife.
My lords.
Yes, a notice to the respondent. The petitioner is, ಇದಾರಲ್ಲ already. Sorry, list on 13th to report settlement.
I'll take back that joint.
ಅದ್ ತಗೊಂಡಿರಿ.
So that
Yes.
try to get the signature of.
Give it to Mahesh.
Yes, please.
You tell him, come
Yes.
to the court, despite being a Friday.
Please. 13th, could it be on 12th?
ನಿಮಗೂ weekend problem ಇಲ್ಲ.
ನನಗೆ problem ಇಲ್ಲ. I'm going out of family.
ಆಯ್ತು, 12th.
Please, please. Interim order.
Interim order subsisting will continue till the disposal of the petition.
Great.
Sitaram,
Lord, this is a petition filed, my lords, keeping in the view of to settle the matter, my lords. My lords.
you are Sitaram?
Sitaram is speaking.
Hmm.
Foxco.
Foxco.
16 years.
Also, my lords.
Age of the victim?
17, my lords.
17. 9th, list on 9th.
Please, my lords.
We'll see, yes.
Great.
Siddharamaiah,
Second respondent petitioners are they.
ಅಲ್ಲಿ ಏನು offense ಏನು?
Release of vehicle ಮೇಲೆ.
Release of vehicle ಕೊಡಿ.
ಅಲ್ಲೋ ಅದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತೀವಿ, ಫಾರ್ಮಲ್ ನೋಟಿಸ್ ಮೇ ಬಿ ಆಲ್ರೆಡಿ.
Emergent-
Second respondent has died.
Emergent notice to the respondent. ಯಾರಿಗೆ ಫಾರ್ಮಲ್ ನೋಟಿಸ್ ಮತ್ತೆ?
Respondent number 2 ಸತ್ತೋಜವ್ರೆ,
ಹಾ.
ಅವ್ರ ಎಲ್ಲಾರ್ಸ್ ಮೇ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ಆನ್ ರೆಕಾರ್ಡ್. ಸೊ
Already they have come on record? ಹಾ, ಇದಾರೆ.
ಈಗ ನಾವು
Emergent notice to respondents 2A, 2B. Returnable by 19ಕ್ಕೆ ಹಾಕ್ಲಾ? List on 19th in the fresh matters list. We'll dispose it on that day.
Yes, please.
ಏನ್ vehicle?
That contract carriage bus.
All right, yes.
Second one is child marriage, my lord, 17 years, 3 months.
ಅದೇ ಅದು 9-9.
She is
Yes,
pregnant,
list on
my lord.
9-9.
Till then.
ನೋಡೋಣ, Supreme Court judgment in this.
Stay may kindly be granted. That is carrying and pregnant.
Custody ಇದಾರಾ?
ಇಲ್ಲ.
List on 9-9, there shall be an interim order of stay of further proceedings. Where the petitioner till the next date of hearing.
My lord, office objection, no. All objections, my lord, 2 objections. Prior further proceedings ಅಂತ ಕೇಳಿದೀವಿ, ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅದು ಕಂಪ್ಲೈ ಮಾಡಿ ಅಲ್ಲಿವರೆಗೆ 9-9.
R2 ಹೆಸರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇಸ್ ಅಫಿಷಿಯಲ್ ಅಲ್ಲ, ಏಜ್ ಹಾಕಿಲ್ಲ ಅಂತ ಇಸ್ ಅಫಿಷಿಯಲ್.
Office accepting the submission, office objection stands overruled. On Jagdish, on 9th, each case we will take up and decide which is to be taken, which is not to be taken. I'll also get
Separate list.
separate list, madam, separate list. We'll have it separately. Second list ಮಾಡ್ತೀನಿ. Was there about 20 cases ಅದಕ್ಕೆ? Yes, sir. 56. ಆಯ್ತಾ? ಲಿಸ್ಟ್ ಮುಗಿತಾ? ಮೂಡ ಇವತ್ತು ಕೊಡಿ. 2, 3, 4.
Number 1 withdrawn.
ಅಲ್ಲ 4, 5 ಎಲ್ಲ ಇದರಲ್ಲಿ ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಇದ್ರೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಅಂತಂದ್ರೆ ಕೌನ್ಸಿಲ್ ಟು ದಿ ಪೆಟಿಷನರ್ ಮೂಡ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ವಿಡ್ರಾಯಿಂಗ್ ದಿ ಪೆಟಿಷನ್ ರಿಸರ್ವಿಂಗ್ ಲಿಬರ್ಟಿ ಟು call in question the charge sheet that is filed during the pendency of the petition. Reserving such liberty, petition stands disposed as withdrawn.
24-20.
5.
ಅದನ್ನೇ ಬರೆದಿದ್ದೆ ಈಗ.
In the meantime, my lord, office may direct to return the certified copies.
The registry is directed to return the certified copies appended to the petition forthwith.
Faithful, my lord.
Yes.
5.
Srinivas Rao. One ನಿಮಿಷ. Wait.
Lords appearing for
Extension of time. Why, madam? What matter is this?
Lord, we're seeking leave to deposit 30% of the remaining check amount. We had, the sentence was
How much time I had granted earlier?
2 weeks' time from the date.
Where is it? Order?
On 19/7/2024, madam.
19/7?
2024, we were directed to deposit 30% of the check amount.
One moment. Oh, that is by the coordinate bench, madam.
Please. The remaining
Within 2 weeks.
2,
ಇದು conviction ಅಲ್ವಾ?
please.
Conviction. Heard the learned counsel. The name is Prakriti, right? Heard the learned counsel Prakriti appearing for the petitioner. This court, the coordinate bench of this court on 19/7/2024 had on IA1 of answering IA1 of 2024 had passed the following order. The learned counsel appearing for the petitioner submits that has IA ಹಾಕಿದ್ದೀರಾ? Has filed an application seeking extension of time for the said deposit. In the light of the judgment of the apex court in the case of Jambu Bhandari versus so and so, reported in 2023, 10 SEC page 446, I deem it appropriate to grant the petitioner 446, in which the apex court has held that a condition, that is the suspension of sentence being made a condition precedent for deposit of 20% of the amount, would be contrary to law unless reasons are recorded for writing. Since the order is already passed in the case at hand, I deem it appropriate to extend the same. ಎಷ್ಟು ದಿನ ಬೇಕು?
Make it tomorrow.
Tomorrow?
50.
No, to
Have the DD
pay the
ready.
remaining amount, how much time you need?
Have the DD ready.
I deem it appropriate to grant 2 more weeks' time to the petitioner to comply with the order dated 19/7/2024. Ordered accordingly, I disposed, yes.
Okay.
Special court met, sir. List on 19th, yes. Shana? ಅವ್ರದ್ದು ಮಿಸ್ ಮಣೀಂದರ್ ಸಿಂಗ್. ಮಣೀಂದರ್ ಸಿಂಗ್ ಫೋರ್ಗೆ R4ಗೆ ಎಲ್ಲರೂ 3 ಜನ.
Serial number 40. ಮಧ್ಯಾಹ್ನ ಫಾರ್ಟೆಡ್ ಆಗಿತ್ತು ಮೇಡಮ್, ಮಧ್ಯಾಹ್ನ ಫಾರ್ಟೆಡ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 40.
ಫಾರ್ಟೆಡ್
ಫಾರ್ಟೆಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು ಮೇಡಮ್. ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಮತ್ತೆ
31ಕ್ಕೆ ಆಗಲ್ಲ. 31ಕ್ಕೆ ಮತ್ತೆ ವೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಆಮೇಲೆ 31ಕ್ಕೆ ಆಗಲ್ಲ. ಇನ್ನೊಂದಿನ ಯಾವ್ದಾರು ಕೊಡಿ ಮೇಡಮ್.
ಇದೆ ಸ್ವಾಮಿ,
ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. 14 14th. You are the husband.
ಫಾಲ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ನಮಗೆ.
You are the husband.
Yes, my lord. Respondent 2. Petitioner 2, so.
Yeah.
Petitioner 2.
12th ಬನ್ನಿ. Yes.
Lord, seal number 29, Lord said passed over, Lord, if possible for dictation. Lord, kindly
Yeah.
fix a date. Seal number
What is that?
29, the first list. Section 500, Lord.
Defamation.
Defamation. Lord, may fix a date for dictating orders.
Post it another day.
Very well.
Yes.
Madam.